Time is now 12:07 p.m. and the Committee on Criminal Jurisprudence will come to order. The clerk will call the roll.
Chair Moody.
Present.
Vice Chair Cook.
Here.
Representative Bojani.
Present.
Representative Bowers. Representative Darby. Representative Harrison.
Here.
Representative Leach. Representative Christina Morales.
Here.
Representative Schatzline.
A quorum is present. As a reminder, anyone present wishing to testify before the committee, I need you to please register at the kiosks located in the hallways behind the hearing rooms. If you require assistance with that process, please let any member of the committee staff know and we will do our best to help you. Do want to mention that we have a number of bills slated to hear today, I think 23 in total, probably our most ambitious schedule so far. But look, we're in the meat of session, so that's how it's going to be. We're going to be judicious with our time, ask questions only when we need to dig into something here for the committee process. But we're also, as pursuant to our posting, going to limit public testimony to 3 minutes. There's a nice little timer up here that'll guide you down the road of conversation, right? Green, yellow, and red. That's exclusive of questions. If members have questions, then that doesn't apply to it. But your prepared remarks, your remarks that you want to make, we're going to limit to 3 minutes because we want to be respectful of everybody. People have traveled from all over the state to be here today for various numbers of bills. We want to be respectful and give everybody the same time, energy, and attention. So we're going to do it that way. For planning purposes, we're going to take things a little bit out of our regular order. I intend to hear House Bill 6 by Mr. Goldman first. I had initially intended to hear House Bill 17 second, but because we had a substitute produced a little bit late in the process, we're going to go ahead and move that back in the schedule. So for those other members and offices that are listening, we usually go by seniority order, going a little bit out of order. Mr. Goldman first, then we're going to start going back through seniority order to the best of our ability. And then after there's some time for folks to have worked through that committee sub on House Bill 17, then we'll bring that one before the committee. So just for planning purposes, since I think those two bills are the bills that have attracted the most number of witnesses, let the record reflect that Representative Schatzline is now present. Okay. And with that being said, and then we plan to vote out a number of bills at the end of the hearing once we've heard everything, if y'all want to hang around for that. Okay. He doesn't have to see what I said. No? Okay. This time, Chair lays out House Bill 6 and recognizes Mr. Goldman to explain the measure.
Thank you, Mr. Chairman. Thank you, members of the committee, and thank you especially, Mr. Chairman, for hearing House Bill 6 first today. Thank those members with more seniority than me who deferred today so that we could lay out House Bill 6 first. I believe it's one of the most important bills we will pass this session. House Bill 6 increases the penalty for manufacturing or delivery of less than 1 gram of fentanyl from a state jail felony to a third-degree felony. Furthermore, when an individual dies from a fentanyl overdose, the penalty will be enhanced to a second-degree felony. This is designed to address the one pill scenario. One pill does kill, where due to the lethality of fentanyl compared to other illicit drugs, it only takes one pill to kill. The bill includes possession of fentanyl with intent to deliver in the organized criminal activity statute. The bill clarifies penalty levels for drug offenses to ensure more efficient prosecution of these crimes. Lastly, the bill adds that if a toxicology examination reveals a detectable amount of fentanyl, the death certificate shall include in the cause of death the presence of such substance as fentanyl poisoning. Mr. Chairman and members of the committee, I, of course, could go in much further detail. This is probably one of the longest layouts I've had of any bill this session and will this session. Like I said, I could go into much more detail. We all know horrific stories of members of our families or our family friends who have died by taking fentanyl, not knowing it was fentanyl, other drugs, even commercial drugs laced with fentanyl. It's a horrific problem, not only in this state, but in this nation. And this bill, in my opinion, does the very best we can possibly do at doing what we can to stop the distribution of fentanyl in this state. And with that, I'll be happy to answer any questions.
Thank you, Mr. Goldman. Let the record reflect that Ms. Bowers is now present. Members, do you have any questions for Mr. Goldman?
And I'll reserve my right to close. Thank you so much.
And we're going to go ahead and proceed to public testimony. Chair calls Jenna Ellinger. Did I get that? Ellinger. It was the two choices I had, and I went the wrong direction.
No worries.
Apologize. Thank you so much for being here.
Thank you so much for having me.
I have you as Jenna Ellinger, representing yourself in support of the bill. Is that correct?
That is correct.
Okay, go ahead and proceed.
My name is Jenna Ellinger. I'm in favor of House Bill 6. I'm here to raise critical issues that require minor changes House Bill 6 does not currently address. To highlight the need for amendments to address these issues, I will take you through my experience as the mother of a child who was poisoned by fentanyl. As with many things, until you've lived it, it's difficult to fully understand the reality of what's happening. My son, Jake, grew up in Austin, Texas. He was a gifted athlete who also excelled in academics. With his score of 35 out of 36 on the ACT exam, combined with his stellar high school grades and athleticism, Jake was recruited to play linebacker by a number of top-tier universities, including Stanford, Brown, Penn, and Dartmouth. Jake passed on these incredible offers so that he could play football at his dream school, the University of Texas. His dad and I went to UT, and his brother Sam was then UT's quarterback. Jake wanted to play football with his brother on the team he had been an avid fan of his entire life. Jake was admitted into the Macomb School of Business as a finance major, became a member of the Texas Silver Spurs, was a UT football player alongside his brother, and was a straight-A student. In the spring of 2021, as a sophomore, he was looking forward to his upcoming internship at Dell and his little sister arriving on campus. On May 6, 2021, I received the unimaginable call that Jake was no longer with us. At the age of 20, Jake had been poisoned with a counterfeit Xanax that contained fentanyl. To our family's further devastation, when the death certificate was issued, the DEA and the City of Austin Police informed us that they were dropping their investigations because the manner of death on the death certificate had been classified as an accident. Even though Jake had been poisoned with fentanyl, the impact of classifying the manner of death as accident meant that the persons who manufactured or sold the counterfeit Xanax containing fentanyl that resulted in Jake's death will never be prosecuted. Those killing our children know this and continue to kill with little or no worry of investigation or prosecution. Jake's death was not an accident. He was killed. He was literally poisoned to death. My hope and prayer is that no other family has to live with the knowledge that their child's death will not be investigated and their child's killer will never be prosecuted. This could be your child. Thank you for listening, and thank you, Chairman Goldman, for carrying this bill.
Thank you, Ms. Ellinger. I appreciate you taking the time to be here and sharing what has to be a very painful story to share. It's good for us to know. Members, did you have any comments or questions for Ms. Ellinger? No? Thank you. Chair calls Karen Burbach. I have you registered as Karen, did I pronounce it right, Burbach?
Yes.
Karen Burbach, representing yourself and in support of House Bill 6, is that correct?
Right, and in support of the Ellinger family.
Understood. Well, in terms of testifying, you testify on behalf of yourself and on other, but you're testifying on behalf of yourself today.
Right.
I understand you're here to support her.
Right.
But for the record part, you were here to testify on behalf of yourself. Okay. Go ahead and proceed. Thank you so much.
Okay. I'm here to speak on amending House Bill 6 just slightly. It makes great strides. We applaud it. We are so grateful to Chairman Goldman for carrying this bill. But the changes we need, as Jenna just highlighted, are so that investigations into fentanyl death will not be prematurely closed, so that prosecutions are not prevented, impeded, or derailed, so that the poisoning of our kids will not continue killing one pill at a time with no thought of any repercussions to those who are distributing these drugs. and so that other families will not have to live as the Ellingers do with the fact that no one will be prosecuted for their child's death. The bill now contains the crime of murder, which is a significant and substantial step forward. And what we would like now to do is to give that bill teeth to prosecute the murder. What happened in Jake's case, which is what happens in most cases of this one pill, is that the death certificate comes out and it's either, there's cause of death and there's manner of death. Cause of death is such as in this bill, it's going to be, for example, fentanyl poisoning. Manner of death is a specific category. It's suicide, natural, homicide. There are specific categories, and you're limited to these categories. In Jake's case, and in many of these cases, it's listed as accident because people think accidental overdose. This wasn't an overdose. This was the same as if I put poison in your water and you drank it and you died from it. He was poisoned. He didn't overdose on what he thought he was taking. So to classify it as an accident, we were told directly by the DEA and the Austin police at the time that once that came out as accident, they were both closing their investigations because prosecuting an accident, as you can imagine, is very difficult. So these investigations are prematurely closed, and thus there's never any prosecution for these people selling these pills to our kids, one pill at a time. They don't even have to worry about it because the investigations will be closed. So that is the key, and there are very slight changes. I have provided the language already. It slightly changes it to say that manner of death is homicide if it's fentanyl poisoning. And there is an exception for the MEs because they, of course, have to be able to do what they need to do and categorize it exactly as they need to. It says, except as otherwise established by the medical examiner, a fentanyl poisoning death will be listed as homicide. So we have that exception for the MEs to be able to do if there's something else they find that they feel is more proper, they can do that. But this way we don't have accident investigations closing and no prosecutions. The other changes, we now have murder in the statute, in the bill, which is great. The lesser included of criminally negligent homicide and manslaughter, we would like to ask that the language we put tracks the language of the murder section exactly, except it's limited to criminally negligent homicide and manslaughter. And this is because for murder, you must have either intentional or knowing. If we cannot prove intentional or knowing, we can't go for murder. You do not have to have intentional or knowing for criminally negligent homicide or for manslaughter. So we would like to also add those two lesser offenses to the bill, along with murder, which is already in the bill. Thank you, Chairman Moody. Thank you all for your time. Thank you, Chairman Goldman. We appreciate it. Thank you for
Mr. Buck.
listening.
I appreciate you zeroing in on what you'd like to see, and certainly appreciate you sharing with us and taking the time to be here. Members, do we have any questions? No. Thank you. And you've given all that stuff to Mr. Goldman already?
Yes.
Okay, perfect. Thank you very much.
Thank you.
Let's hear from a medical examiner. Chair calls Keith Pinkard. I show you as registered as Keith Pinkard testifying on behalf of yourself
Yes.
and neutral on House Bill 6,
Yes.
correct? Okay, go ahead and proceed.
Good afternoon, Chairman Moody, Vice Chairman Cook, and committee members. Thank you for the opportunity to speak to you about HB 6 and the possible changes to the bill as filed. My name is Dr. Keith Pinkard, and I'm the Chief Medical Examiner for Travis County, and I'm here to testify on HB 6. I have no concerns or discussion, in fact, on the bill as filed. I do have concerns about some substituted language that went into the companion bill in the Senate, SB 645. As a medical professional, a physician, I have concerns with the changes that were made in the Senate on the companion bill that would require the use of the term poisoning on the death certificate for a fentanyl-related death. We understand that the objective of requiring the term poisoning is, in fact, to imply that a criminal act has occurred and to thereby facilitate the prosecution of manufacturers and distributors of illicit substances. However, we believe this to be an inappropriate use of the death certificate, which has an entirely different purpose. A cause of death statement should be limited to just that, a medically appropriate cause of death without implications of intent or criminality. That isn't what the death certificate was designed for. Death certification is a medical opinion that should not be forced upon the certifier. Physicians must have the freedom to make and certify medical diagnoses to the best of their medical knowledge and using their medical expertise. The term poisoning is a broad and nonspecific term that focuses on an implied act rather than a physical.
I do want to do this because is the language that you're concerned about housed in House Bill 6 that's before us today?
The language I'm concerned about is in the proposed committee substitute of Senate Bill 6.
Okay, we don't have the Senate bill here and we don't have a committee substitute for the bill. So I have you neutral on this particular bill. What I'm hearing you say is that that is a concern you would have if it were to be added to this bill. I want to make sure that, just for our record, what's in front of us is what we allow to be testified upon. And so, but you do have expertise, and I don't want to dismiss the expertise. I think that conversation is going to happen in the Senate, and if and when that comes to this bill, I think that's what's important for you to let this committee know. Is so the bill, as is, your opinion, would not be aided by requiring something like that on the death certificate. Is that that's what you'd like the committee to know?
Yes, sir. What I wanted the committee to know was that the companion bill had language that, as we understand, companions all the time end up becoming reconciled. We did not have the opportunity to address the companion bill in the Senate, so we simply wanted to get that on the record. I
appreciate that. That's important. We're obviously have a long way to go in this conversation, but it is this. So what I think the committee has heard that is a concern you would have, and you as your position and as medical examiner. That language isn't in this bill now, but we certainly have want to take your expertise into account as well. So we do appreciate you letting us know about that, and we'll watch what they do in the Senate like we always do, but we're very independent over here, and so we will continue to monitor those changes. But I appreciate you taking the time to let us know about your concerns about potential language that could find its way into the conversation.
Thank you very much. I appreciate
Do you have any other
the committee's time.
Do you? Yes, Mr. Cook.
So, do you agree that this is a difficult situation as far as what Ms. Ellinger has testified to today?
Absolutely.
Do you have any recommendations as the chief medical examiner how to prevent this exact scenario from happening in the future?
How to prevent fentanyl deaths?
No, specifically. What I'm zoning in on, she talked about the fact that you're putting accidental death on the birth certificate is an indicator to the prosecution and law enforcement that they need to take no further action. Do you agree with that?
I don't.
Okay, so what would you recommend? How would you recommend that we handle that differently?
So manner of death on a death certificate is designed for statistical purposes and epidemiologic data. It is not a legal determination of culpability or responsibility and should not be used to drive decisions regarding prosecution. So the important issue of what's on a death certificate is what appears in the cause of death statement. So for example, if the word fentanyl appears in the cause of death statement, which is our common practice, that means the death was caused by fentanyl. So if the circumstances surrounding that death, for example, illegal drug manufacture and distribution, are there is nothing that prevents a prosecutor or a law enforcement agency from prosecuting that case.
But how as a medical examiner, would you make a determination that the manner of death was accident if you don't know how it was, how it was received?
In general, that determination is made based on the circumstances of the case. So I'll use a similar comparison. So a hit and run car accident, okay? The event itself, the collision, was not intentional. Therefore, the blunt trauma sustained was accidental in nature. the fact that one of the parties involved fled the scene and is now responsible criminally for a criminal act, for example, negligent homicide or manslaughter, is an independent question. So that is not what manner is designed to do.
Okay. So in your example, like let's say if a mechanic, cut the brake line, and which is, in my opinion, would be synonymous with a drug dealer providing fentanyl on a pill. In that scenario, you would have a situation where someone's taking an intentional act and cutting a brake line, knowing that someone would not be able to stop their vehicle, which may result in death, right? And so how would you compare and contrast that situation with because I get what you're saying, but I'm not really hearing a solution from you. And I get that you're not, you're not advocating that the current system is perfect, but is there any suggestions that you have that would take care of this situation?
Again, I think the two activities are entirely independent.
So you think it's just an educational component?
If the death is due to fentanyl, and that's how we certify the death as being, that is the responsible agent is the fentanyl, then the law enforcement, whatever their investigation is, depending on what the alleged criminal acts of that person is, that fact alone, that fentanyl was the cause of death, is the evidence to substantiate any charges that might be brought.
So as far as manner of death, what are the choices that you have to make, as far as the medical examiner, what are the options that you have that you can put in there for the manner of death?
Sure. So in Texas, they are natural, accident, suicide, homicide, and undetermined.
Okay. And so how are you making the determination that it's accidental as opposed to homicide if you don't know the facts?
So in general, deaths due to the effects of drugs are listed as accidental because in general, people are taking drugs for the purpose of the effect the drug gives them. So, for example, if we had evidence that somebody took drugs with the intention of committing suicide, for example, and left a note, we might call that a suicide.
Sure. Thank you.
Members, any other questions? Thank you. I appreciate you lending your expertise. I know these are, these are difficult topics to talk about, obviously, when people lose a loved one, and we want to make sure that we're guiding our policy with a lot of things in consideration. So I appreciate you taking the time to raise that issue with us. Thank you.
Thank you very much for your time. I appreciate it.
Chair calls Stephen Postilnick. Sure. I have you listed as Stephen Postilnick. Are you testifying on behalf of the Medical Examiner's Office of Fort Bend?
Yes, I am.
Okay. I have you in that capacity and also as neutral on House Bill 6, correct?
As written, yes.
Okay, perfect. Then please proceed with your comments. And
I like to thank Dr. Pinkard for his prescient comments, and I'd like to thank Member Cook for his very on-point comments to Dr. Pinkard. I'd like to address those. When your question, my heart bleeds for all the families that are suffering from deaths from fentanyl. It's a scourge on this country. It's a scourge on this state, and it's a scourge on my county. The certification of the manner of death is such that if we have, I'll go back to the car accident. If we have someone doing a hit and run or someone doing drunk driver, they run over somebody, they die, we call that an accident. We have no information. This comes from the police as well as our investigators that say that this was a drunk driver, that dead person was not specifically targeted for injury by that person. So we call those accidents. That has never, and Mr. Rohde, who's sitting behind me, can confirm, that has never stopped the prosecution of any accidental death that we certify as an accident. If we hear that the car was creeping along and then suddenly veered onto the sidewalk and the dead person was the ex-girlfriend of the driver, that is intent to kill that person. We call those homicides. For people who take super high doses of drugs leave notes, all that sort of stuff. We call those suicides. So the manner of death comes in large part from the investigation. And if we have something to say it's a homicide, that it's targeted, no problem calling a drug death a homicide. In these fentanyl deaths, what we're seeing is that fentanyl is now being packaged with other drugs, bromazolam and xylazine. People are getting fentanyl. We can now buy Narcan, the reversal drug for fentanyl and other opioids, in CVS and Walgreens. People are getting Narcan and saving their lives in the fentanyl, but they're dying from the bromazolam and the xylazine. Xylazine is a veterinary anesthetic, highly toxic. So we almost never see fentanyl alone. We see fentanyl with 5 other drugs: methamphetamine, cocaine, alcohol, maybe a little heroin, that sort of stuff. So we call it like we see it. If we see 5 drugs, all 5 contribute. If we see one drug contributes. And to Member Cook's questions, that's how we do manner of death. So, for instance, these cases, if we know that if we are brought credible information from the investigation that this drug, these pills were put out on the street for the purpose of causing death, we'll call it a homicide, okay? That's it. That comes from the investigation. That's the police. Whether an accident is prosecuted criminally, that's the district attorney's office, okay? And I've been doing this for 27 years. I've never had a single case that I called an accident, either a drug death or a car accident or anything like that, that was not prosecuted because of what we said on the death certificate. It doesn't happen. Whatever information that the DEA was giving to the families about why they didn't want to prosecute, that's up to them. They didn't just, it was probably a case that was too difficult for them to make against a specific defendant.
Okay. Thank you so much. I appreciate you taking the time to lend your expertise to us. I do want to have a question. You talked about, obviously, the uptick in these types of deaths. So in Fort Bend County, when did you start seeing the increase in fentanyl-related deaths?
Actually, there have been 2 sort of peaks. There was a minor peak, and now we're in the major peak. The minor peak was a decade plus ago when fentanyl was over the counter in patches. People were cutting them off, and they were sucking the gel out of them, and they were dying from them because that was easier to get and more controlled than getting heroin or morphine off the street. Mm-hmm. So that then decreased all those deaths. And then we saw a lot of hydrocodone combined with Xanax, combined with Soma, which is carisoprodol. And then the hydrocodone has been replaced. I see almost no hydrocodone deaths anymore. That's been replaced by fentanyl. Fentanyl is so ubiquitous, it's easy to manufacture, and the people that are distributing this think that they, distributing it to their hydrocodone patients, their opioid-addicted customers, and they think that they're giving an equivalent drug for pain relief or narcotics and stuff like that. They just have no clue that it's 1,000 times more potent than hydrocodone. So the upsurge in fentanyl deaths from this illegal manufacturer, transportation into around the world and into the United States, we've started seeing that in the last 5 to 7 years. And that has driven the opioid crisis that all medical examiner offices are suffering under in terms of case numbers. You see medical examiner offices around the country seeing increases of 50, 100, 200, 300 deaths over what they saw the previous average of 5 years. And that has driven the incredible shortage of medical examiners around the country. Every office, my office too, are trying to recruit medical examiners to handle all the opioid deaths, just those that we're seeing. It's incredible, and it's making it difficult. So that's, this is a recent phenomenon, and it kind of mirrors that hydrocodone and Xanax are going down and fentanyl is going up in its place. The problem is the other drugs that they're packaging with fentanyl as well. Bromazolam and xylazine. Those are real horrible drugs.
Okay. I appreciate you giving us that background. It's helpful. So your testimony is we're right in the middle of the height of this second surge that you described. I mean, this,
I don't even think we're at the peak.
you think, okay, so we're on.
I think it's going to get worse. Okay? And making medical exam, again, I don't know, I know you don't want to hear about any committee substitutes, but again, medical exams, we are the hardest working civil servants you're going to find because we've, you know, I go out and dig people up out of the graves at the middle of the night. We go out to scenes, we do all this stuff. We're at the roadside at car accidents. We're in, you know, pill houses for people that are overdosing all the time. Myself personally, not just my investigators. And we want to, we don't want anyone to think that we are inhibiting any prosecution of any drug death, illicit or prescription. We're still seeing a lot of prescription drug deaths as well.
Understood. No, thank you very much. I appreciate you taking the time to be here and appreciate the work that you do. Certainly very difficult. Members, do you have any questions? Thank you, sir. Chair calls Kate Graziani. Oh, yeah, sorry. Let the record reflect that Chairman Leach has joined us. Also want to let you know that we have an overflow room for anybody that is looking for a space to sit. That is an E1026. Kate Graziani.
Hi, good afternoon.
Hey,
Sorry, I'm a little out of breath.
No worries. Let me see. I have you registered as Kate Graziani, representing the Texas Harm Reduction Alliance and against House Bill 6. Is that correct?
That is correct. Thank you.
Go ahead
And thank you for taking the time to hear me today.
Sure.
So we're here in opposition to HB 6 because we know that punitive strategies to end the overdose crisis don't work. They're going to cause further harm and more deaths. And we implore you to consider public health strategies instead. HB 6 in particular, I'm not sure if y'all are aware of our 911 Good Samaritan law in Texas, but it is very limited. And so fear of law enforcement is the #1 reason why people don't call 911 during an overdose. And this bill is going to make people more afraid of calling for help when they're witnessing an overdose. So a young person is with friends, somebody overdoses, they think, well, am I the one who purchased these drugs for my friends and gave them out to this party? Will I be prosecuted as a murderer? I'm not going to call 911. And that means that folks will die. And I understand that as somebody who has lost loved ones to overdose myself, I understand the need for healing and justice, and we absolutely want that for families and loved ones as well. However, we believe the best way is to provide prevention and harm reduction so those overdoses do not occur. We believe the best way to provide healing and justice is for that death not to happen, and there are public health strategies and harm reduction strategies that can keep people alive: education, overdose reversal medication, and fentanyl testing strips. These are things that this legislature has the opportunity to authorize this session, and instead of going down this road, we seriously implore you to consider public health options. You've heard that this is not the end of the overdose crisis. It is only going to get worse. We will not meet again for 2 more years. So this is the moment for y'all to take a look at what would really prevent deaths in our state. And I hope that you are supportive of harm reduction and public health strategies and see the way that enhancing penalties will make people more afraid of asking for help, and it will cause further harm and death in our state. Thank you.
Okay, thank you very much. I appreciate your testimony. Members, do we have questions? Thank you. Chair calls Tammy Brown Rodriguez. Tammy Brown Rodriguez. Okay. We'll switch her to not testifying. Chair calls J.J. Ramirez. J.J., I have you as J.J. Ramirez testifying on behalf of the Texas Harm Reduction Alliance against House Bill 6. Is that correct?
Correct.
Okay, go ahead and proceed.
So cool. Thank you. Thank you, everybody, for hearing me. Condolences to everybody who's lost people in this overdose crisis. It is truly sad, and I don't want to mitigate anyone's pain. Justice and healing is what's needed. But prosecutors and legislators claim that higher penalties and drug-induced homicides drug-induced homicide laws will lead to deterring the selling and thus reduce drug use, and that's simply not the case. There is no systematic empirical evidence that shows that DIH prosecutions slow the sale of drug use. On the contrary, they may be counterproductive. Running at a cross to proposed 911 Good Samaritan laws, DIH prosecutions discourages witnesses to overdose from calling 911 for the fear that they'll be arrested and charged with DIH or other serious crimes. This bill is not the solution to the problem. The majority of prosecutions that are being brought against individuals across the country are either low-level dealers or friends and families or co-users of overdose deaths. Again, this is not the solution, right? Historically, the only way legislation has handled drug-related use is to criminalize the source, and it has never worked. This has been going on for 50-plus years. Criminalizing the supply side has never stopped overdoses from happening. So I urge you to lean into the fear of users and those who happen to be in this system and consider more holistic solutions to the demand side of these issues, rather than just pass a statute that will surely lead to more overdose deaths in Texas. Please do not pass HB 6.
Thank you, JJ. Member 2 have questions? No? Thank you so much. Chair calls Noel Johnson. Sir, how are you? I have you registered as Noel Johnson, representing the Williamson County Sheriff's Office and yourself, testifying in favor of House Bill 6. Is that correct?
That is correct.
Go ahead and proceed, sir.
I'll keep the time short at the behest of the committee. Just want to give you some statistical data that we're dealing with in Williamson County. Last year, we had 39 deaths that we could prove were fentanyl related, and those are growing by the day. We had 3 high school students that died as a result of ingesting fentanyl, and that is just for the unincorporated areas and the parts of the county that we are doing the investigations. That does not include the other major cities like Round Rock, Cedar Park, Georgetown, that are dealing with this epidemic. We think Chairman Goldman has brought forth a good bill that will help us to go after these high-level dealers and hold them more accountable for putting these drugs on the street. Thank you for your time.
I appreciate that. Now, thank you for giving us a law enforcement, one second, kind of perspective on this. We heard from the medical examiners about they're making a determination, right? This is their process, separate and apart from a criminal investigation and criminal liability for conduct. Do you encounter in your investigations where any decision they're made at the ME's office is somehow coloring your investigation or tipping you to a certain direction? Or I mean, do those things operate in silos as they're supposed to, or does it have an impact on the way that you all proceed?
So we were going to have our sergeant from our organized crime task force here today, and she could speak much better to these types of things. I get the complications the medical examiners are bringing up, which may open the door to the fact that when we do conduct investigations, we have to make sure that we're using the information provided, that we can go out and say, if this is a determining factor, we need to find out where the criminal element of it was. But I hope Sergeant Vargas will be at a future testimony to address that issue.
And obviously, we want to make sure the sergeant's able to continue to do the work that the sergeant needs to do. But if the sergeant is able to provide us with any commentary to the committee, we can distribute it. I want to send some written comments, that's perfectly fine too. It'd just be interesting to know, because of the layers of it, I could see, and I think probably at the back end of it is where you'd see people use it the most. If you have a trial, a defense attorney certainly would use that. I mean, I could see how they would try to use that in front of a jury to talk about, well, that was a determination the medical examiner made, and they could try to kind of marry the two concepts when in reality, the criminal liability and investigation is in a different silo than the determination that they're making at the medical examiner's office. I know that those two are going to get merged if you're in a jury trial. You're going to, I mean, I guess that's the line of questioning they'll get. I wonder, that's my thing, is I don't know how we legislate around it, but it is certainly an interesting topic as far as this is concerned. But I appreciate you taking the time to be here.
Chairman, I will get with that unit and follow up with the committee.
I appreciate that very much.
Thank you.
Chair, let the record reflect that Chairman Darby is present. Chair calls Paulette Soltani. Okay. Going to show her as not testifying. Katie Dyer. Katie, I have you registered as Katie Dyer, testifying on behalf of yourself against House Bill 6. Is that correct?
Yes.
Okay, please proceed.
So my name is Catherine Katie Dyer. I'm a criminal defense attorney who has represented hundreds of people facing harsh criminal penalties for drug use. I also teach law students how to compassionately work with people who use drugs, who get caught in the criminal legal system. Today, however, I'm here in my individual capacity as somebody directly impacted by the fentanyl epidemic to register my opposition to HB 6 and to talk about the personal harm that it can cause to loved ones who lose somebody to a fentanyl overdose. 3 years ago, my sister, Ashley, a mother to a 5-year-old little boy, was struggling to make sense of the threat and isolation caused by the COVID-19 pandemic. Ashley had engaged with opioid use throughout her adult life as she struggled with depression and other mental health conditions. But Ashley also repeatedly had long periods of success in recovery, and Ashley worked in a residential treatment program, helping young women find their own recovery, and spent countless hours telling people and reminding people that they mattered and were valued. On March 24th, 2020, Ashley called a friend and talked about some of the things that she had been struggling with. Her son was with other family that night, and Ashley decided to use drugs to cope. That night, Ashley snorted heroin that she had gotten from a friend. That heroin had fentanyl in it. And Ashley died from an accidental fentanyl overdose. It was the tragic end to a lifelong tug of war with substance use and the fight with depression that she had battled as long as I can remember. My mom went through something no mother should have to go through, finding my 36-year-old sister, calling 911 to have EMTs tell her what she already knew. Ashley was gone. What happened next led to months of anger, wonder, and disappointment. Police detectives pushed my mom to cooperate with the criminal investigation to track down Ashley's killer. To them, that was the person who had given her heroin that night. The police took Ashley's phone, a phone that had hundreds of pictures of Ashley and her son enjoying life, pictures my mom was desperate to hold on to. And the police made promises that if our family cooperated with the investigation and kept talking with them, there would be justice. We wanted answers. How could this happen right now? Ashley had been doing so well. Why didn't Ashley take precautions? Why did she die because she hadn't been using drugs and went back? Did she not know that this was going to be risky? None of those questions were answered through police investigation or the threat of prosecution. None of those questions could be answered through police investigation or the threat of prosecution. And in fact, no answers to any questions came from the detective's investigation. The only thing that resulted was months of wondering what happened, wanting to have the answers, and waiting on that investigation led to a huge disappointment for my mom and my family. There were no suspects, no charges, and no answers. The answers my mom desperately wanted were never coming. The detective's promise to vindicate Ashley's death was broken. And that's because it was not the friend who gave my sister heroin that killed her. It was the shame and stigma surrounding her drug use. It was the fact that Ashley felt like she had to hide her use of drugs and to do it alone without properly testing. That's what killed her. And what could have saved Ashley and so many others is to provide proactive harm reduction resources and support, to remove the stigma so that people like Ashley aren't hiding and using alone to risk overdose and death. Had Ashley used fentanyl testing strips or taken other precautions or had a safe space to not be alone, she might be here today. So we know that giving people clean syringes, testing materials, safe places, and real health care and mental health services is what keeps people alive. And we know that pushing drug use further underground and criminalizing things like HB6 will do is an inhumane public health catastrophe. As a lawyer, I'm horrified by the lack of intent required in what this bill purports to do. As a person who loves people who use drugs, I'm terrified for the way that this will exacerbate the shame and marginalization. Don't clog up the legal system and waste these resources on fruitless investigations and prosecutions that lead to false hope for loved ones. Thank you.
Thank you, Ms. Dyer. I appreciate you sharing your personal story. It's important for us to understand the differences in how people, when tragedy strikes, what that looks like for them. And it's part of the policy considerations we have to make. Members, do you have any questions? Vice Chair Cook.
First of all, sorry for your loss, and it sounds like a very tragic situation, not only for you, but your mother and entire family, so you have my condolences. I'm assuming that your mom probably was listening to you through this process, I mean, like getting advice from you, probably, is that correct? I mean, like while she was cooperating with law enforcement?
Yeah, I certainly supported her.
Yeah, and so, I mean, did you think at the time that she should cooperate and try to find a quote-unquote killer?
I told her that I thought it would be unlikely that that would yield results, and that unfortunately proved to be true.
But if it would have, I mean, would you still be here today opposing HB 6 if the police and or district attorney would have pursued a person for the cause of death?
Absolutely. Do I think the person that handed my sister heroin should be charged with murder? No. That's another person in this world that is not in trying to kill her by any means.
And do you think it matters whether or not your sister knew that she was taking fentanyl or not? She knew she was taking heroin, I believe you said, is that right?
Yes.
Okay. So you don't think it's important as to whether or not she knew that she was ingesting fentanyl? You don't think that's important?
I think I think that's absolutely important. And the way for her to know that would be able to test the drugs and to be able to have a safe way to take them.
So did someone deceive her? I mean, in what she was ingesting into her body? Did somebody?
I have no idea.
Well, sure. Yeah, you do. I mean, you said that your
I have
sister didn't
no
know,
idea
right?
who gave her the drugs and what they knew about them and what it was made
But
of.
I'm assuming you.
Which is why you can't prosecute this.
Assuming you know, assuming you knew who provided this, and assuming that your sister did not know she was taking fentanyl, do you believe that that person has any mental culpability for the death of your sister?
No, I do not.
Okay, thank you.
Chair calls Sarah Reyes. Hi, good afternoon. I have you registered as Sarah Reyes, testifying on behalf of the Texas Center for Justice and Equity against House Bill 6. Is that correct?
Correct, yes.
Go ahead and proceed.
I'm in opposition to this bill. I'm a policy analyst for the Texas Center for Justice and Equity. My fellow advocates, Kate and JJ, said a lot of what I'm going to say, but I think it's really important that it's heard as much as possible. The solution to the overdose crisis we are seeing in Texas and around the country is to be tough on crime and implement the harshest penalties we possibly can. And time again, we increase penalties and punish people. Yet Texas is ranked third in the number of fatal overdoses among all states. Incarceration has not worked in addressing overdoses because it does not address the underlying reason people use or sell drugs. It only perpetuates it. Likewise, criminalization increases the stigma associated with drug activity, and research indicates that negative and frequent experience of being stigmatized is a major factor in why individuals decline to seek and complete treatment. And often individuals who are selling or manufacturing substances are individuals that need help as well. Another consequence of this legislation we see, as mentioned, is a potential increase of the number of overdoses we see. There's evidence that harsher prosecution often deters people from calling 911 when witnessing an overdose. Lastly, racial disparities are already particularly pronounced in the application and enforcement of drug laws. Black and brown communities are often prey to police saturation or hotspot policing, and the more we continue to double down on punitive solutions that have proven to not work, the more these communities will suffer further incarceration instead of receiving help. For all these reasons, increased prosecution fails to fulfill the promise of reducing overdoses and instead have negative impacts. We all want to keep people from dying due to overdose, so we need to start pushing research-based public health responses that adapt a harm reduction approach to drug use as an effective alternative. Thank you for your time, and I am open to any questions.
Sarah, thank you. I appreciate you bringing that information for us. Members, do we have any questions?
Thank you.
No, thank you. Chair calls Ed Burback. Sir, have you registered as Ed Burback, testifying on behalf of yourself and in favor of House Bill 6? Is that correct?
Correct, Chairman.
Okay.
Yes.
Go ahead and proceed with your testimony.
Again, my name is Ed Burbach, and in 2003, I had the pleasure and honor of being appointed by then newly elected Attorney General Greg Abbott to be the state of Texas's Deputy Attorney General for Civil Litigation. And I served in that role for almost 4 years, from 2003 until 2007. I've been a lawyer in the state of Texas for over 35 years. I'm currently a partner with Foley & Lardner law firm here in Austin, Texas. We have over 1,100 lawyers, and am the office managing partner for Foley & Lardner's Austin, Texas office. My wife Karen previously testified. She previously served as general counsel to Governor Perry when he was governor of the state of Texas. I'm here to speak on my own behalf and obviously in behalf of testimony that was given previously by Ms. Ellinger. Specifically, I was interested by the testimony given earlier today by two medical examiners, Dr. Pritchard and Dr. Stillish. I thought their testimony was very well-meaning. And however, the speculation that was given with regard to whether law enforcement does not shut down investigations based upon MEs categorizing the death as an accident is simply not true. And how do I know that? I know that because that was not something told to the family. That was told to me directly by the City of Austin attorneys and also by the DEA in my capacity as a lawyer. Not as an emotional family member, but as a lawyer. And that's why they said they shut down the investigation. What was interesting in that is I think Dr. Pritchard testified that manner of death is actually used to collect statistics. That's the purpose of the use of manner of death. Dr. Silla testified that, and this is consistent with our understanding, that has become the norm for medical examiners to categorize fentanyl poisonings as accidents, as overdoses. I think you heard him testify to that. And that's been our experience also. So we're speaking in behalf of HB 6, and specifically you heard there is a carve-out that's been proposed within HB 6 that would allow the medical examiners, if they aren't comfortable with writing the words poisoning on that cause of death, they can still write accident with regard to amendment that's been proposed. So the concerns they've stated here today are taken care of. So we would just stress again that this is what's happening out there. If you're serious about prosecuting these individuals who are selling this poison to the children of Texas, then I think there is an alternative that gives another option to the MEs to write down something other than accident, because it is closing investigations and it's ensuring people aren't prosecuted. Appreciate your time.
Thank you, Mr. Burbach. Oh, 1 second. Do we have any questions, members? No? All right, thank you. Chair calls Lauren Johnson. Lauren Johnson. And I know we have an overflow room, so I don't want to cut people off, but I don't see Lauren. We'll go ahead and switch her to not testifying. I'm going to do my best here. Chair calls Andrew Anagnostis. I'm going to mess that up when I do it now. Andrew Anagnostis, representing the Office of the Dallas County Criminal District Attorney, John Crusoe, and for House Bill 6, correct?
Correct.
Okay, go ahead and proceed with your testimony.
Thank you, Chairman and committee members. My name is Andrew Anagnostis, and I have been a prosecutor for over 17 years. I'm honored to be representing Dallas County Criminal District Attorney Judge John Crusoe in support of House Bill 6. In the 87th legislative session, this body placed fentanyl in its own new penalty category, penalty group 1B, and also increased the punishments for knowingly manufacturing and delivering, and also possession with intent to deliver fentanyl. House Bill 6 is a bill that increases the penalty for the manufacture and delivery of fentanyl less than 1 gram from a state jail felony to a third-degree felony. This body is taking great steps in the fight against fentanyl last season, and we support the efforts to do even more this session. Additionally, House Bill 6 clarifies the appropriate level and degree of drug offenses with enhanced punishment ranges, whose penalties are found in the Health and Safety Code. Currently, if the level and degree of felony offense is not specifically designated in the code, the offense is categorized as a third-degree felony under Section 12.401 of the Texas Penal Code. By clearly defining that a person who violates these laws will face first-degree penalties, these offenses can be prosecuted with the severity they deserve and will no longer be categorized as third-degree felonies pursuant to Penal Code 12.401. This bill also enumerates that if the maximum punishment for an offense is 99 years or life, the offense will be specifically categorized as a first-degree felony, like all other first-degree felony offenses, which have a maximum punishment of 99 years or life. This bill also adds the first-degree felony penalty designation to current drug offenses, which do not have a designated offense level, but have a potential punishment maximum of 99 years or life. These changes are important to not only correctly charging the crime, but also ensuring that the records of judgment and sentence are clear and correct. For these reasons, I encourage you to approve House Bill 6. I will be happy to answer any questions that you may have.
Thank you very much. Members, do we have questions? Yes. Vice Chair Cook.
Just want to ask the question we talked about earlier a little bit. In your opinion, as part of your investigation, if a case is brought to the Dallas County DA's office, do you look at the death certificate?
Yes, we do, yes.
And do you look at the cause of death?
Yes, and the cause of death, the reason of death, manner, or cause are two.
Well, that's my next question. My first question is,
Okay.
is do you look at the cause of death?
Yes.
Okay, what does that tell you?
It just tells me whether it's going to be a homicide, an accident, or undetermined of that nature. Now, once the case actually gets through the police file it through intake to a prosecutor, I don't see why an accident, one that's even shown as an accident, can't still be prosecuted for criminal liability. That's not an issue, in my opinion, as far as pushing forward.
I'm sorry, didn't mean to interrupt. I know Dallas County DA's office is obviously a large office, and we all have different roles in different offices, so that's probably not your role, is what you're saying. I mean, you're not at the intake where you're the one determining whether or not to pursue the case necessarily.
No, sir, but those that we do have been falling under the delivery causing death statute. So it's a little bit different than looking at it in a murder perspective, but seeing that at that point, the cause of death would be the fentanyl toxicity, toxic degree of fentanyl in the system, and that's where we get our information determining whether or not we would be able to prosecute a person. Those are the facts behind that which caused the death, or what's really the important part, and not only what's listed on the death certificate. The death certificate, in my opinion, isn't the end of a case. It doesn't have to be the end of the case. case.
So you're saying, to your knowledge, that that would not be a dead end in the Dallas County District Attorney's Office?
Well, in my opinion, it does not have to be the end, depending on the certain specific case or circumstances. Not to my knowledge that there is a specific rule or guideline or anything of that nature that specifically says this is the end. No, sir.
Yeah, and I probably should have asked this question earlier, but as far as manner of death, do you know if undetermined is an option or not?
I believe it is, yes.
Because would you agree that, I think publicly in statements, I remember with the case that we've been talking about, the Ellinger family, the family did state that it was an accidental overdose. And from their son's perspective, it was obviously an accident. He didn't know that he was taking fentanyl. But from the person that provided that information, or the ones that provided the pill that knew that it had fentanyl, has a different, mens rea or mental culpability. Would you agree with that?
Correct.
Yeah.
Completely. That's why it's looking at a completely different perspective than what's on the death certificate to what crime occurred. It's a completely different perspective.
All right. Okay. Thank you.
All right, thank you very much. Is there anyone else present wishing to testify on, for, or against House Bill 6 at this time? Chair seeing none, recognize Mr. Goldman to close on the measure.
Thank you, Mr. Chairman and members. I do appreciate y'all listening to all the testimony. I do want to follow up, since the city of Dallas is just here. They've just embarked on a massive informational program for their citizens on the horrors of fentanyl. I want to thank the Dallas Morning News that just did a massive in-depth front page story on basically the traces of fentanyl, how it's getting here, and the trouble it's doing. It's the #1 killer of 18 to 45-year-olds. We have to do something. We can't sit around and watch this happen to our children anymore. This bill, I believe, is one of the ways to put strength back into the system to prevent these deaths from happening. Obviously, this is not the final bill as laid out today. We are still working on it. I encourage all those who want to have a say in it further to come by my office. We hope to have the committee substitute by you next week so y'all can vote it out. That's the whole goal. So please, if you have any additional information or input into this bill, I encourage anyone and everyone to come by our office. And I thank you very much. And if there's no further questions, I close.
Mr. Goldman, just a comment, and I appreciate you bringing it forward. Obviously, changes in our penal code structure are one way that we could look at, addressing issues. You heard a lot of testimony about harm reduction strategies as well. I think that's an important conversation to have alongside what you're doing. So I'd encourage you to meet with those folks. And then specifically, there was conversation around Good Samaritan policy. I know we've sent stuff to the governor before that's been vetoed in that arena, but maybe there's some room for that conversation here too, because it is, as we've heard, obviously this is not going away anytime soon, but employing multiple strategies to address this crisis is something that I think would be wise. And I appreciate you bringing the bill and being open to having those conversations with
Couldn't agree more, and absolutely appreciate that. We will do that.
All right. Members, any questions? No?
Thank you.
Thank you.
Close.
If there's no objection, HB 6 will be left pending. Chair hears none, and HB 6 is left pending. Okay. For planning purposes, I have Chairman Metcalf here, and because the number of witnesses on your bill, let's go ahead and move yours quickly. Chair lays out House Bill 1221 and recognizes Mr. Metcalf to explain the measure.
Thank you, Mr. Chairman, members. Good to be with you all. I think this is a probably much simpler bill than the one you previously heard. Currently, Texas Department of Criminal Justice receives court orders to withdraw funds from inmates' accounts and remit payment to a county for court costs, fines, fees, or restitution. The process can be expanded and utilized to create a system where an inmate's unclaimed property, which is held by the comptroller, passes from the comptroller through TDCJ to the counties to be paid to victims who are entitled to restitution from the inmate. House Bill 1221 establishes a process for TDCJ to file a claim for unclaimed property held by the comptroller on behalf of the victim if the owner of the unclaimed property is confined in TDCJ custody. TDCJ will verify if the amount of restitution owed by the county. It will forward payments received by the county for disbursement to the victim. This legislation gives victims an additional avenue for restitution through the unclaimed property claims process, which may result in an increased amount of restitution paid by inmates. TDCJ will be required to send a data set to the comptroller to match inmates to unclaimed property. Counties will also be required to provide an accurate accounting of an inmate's outstanding restitution balance and only requires TDCJ to file a claim on behalf of a victim if TDCJ has confirmed the amount of outstanding restitution with the county. Finally, counties will be required to accept restitution payments from TDCJ and forward the payments to victims or other persons eligible for restitution, including the compensation to victims of crime fund. Members, I hope you can all see that this legislation is about expanding justice for victims of a crime. By allowing victims to have access to these funds, we can make sure that they receive the compensation they are due from their assailants. This same legislation, as House Bill 978 from the 87th legislative session, passed out of this committee and the House floor unanimously, but unfortunately died in the Senate on the last local calendar day. I'd be happy to take any questions this time, and I do believe we have a resource witness from the Comptroller's Office.
Members, do you have questions? No? I'm sorry your bill died in the Senate. We're going to try and do better by you. I've been down that road myself a few times, but we'll try to do better by you. I don't show a resource witness here, but although Have is not testifying. Okay, does anybody need to hear from the Comptroller's Office? Or are you going to trust Mr. Metcalf's? Well, yeah, okay, you feel good about it. All right. Then is there anybody else wishing to testify on for or against House Bill 1221 at this time? The chair sees none. We recognize Mr. Metcalf to close on the measure.
Thank you very much for your time, Mr. Chairman, members, and I close.
All right, thank you. If there's no objection, House Bill 1221 will be left pending at this time. Chair hears none, and House Bill 1221 is left pending. Is Jewel? Chair lays out House Bill 1826 by Mr. Turner of Tarrant and recognizes Mr. Turner of Tarrant to explain the measure. Are you the only Turner now, right?
Yeah, I'm
still gonna say it, sir.
I'm the only Turner, so you no longer have to say the Tarrant
Nope,
part.
still gonna say it.
I'll still respond.
I like the alliteration.
Thank you, Mr.
Hold on.
Chairman.
Wait, we do have a substitute on this, right? Okay, this time Chair lays out a committee substitute, House Bill 1826, and recognizes Mr. Turner of Tarrant to explain the bill and the differences in the substitute.
Thank you, Chairman Moody, Vice Chair Cook, members. Appreciate you hearing this bill today. During the last interim, Speaker Phelan asked the House Committee on Business and Industry to study the effects of organized retail theft on Texas businesses as one of our interim charges. The committee found that this type of theft is a severe problem, increasing in intensity in Texas and across the country, as well as across the country, and that brick and mortar retailers, law enforcement officers, as well as online marketplaces are looking for help in combating it. And for anyone who's not familiar, because I wasn't super familiar with this before we studied it, organized retail theft is not shoplifting. Organized retail theft is the coordinated, concerted effort to steal thousands, sometimes tens of thousands of dollars worth of merchandise from stores and then resell it oftentimes in an online marketplace or other surreptitious ways. And it's an increasing problem in our state and country. According to the U.S. Department of Homeland Security, in 2019, organized retail theft cost retailers $70 billion nationally. This problem is only getting worse. According to the National Retail Federation, there was a 26.5% increase in organized retail theft from 2020 to 2021. So during our interim study, witnesses testified that when thieves conduct organized retail crime across jurisdictions, it can be more difficult to apprehend and charge them due to the lack of coordination between agencies. There was an agreement from retailers, from law enforcement, and online marketplaces that a task force created with the goal of coordinating a response to organized retail theft would be an effective tool against this crime. And that's what many other states have done and have found it to be successful. House Bill 1826 would direct the comptroller to appoint a statewide task force to study the impact of organized retail crime in Texas. Task force would examine the economic impact of retail theft in Texas, current laws addressing this crime, and potential actions that could further address this problem. The study would culminate with a report given to relevant public officials. By creating a task force to investigate the impact of organized retail theft, the task force could provide recommendations to address this type of crime in our state. Now, the committee substitute that you have before you would add language specifically allowing virtual meetings and a digital report. It would also add permissive language for the task force to work together and share information on active cases as warranted. Additionally, the committee sub would add recommendations on better coordination of all stakeholders, how to educate law enforcement and prosecutors on the most effective way to prosecute organized retail crime. Members, there was widespread consensus between all stakeholders that a task force would be a beneficial tool in the fight against organized retail theft in Texas, and witnesses testified to the success of these task forces in many other states, including Florida, California, Oklahoma, and Missouri. There are some witnesses here who can speak in more detail. I believe there's a witness from, or a resource from the comptroller's office as well, if the committee would like to hear. And I respectfully request the right to close.
Yes, sir. We will do that. Members, you have questions? No? All right.
Thank you.
Chair calls Alan Horn. Alan, I have you registered as Alan Horn, representing CVS Health and for House Bill 1826. Is that correct?
That's correct.
Okay, go ahead and proceed with your testimony.
Mr. Chairman, thank you for the opportunity to be here. Thank Representative Turner for bringing attention to organized retail crime. Just want to put some stats for what it is for CVS. So we have about 840 stores here in Texas. We have seen a 300% increase in organized retail crime in our stores since 2020. For us, across our 10,000 stores nationwide, it's over $230 million a year for us. We have an entire department that works, as many other retailers do. That's all they do is organized retail crime. And as Representative Turner said, this is not shoplifting. This is very, very sophisticated outfits that come into our stores, and we have an ORC event every 3 minutes in one of our stores nationwide. So we really appreciate the opportunity to be here in support of this, support Representative Turner and his efforts to bring attention to this, because it is a significant problem. And when you talk about the product loss, there's also a tax revenue loss to that. That product's out the door, we're not paying tax on that product to sell it. So really appreciate the committee's favorable attention for this bill. Happy to answer any questions.
Thank you very much, members. Do we have questions? Yes, Representative Bowers.
Thank you, Mr. Chairman, and thank you, Mr. Horn. I just wanted to take a note. How quick are those ORC events happening?
For us in our stores nationwide, 1 every 3 minutes.
1 every 3 minutes. And they're, of course, online, right, that this is happening?
They're actually coming into our stores.
Wow.
Yes.
Okay. So this is foot traffic.
This is people, these are organized individuals that, and I wish our department was here today. He had a medical procedure day, so he couldn't be here. And he's actually the president of the Organized Retail Crime Association of Texas. But he could tell you that we help law enforcement. We watch people go in our stores. We prepare the cases, take that to them. But these are actually people coming into the store, and there'll be 2 or 3, and somebody will distract somebody in our store, and while someone else is stealing a significant amount of product in the store, they'll take it back to a warehouse, and then they'll scrub it. They'll take off the tags, they'll take off the stickers, and then they will resell that. And so when somebody buys something online, you don't know for sure, in many instances, whether or not that is a product that has been resold or stolen.
And do you, because I thought that unfortunately, even in my district, I thought I had witnessed some of this and was, made aware, but I guess, is any of it the product being returned that's bought online? It's not in that way happening?
Not that we're seeing as being returned, it's just being resold. And the other problem, you mentioned seeing in our stores, is that several years ago, we really didn't see that many instances where people were bringing in weapons. Now that's completely different. We are seeing people come into the stores that are armed when they're committing the theft.
Thank you.
Thank you.
Yes, Mr. Bojani.
Thank you, Chairman Moody.
Also of Tarrant.
And thank you, Chairman Turner, for filing this bill, because, being in the gas station industry for the last 20 years myself, I've seen that firsthand, how this happens. And I used to also represent a chain of 6,000 gas stations around the country. And I think a lot of shrinkage happens in our stores because of organized theft like that. So, and I hope that y'all can include the gas station industry in this study to see how we can really fight this thing. Thank you so much.
Thank you. Members, do we have any other questions, comments? Thank you, Mr. Horn.
Thank you.
Chair calls John McCord. Have you registered as John McCord, representing the Texas Retailers Association, testifying for House Bill 1826? Is that correct?
Yes, sir.
All right, go ahead and proceed.
Thank you very much. Good afternoon, Chairman, members. Appreciate the opportunity to visit with you for just a few minutes about ORC and how these sophisticated crime rings impact each of your communities. As I mentioned, my name is John McCord, and for just over a year, I've had the privilege of serving as the Executive Director for the Texas Retailers Association. The retail industry here in Texas is the state's largest employer by industry, currently employing nearly 3 million Texans, and is responsible for more than $90 billion in direct income across the state. TRA's goal is not to simply keep Texas a business-friendly state, but to ensure that we have the best climate in the country to open, operate, and expand a business. HB 1826 by Chairman Turner is an important step to ensure that Texas retail industry remains strong for years to come. I was going to kind of walk through a little bit of what ORC is, but I think the chairman did a really good job of that. It's not someone just coming in and stealing something because they need it, right? It is an organized crime ring, and a lot of times what we're seeing is that while smash and grabs certainly do have a place in an organized retail crime ring, a lot of times you'll see a fence that will put out a shopping list, and you'll see a thief come into a store and meticulously shop for hours for the items that they need to be stolen, and then walk out the store with it. There was a story from the West Coast just yesterday where they had an incident and a security officer tried to stop the thief, and the security officer ended up having an ear bitten off as part of this crime ring. So it is not just the items that are being stolen, but it's also the safety of the customers and the store employees as well. Now, after these items are stolen, they're not typically resold immediately, as Alan mentioned. Instead, they're collected by an individual or small group who will fence the items. KHOU recently highlighted a story where one accused fenced in the Houston area. The individual portrayed in the story had over $1 million of stolen items from Home Depots across multiple states stored in his home. The man even had an elevator installed to get the heavier items from the first floor up to the second floor, and was just kind of living in his kitchen area. In fact, ORC is becoming more prevalent across the state, as the chairman mentioned, and it's a problem that we are seeing growing across the country, and is certainly getting worse here in the state. In fact, the Houston area ranks as the 6th worst place in the country for ORC, and one of our members reports that the DFW area for them personally is in the top 5. So it's certainly an issue that it's not just one or two companies that are my members. It's across the board that my members deal with on a daily basis. Really appreciate Chairman Turner bringing the bill forward, and y'all giving us the opportunity to visit with the challenges that we face on a daily basis, and we'll be happy to answer any questions.
Any questions or comments? Yes, Ms. Bowers.
Thank you, Mr. Chairman, and thank you, Mr. McCord. I hear y'all talking about the national impact, but I guess I just want to hear certainly how it affects Texas in a number and in terms of income.
Sure. So I can get you an exact stat for the impact that ORC overall has on the state. What I will tell you is that the National Retail Federation will rank the cities across the country who have the biggest issues with ORC. Right now, Houston ranks as the 6th city. And we have individual member companies that offer similar rankings. DFW and Houston typically pop up in those top 10 for our individual member companies, but I can certainly get some data for you on the overall impact on the economy from ORC here in Texas.
Thank you.
Absolutely.
Members, any other questions? No, thank you, Mr. McCord.
Thank you.
Chair calls Celinda Gonzalez. Have you registered as Celinda Gonzalez, representing the Home Depot, testifying in favor of House Bill 1826? Is that correct?
That's correct.
Go ahead and proceed with your testimony.
Thank you, Mr. Chairman and members of the committee. My name is Celinda Gonzalez. I currently serve as manager of the state and local government relations for the Home Depot here in Texas. The Home Depot is the world's largest home improvement retailer. In Texas, the Home Depot provides more than 4,100 jobs, has 181 stores, 24 distribution centers, with an annual impact to Texas over $17.6 billion. On behalf of our associates, we are grateful that the legislature took the time over the interim to study this highly concerning issue of organized retail crime. We'd like to thank Chairman Turner for his leadership on this issue. The impact of ORC in Texas is significant. The overall cost of retail theft to the Texas economy is $7 billion. It results in 36,650 fewer full-time jobs. The loss of state and local taxes is $343 million, and this is according to a 2021 study done by the Retail Industry Leaders Association. The Home Depot sees a critical need for HB 1826 to combat the rapid growth of ORC, especially as it poses a threat to the community. And as John mentioned earlier, to be clear, this is not petty crime. It's not petty shoplifting. It's theft for greed. These are sophisticated criminals that are stealing from small businesses and large businesses. These criminal rings routinely use the proceeds from selling their stolen goods to fund additional criminal activity like gun trafficking, drug trafficking, and human trafficking, and other crimes that pose a significant threat to our community. We strongly support proposals like HB 1826 that would allow better cooperation amongst the state, law enforcement, and our in-house investigators to get to the root of this problem. So we ask that you give this a favorable report. I'm here to answer any questions.
All right. Thank you, Celinda. Members, do you have questions? No. Thank you. Is there anyone else wishing to testify on, for, or against House Bill 1826 at this time? Chair seeing none, recognize Mr. Turner of Tarrant to close on the measure.
Thank you, Mr. Chairman and members. And Representative Bowers, I very much appreciate the question you raised about the Texas-specific impact. And I think that's one of the things we hope to get a better handle on through the creation of this task force in the Comptroller's office. Because right now, we don't fully, we know it's a huge problem nationwide, including in Texas. And while there's been some quantification done nationwide as to the impact, we don't have a true sense of in terms of the dollar value of merchandise lost or stolen every year to ORC, nor do we have the impact on general revenue in terms of sales tax dollars lost as a result. And so that's one of the things we hope to learn from the creation of this task force to help inform policymakers how best to grapple with this going forward. And again, members, I appreciate your favorable consideration. If there's any other questions, I'll be happy to try to address them. If not, I would close.
Members, do you have any questions? Ms. Bowers?
Not a real question, but thank you, Mr. Chairman, and thank you, Chairman Turner, for this important piece of legislation. And it was brought to my attention as well during the interim, and I think that the task force will be well worth it. So thank you.
Great. Thank you, Representative.
Any other questions? No?
All right, I close. Thank you.
This time Chair withdraws the committee substitute. If there is no objection, House Bill 1826 will be left pending. Chair hears none, and House Bill 1826 is left pending. I see my colleagues, just for everybody's planning purposes, Mr. Anchia, Ms. Johnson of Dallas, still have to make that distinction, have identical bills, similar witnesses. And so we're going to run those back to back. I do see Mr. Meyer here. I don't see anybody registered on his bill right now, so I'm going to take that quickly. Mr. Wu, I know you're being very patient. There are a number of witnesses that are registered on yours, so I'm going to try and be as efficient as possible since we have a lot of business. So let me Chair lays out House Bill 1769 and recognize Mr. Meyer to explain the measure.
Thank you, Mr. Chairman, committee. Members, currently the statute of limitations for the offense of trafficking a child with the intent that that trafficked child engage in forced labor or services is 10 years from the 18th birthday of the victim of the offense. Additionally, the statute of limitations for the offense of inducing a child to engage in sexual performance is 20 years from the 18th birthday of the victim, but only if they were younger than 17 years of age at the time of the offense. HB 1769 raises both of these offenses' statute of limitations to 20 years from the 18th birthday of the victim. In doing so, victims of these horrific crimes would have more time to come forward and speak out. It would also allow for more time for the guilty parties to be held accountable for their actions. Thank you, members. With that, I respectfully reserve my right to close and will happily take any questions you may have.
Members, do we have questions? Hang tight, let me just make sure. Is there anyone here wishing to testify on, for, or against House Bill 1769 at this time? The chair sees none to recognize Mr. Meyer to close on the measure.
Thank you, members. It's just a common sense increase in statute of limitations to allow children victims their right at justice. And with that, I close.
Thank you, Mr. Meyer.
Thank you.
There's no objection. House Bill 1769 will be left pending. The chair hears none. And House Bill 1769 is left pending at this time. Chair lays out House Bill 3548 and recognizes Mr. Anchia to explain the measure.
Chairman Moody, Vice Chair Cook, members of the committee, thank you for having me today. As many of you may know, about 5 months ago in my district I represent, District 103, 2 healthcare workers, Jacqueline Pukua, a social worker, and Katie Annette Flowers, a nurse, were shot while working at Methodist Dallas Medical Center. The violent offender who'd killed these innocent women had a criminal record dating back 10 years, multiple arrests, tried to cut off their ankle monitor. We have a suite of bills that have tried to deal with this. Today, we are dealing with a very important element, and that is letting our hospital workers know that the state has their back. You know, because of this heinous crime, and if I can contextualize Methodist for you all, as many of you may have hospitals in the district you represent, but Methodist plays a special role, and it represents kind of the heartbeat of North Oak Cliff, certainly where I live. It's about a stone's throw away from my home. And this is a place where babies are born, where parents pass with dignity, where the community is invested. There's a lot of uncompensated care for community, mammogram checks, blood drives, town halls, community meetings. I mean, it really does represent kind of that heartbeat of District 103. And we lost people there unnecessarily, candidly. Ms. Pukua's peers say she was known for her calming presence, her warm smile. She beamed even more when she talked about her son. And Ms. Flowers shared the same love for family of 4 children and 5 grandchildren that she helped other families experience that same joy in the maternity ward. And they were gone too soon. However, this just doesn't deal with the district I represent or Methodist Hospital. According to the American Hospital Association, the healthcare field has experienced a large increase in workplace violence, with almost 68% of registered nurses experiencing physical violence or verbal abuse. Yet there are no heightened penalties in Texas against assaulting workers in private hospitals. Currently, only healthcare workers in public hospitals are protected from assault. So this bill would ensure that healthcare workers in private hospitals, like Methodist Hospital, receive the same protections. The bill, just to give you a brief sense of the scope of the bill, it defines hospital personnel as nurses, physicians, physician assistants, maintenance or janitorial staff, receptionists, and other individuals who are employed to work by
or work in a hospital facility that is licensed as a general hospital or specialty hospital in the state of Texas. And so just to add a couple of more notes, this would be a penalty enhancement for assaulting a hospital worker at a private hospital. This would be a third-degree felony, punishable for up to 10 years in prison. And the two families whose loved ones were killed at Methodist Hospital gave me their blessing to name House Bill 3548 after Jackie and Katie Ann. So members, this brings our private hospital workers like those at Methodist Hospital and the hospitals that many of you represent on par with those in public hospitals. And I humbly beseech the committee for the opportunity, since no right exists, to close. Thank you.
Sir, we're gonna ponder your request.
Thank you. Thank you for taking it under consideration,
during the
Vice Chair and Chairman.
testimony. I won't poll the members at this time to see whether we're gonna let you do that, but we'll find out. No, thank you, and I appreciate, obviously there's a number of, we just have this bill in front of us now, but I know there's a number of things you're doing to work on in response to that tragedy, and certainly, I know a lot of us were sending our prayers as you all were grappling with that situation. Chair calls Stephen Love. Sir, I have you registered as Stephen Love, testifying on behalf of yourself and in favor of House Bill 3548. Is that correct?
That's correct, and I am also President, CEO of the Dallas-Fort Worth Hospital Council, representing the 90 hospitals in North Texas.
Yes, sir. Go ahead and begin.
Thank you, Chairman, and also thank all of the members of the committee for your public service. You know, when you think in terms of a private hospital, a community hospital, sometimes it's the best day of your life. It's when maybe a newborn is coming into your family, and it's a time of celebration. But sometimes, unfortunately, it could be the worst day of your life. You lose a loved one. Someone comes into the trauma unit, and maybe they've been injured or they've had a severe medical emergency. My point is, emotions run high. There is emotional stress and strain at hospitals, and was indicated, we really support this bill, making it a felony if you hurt, attack, as was defined, healthcare hospital personnel. You were given the statistic that the American Hospital Association had, where 68% of nurses during the pandemic were physically attacked. That didn't include all the nurses that were verbally abused. Yesterday, I was at my dermatologist for a routine visit, and I asked her, I said, "You're a dermatologist. You don't have to worry about workplace violence." And she said, "I get threatened frequently. Just last week, I was threatened because an individual felt the scar left from a procedure I had done was bigger than it needed to be, and I was physically threatened. Luckily, I was not attacked." This is a very serious issue. We need to think in terms of a hospital being a safe haven where people can celebrate births and at the same time have the peace and the comfort when they have to deal with tragedy or bad news. And the environment should be safe for the patient's family, and of course, the hospital staff. So we strongly support this bill, and we hope that you will as well. Thank you very much.
Thank you very much, sir. Members, do we have any questions at this time? No? Thank you, Mr. Love. Chair calls Dan Blizzard. Sir, I have you registered as Dan Blizzard, representing Methodist Health System and testifying in favor of House Bill 3548.
Yes, sir.
Is that correct?
Yes, sir.
Go ahead and proceed.
On behalf of the nearly 10,000 employees and physicians practicing at Methodist Health System hospitals in North Texas, we want to express our sincere appreciation to Chairman Moody, Vice Chairman Cook, the members of the Criminal Jurisprudence Committee for agreeing to consider this legislation. Like the overwhelming majority of healthcare facilities across Texas, Methodist Health System facilities are not impenetrable fortresses designed to prevent anyone intending to do harm from entering, but instead, places providing an environment for those who have been harmed or in need of care feel comfortable seeking the care they need. That caring environment was taken advantage of when a convicted felon on parole, wearing an ankle monitor and armed with a concealed handgun, was granted permission by his parole officer, to be present at Methodist Dallas Medical Center for the birth of his child. On October 22nd, 2022, the day after the birth of his child, after an argument with his girlfriend, the alleged suspect opened fire and killed two of my colleagues, 45-year-old social worker Jackie Pokua and 63-year-old registered nurse Katie Flowers, who had responded to the disturbance in the labor and delivery department of the hospital. A Methodist police officer, Sergeant Robert Rangel, engaged and disarmed the alleged suspect, thereby preventing his escape and causing further harm to other patients, employees, and physicians in the hospital. Jackie and Annette dedicated their careers to helping others. On that fateful day last October, they were innocent victims in the heartbreaking tragedy that leave behind grieving families, friends, and coworkers. We strongly urge you to advance this legislation to amend the Texas Penal Code to increase the penalty for assaulting a healthcare worker on the premises of a hospital from a Class A misdemeanor to a third-degree felony. Due to the ongoing criminal investigation related to this senseless tragedy, I'm not able to comment further on the events of that fateful day, nor any security measures in place at the time or steps that have been taken or are being considered at Methodist Health System facilities. Thank you.
Thank you very much. And obviously, we would want to extend all of our condolences for the loss. I mean, that's your family that you work with, and so.
Thank you, Chairman.
Very sorry for your loss. Members, do you have any questions? Thank you, sir. Chair calls Jennifer Cagle. Have you registered Jennifer Cagle? Is that pronounced correct?
It's Jennifer Catchell.
Catchell. All right. Jennifer Catchell.
Everybody gets it wrong.
Representing the Dallas County District Attorney's Office for House Bill 3548. Is that correct?
Yes, sir.
Go ahead and proceed.
Thank you very much. Thank you, Mr. Chairman and members. Again, my name is Jennifer Catchell. I have been a prosecutor in Dallas County for 16 years, and I am honored to be here on behalf of Dallas County District Attorney John Creuzot, testifying in support of House Bill 3548. As you've heard, there are only certain instances in which an assault is a felony offense when committed against specifically designated hospital staff. House Bill 3548 would add a provision to the Penal Code to protect all hospital personnel who are assaulted while doing their job. Currently, only when emergency services personnel are specifically providing emergency medical services when assaulted does the law deem this a felony. This means that if a hospital staff member is assaulted while providing discharge instructions to a patient, a postpartum nurse is assaulted while caring for a new mother and baby, a janitorial staff member is assaulted while keeping the hospital clean and safe, or a hospital social worker is assaulted while providing services and resources to a patient and their family, these offenses would not be a felony offense under current law. Also, as you've heard from previous speakers, there's also a distinction between those who work for a public hospital, such as Parkland or JPS in the DFW area, and private hospitals. If any public hospital employee is assaulted, it is a felony under assault public servant, while someone performing the same role at a private hospital would merely be a misdemeanor. Our healthcare professionals have had a very challenging and difficult last few years, serving our communities on the front lines during the COVID pandemic. Every person who works in a hospital is providing a service to our community and keeping a crucial institution running. Many of our healthcare workers feel abandoned and unprotected by our current laws. They come to work to help save and improve others' lives and are often met with hostile and abusive behavior. When that hostile and abusive behavior turns physical, the hospital employees look to law enforcement for help. As law enforcement, we are often limited by the laws as they are currently written. It shouldn't matter what type of care or service they're providing or who the employee works for, whether it's the government or a private hospital. Each and every person who works at a hospital is serving our community. These loopholes need to be closed. The law is clear and protects those who care for us in our times of medical need. Our healthcare workers have our backs every day, and by supporting House Bill 3548, we can have theirs. Thank you. Do you have any questions?
Thank you very much. Members, any questions for Jennifer? No? All right, thank you.
Thank you very much.
Appreciate your testimony. Chair calls Heather De La Garza.
Good afternoon, Mr. Chairman. Good afternoon,
Hold
Chairman.
on real quick, 1 second.
Sure.
Sorry, my system is not updating. There we go. I have you listed, registered as Heather De La Garza, testifying on behalf of the Texas Hospital Association in favor of House Bill 3548. Is that correct?
That is correct.
All right, go ahead and proceed.
So once again, good afternoon, Mr. Chairman and members. My name is Heather De La Garza, and I'm the Assistant General Counsel for the Texas Hospital Association. I'm proud to testify this afternoon on behalf of THA and its more than 650 members in support of HB 3548. Preventing violence against our hospital staff is a priority for Texas hospitals. HB 3548 is designed to prevent violence against hospital personnel while such personnel are working in the hospital by increasing the criminal penalty for an assault from a Class A misdemeanor to a third-degree felony. In late 2022, THA surveyed its member hospitals on a variety of workforce issues, including workplace violence, to better understand the workforce challenges impacting our member hospitals. Responses to the survey indicated that violence in hospitals has significantly increased or stayed the same since the start of the pandemic. 61% of the responding hospitals also reported that violence severity has also increased. As we are asking you this session to significantly fund an increase in capacity at our state's nursing schools, we also strongly support efforts to ensure a safe work environment for hospital staff. THA supports the bill's broad application to include any person, even other hospital personnel, who assault hospital staff. However, we want to be clear that THA does not support the criminalization of mental health and believe that this bill will not lead to any increase in charges being filed against individuals who react violently in a hospital and don't have the capacity to form criminal intent. I want to thank Representatives Anchia, Sherman, Jones, and Lalani for authoring this bill and for working with us to keep hospital personnel safe. Thank you for the opportunity to testify today, and I'm happy to answer any questions.
Heather, thank you very much. I certainly appreciate your testimony. Members, do you have any questions right now? No?
Thank you.
Thank you. Is there anyone else wishing to testify on for or against House Bill 3548 at this time? Chair sees none, recognizes Mr. Anchia to close on the measure.
Thank you, Mr. Chairman, for recognizing me and this opportunity to close. Thank you. Thank you for validating me. I needed that today. I feel seen. And members, I really do appreciate the opportunity to hear this bill and honor these families of our lost healthcare workers. But this is something that's happening in all our districts, and I would appreciate your favorable consideration. Thank you.
Thank you, Mr. Anchia. Yeah, there are a number of bills that touch on this topic. So certainly something that seems to be popping up all over the state. Members, if there is no objection, House Bill 3548 will be left pending. Is there any objection? Chair is none, and House Bill 3548 will be left pending at this time. And we try to move, just to have other members in the room, try to move by seniority best we can. Mr. Anchia and Ms. Johnson have identical bills, similar witnesses, so we're going to hear those back to back just for your planning purposes. But we just heard some of the testimony, so I think it'll be hopefully we'll move efficiently on the topic. Chair lays out at this time House Bill 2189 and recognizes Ms. Johnson of Dallas to explain the measure. Chair lays out committee substitute to House Bill 2189 and recognizes Ms. Johnson of Dallas to explain the bill and the substitute.
Thank you, Mr. Chairman, committee. This bill was brought to my office by Texas Health Resources Plano and the Texas Hospital Association over the summer. And then, unfortunately, the purpose of it was brought to full fruition in October when these two employees of Dallas Methodist were killed. To keep it short, because you've already just heard so much of the testimony, but the net effect is right now, emergency room personnel are subject to, if you assault an emergency room personnel, you get the third-degree felony, but no other hospital employee. This pretty much raises the same penalty to all hospital employees across, regardless of position. And our community substitute also includes social workers, since, one of the deceased victims was a social worker. So with that, I'll reserve my right to close.
All right. Thank you. Members, questions? No? All right, we'll move to public testimony. Chair calls Dan Blizzard. And Dan, just so I have it straight for the record, I have you registered as Dan Blizzard, here to represent the Methodist Health System in favor of House Bill 2189.
That is correct.
Right,
Rather than repeating myself earlier, I just want to state on behalf of Methodist Health System, we support this bill by Representative Johnson, and we wish a favorable consideration on your part.
Thank you very much, and I appreciate you being here to support both of these measures. Chair calls Stephen Love. Sir, for the record, I've got you registered as Stephen Love here testifying on behalf of yourself in favor of House Bill 2189. Is that correct?
That's correct. Plus, I'm representing the Dallas-Fort Worth Hospital Council.
Yes, sir.
And we certainly
you are currently the president and CEO of the Dallas-Fort Worth Hospital Council, correct?
Correct.
Okay.
Yeah, I just wanted to add a couple of things. As Dan said, I'm not going to repeat myself, but we certainly want to thank Representative Johnson for supporting this. I do want to emphasize, though, I've been at the Hospital Council 15 years. Prior to that, I worked in hospitals 35 years. And I want to explain that if someone did act out in the emergency room and it was obvious that it was a mental health or behavioral issue, the hospital personnel are trained on how to deal with that. So I think any concern along those lines can easily be addressed through the use of the discretion of the staff. The other thing I wanted to point out, when you get on a plane and you fly from Texas anywhere and you assault a flight attendant or anyone that's in line with the aircraft, then it's a federal felony. And so attacking healthcare workers should be on that same level. But we want to thank you for your consideration. We support this bill. And I do, once again, want to thank you for your public service.
Thank you, sir. I appreciate that. Chair calls, she just told me, Jennifer Cachel. Now I forgot it again. Kate, say it one more time. Cachel. Cachel. I have you registered as Jennifer Cachel, representing the Dallas County District Attorney's Office in favor of House Bill 2189. Is that correct?
Yes.
Okay,
Thank
go
you
ahead.
very much, sir. And thank you again, Mr. Chairman, and members of the committee. Again, Jennifer Cachel with the Dallas County District Attorney's Office, representing District Attorney John Crusoe of Dallas. I don't want to repeat everything that I just said to y'all, but just wanted to again reiterate our support of these bills, and we are in favor of House Bill 2189. And we are here to support our delegation of representatives that are supporting our healthcare community with this legislation. And if any questions have arisen, happy to answer those.
Okay. Members, questions? No? Thank you so much.
Thank you very much.
Chair calls Heather De La Garza. Heather, my registration shows you as Heather De La Garza, representing the Texas Hospital Association in opposition to House Bill 2189?
No, it should be support.
Okay, so I did find that odd. We're going to have to make sure that we
Apologies.
correct
That
that.
must have been an iPad finger error.
Do we have your permission to change
Yes,
the
you
record
have my
in
permission to change the
support of House
record
Bill
in
2189?
in support of House Bill 2189.
Okay, we're going to go ahead and make that change at your
Yes.
request.
Apologies for that.
You're never allowed back here again. No, go ahead. I was like, I'm going to be interested to hear the difference between.
No. As has been stated, these are identical bills, so I won't go over and repeat my testimony again. Just want to reiterate our points that keeping our hospital workers safe and preventing violence in the hospital is a top priority for our hospitals. Again, we surveyed our members and we found that workplace violence has significantly increased and the severity of the violence has increased. And I also wanted to take a moment to mention that hospitals are very workplace violence is a main issue, and so we are also supportive of other bills making their way through the legislature in the House and the Senate that would require all hospitals and other facilities to have workplace violence policies and procedures in place to, handle workplace violence issues. So with that, I will end my testimony, and I'm happy to answer any questions, and I apologize again for
No, no worries, Heather.
error.
No, any members, any questions for Heather? No? All right, thank you so much. Is there anyone else wishing to testify on, for, or against House Bill 2189 at this time? Chair sees none, recognizes Ms. Johnson of Dallas to close on the measure. Did you talk about the difference between the sub and the bill?
Yeah, we added social workers.
Okay, that's what I thought. Okay, just
Yeah, they were initially not included, and then since I have a bunch of social workers on my staff, they caught it. And
it made your bill better.
We added it, yeah, so that's a little bit of a distinction between the two bills. But thank you. This is an important issue that can send a signal to our healthcare workers that they're valued and important, and we care about their safety. So thank you so much, and with that, I close.
Thank you very much. All right, we're going to go ahead and Chair withdraws the committee substitute to House Bill 2189. If there's no objection, House Bill 2189 will be left pending. Is there any objection? Chair hears none. House Bill 2189 is left pending at this time. I'm going to go to Brooks. He's got neither. I'm going to run both of his. And then I'll go to James after that. Then I'll do James. This time, Chair lays out House Bill 1784 and recognizes Mr. Landgraf to explain the bill. I have a sub, right? No? Okay.
Thank you, Mr. Chairman. I appreciate the opportunity to lay out House Bill 1784. Here in the legislature, as you all know, we do have a duty to keep the laws of this state in harmony with technology's rapid advance, and House Bill 1784 is consistent with that duty and provides much needed protection to individuals who require a protective order. As we all know, smart home devices offer powerful capabilities to homeowners by allowing them to control home appliances from a distance, but they also allow individuals who have malice in their heart to harass innocent people. So House Bill 1784 addresses this issue by allowing magistrates to prohibit individuals who are subject to a protective order from remotely controlling smart home devices that belong to a protective order's applicant. It allows magistrates to prohibit individuals who are subject to an order for emergency protection from controlling smart home devices that belong to a person protected under the order for emergency protection. And 1784 allows magistrates to include, as a condition of release on bond for an individual charged with family violence, a condition that the individual refrain from controlling smart home devices that belong to an alleged victim of family violence. Basically, what this does is it would include this new technology as part of the order so that somebody who is the subject of a protective order can't do remotely what they would be able to do in person. So I believe 1784 will protect victims of family violence as well as individuals who need a protective order from harassment via smart home devices. And Mr. Chairman, I'm happy to answer any questions that you or the committee may have.
Thank you. Members, I have a ton of questions I'm going to ask you offline. Save a little bit. No, I'm just kidding. Do we, no? All right, I don't have it. Let me just make sure. Is there anyone wishing to testify on, for, or against House Bill 1784 at this time? Chair sees none. Recognize Mr. Landgraf to close on the measure.
Thank you, Mr. Chairman. I close.
Okay, if there's no objection, House Bill 1784 will be left pending at this time. Is there any objection? Chair hears none, and House Bill 1784 is left pending. Chair lays out House Bill 2084 by Mr. Landgraf and recognize Mr. Landgraf to explain the measure.
Thank you, Mr. Chairman. I appreciate the opportunity on this one as well. Just a few weeks ago, I think many of you, if you're like me, saw videos of street takeovers and street racing only a few miles from the state capitol. Unfortunately, incidents like that are happening all over the state, and they threaten the safety of Texans. In some cases, as we've seen in my district, some of these street racing episodes can take place in the dark of night with vehicles traveling upwards of 130 miles per hour. In fact, at a recent trial in my district in Odessa, a man was sentenced to 20 years in prison for killing 4 people while engaging in one episode of street racing. Unfortunately, under current law, the maximum penalty for causing death due to street racing is a second-degree felony capped at 20 years in prison, irrespective of the number of individuals killed. House Bill 2084 provides a legislative solution to street racing by increasing the penalty for street racing when 2 or more persons suffer serious bodily injury or death as a result of the offense. So in a situation like that, it would increase the penalty application from a second-degree felony to a first-degree felony. So that's the gist of it. We would account for those situations where there are a higher number of casualties. And Mr. Chairman, I'm happy to answer any questions.
Members, do we have any questions for Mr. Landgraf? No? Let me just check. Is there anyone wishing to testify on, for, or against House Bill 2084 at this time? The chair sees none, recognizes Mr. Landgraf to close on the measure.
Thank you, Mr. Chairman. I close.
All right. Thank you. If there's no objection, House Bill 2084 will be left pending at this time. Is there objection? The chair hears none, and House Bill 2084 is left pending at this time. Thank you, sir. Don't leave now, Gene. He can go.
Yes.
Is it in the committee's possession?
I'm sorry about that. I thought you said I was last. Oh, I'm so sorry about that.
Mr. Wu, I appreciate your patience. I thought you were just pranking me by leaving.
Oh, no. I thought you,
I was like,
you said like I'm after all these other bills. I'm
No,
like, okay.
well,
I was just chilling out.
Sorry, wasn't clear. This time, Chair lays out House Bill 1362 and recognizes Mr. Wu to explain the measure.
Thank you so much, Chairman Moody, and apologies for the awkward start.
Okay, you're going to finish strong, I know it.
Okay, I'm actually going to read from my prepared notes a little bit more than this one. This is a very important bill, and it's a little complicated, but I want to make sure that I follow the script that I've been provided for once. So, just in short, this change in a law, proposed change in a law, would ban the execution of defendants under 21. That's the short of it, okay? And this is the reason why, okay? In 2025, the U.S. Supreme Court ruled in Roper v. Simpson that the use of the death penalty against juveniles, that means in Texas under 17, in other states is under 18, is cruel and unusual punishment prohibited by the Eighth Amendment. The Roper decision, this is the important part, the Roper decision was based on an agreement and a finding that juveniles have diminished culpability because of 3 key areas. They lack the maturity for making decisions, results in what the courts call impetuous and ill-considered actions. 2, in turn, this leaves them more vulnerable or susceptible to negative influences and outside pressures. And 3, the character, as this is the court's own statement, the character of a juvenile is not well formed during that period. So that personality traits of juveniles are transitory and less fixed. And then anybody who has kids, teenage kids, can understand that very easily. Increasing the likelihood and propensity for reform. In short, this is arguing, in the court's decision, what they looked at was they looked at all the states where if you're under 18, all the things that you're not allowed to do because our government and our society has deemed them to be not responsible enough, that their brain is not good enough at making decisions of what they're not allowed to do. We don't let them vote. We don't let them sign contracts. We don't let them make their own medical decisions. On this same note, under this sort of same reasoning, right now, under 21, you're not allowed, well, we just changed it last time. You're not allowed to buy tobacco. You're not allowed to buy alcohol. You can't buy any hemp-based products. You can't gamble. You can't sign up for a credit card. Credit cards on their own decided this, but we've also, the federal government has also put this into legislation as well. Saying you can't sign up for a credit card without a cosigner. You can't even rent an apartment without a cosigner if you're under 21, right? And we have made these decisions from both an economic standpoint and from a governmental standpoint, saying like under 18 or under 21, you're not quite responsible yet. You're not quite ready to make those decisions, right? So this follows on over 20 years of brain science that has renewed the debate on whether young adults should also be excluded from the most severe form of punishment in our society. The developments in the fields of neuroscience and neuropsychology have determined that the brains of young people between the ages of 18 and 20, while functionally indistinguishable, are functionally indistinguishable from the brains of 17-year-olds in the way that are relevant to the Eighth Amendment moral culpability arguments and decisions, and the potential for potential for determining future dangerousness is inapplicable. Science has shown that 18-year-olds are more inclined to risky behavior and have diminished impulse control relative to adults, much like their younger counterparts. The psychological capability of late adolescents to exercise a mature sense of responsibility and to resist outside pressure is still very much in progress. Meaning, again, to put it in plain English, that they're much more susceptible to peer pressure and don't think things through before making a decision. The actions that lead to these convictions are often not made rashly, but are made under high stress and emotionally volatile circumstances, which adolescent brains are simply not equipped to deal with and to process and to respond to. As a result, young people are more likely to engage in antisocial and violent activities, but they are overwhelmingly grow out of it as they age and their brains develop. This is what's commonly referred to as the age crime curve. Simply put, decades of scientific research shows that adolescent brains are still developing and that critical areas of the brains relating to judgment, thrill-seeking, consequential thinking do not mature until the mid-20s. Due to these facts, experts in the field of psychology, neuroscience, psychiatry, criminology, and forensic testing for future dangerousness, and this is the term that's going to come up many, many times, future dangerousness, and psychopathy agree that it is not scientifically possible to reliably predict future dangerousness in a case of late adolescents under the age of 21. And that assessment of future dangerousness for this group is therefore likely to mistake a temporary deficit in maturity for a permanent deficit. This is critical, as the Texas death penalty law requires a finding of future dangerousness. This is a finding that juries must make before they can issue the death sentence. This bill would prohibit the imposition of the death penalty as to anyone younger than the age of 21 at the time of their sentencing in the commission of a crime. The U.S. Supreme Court has historically and continuously emphasized that the death penalty should be reserved for those people who have committed the very worst crimes and who have the highest level of culpability. Developments in the last 2 decades have shown that the same scientific and moral reasons given in the U.S. Supreme Court Roper decision in banning the death penalty for those under the age of 18 apply exactly to those under 21. So, and that's it. I'm gonna leave the rest for our witnesses, and then I would like to reserve some time to close.
Gene, have you had this, has this measure been heard before?
I have not filed this in the past.
Has it been I'm just wondering if we've had this, I don't think, I've
don't
heard
think
a lot of death penalty topics. I don't know that this is one of, maybe with some of the witnesses, they'll be able to remind me. But I didn't know if this was something we had ventured into before.
I don't believe so.
Okay. I appreciate you bringing it. Certainly, it is a complex topic and deserves time, energy, and attention for us to focus on. Members, do you have questions for Mr. Wu before we move to testimony?
Let me say just one more thing before I go to witnesses, and if there's no questions. We put into place an alternative to the death penalty, and that is life without the possibility of parole, meaning a true lifetime incarceration with no risk to society. So that is available in place, and that's one thing I think we should keep in mind as we talk about this. And I'll talk more about it in our closing.
Got it. Thank you. We will move to testimony. Chair calls Susie Bell Gosley. Ma'am, I have you registered as Susie Bell Gosley, representing the League of Women Voters Texas in favor of House Bill 1362. Is that correct?
That is correct, and I'm testifying for myself
On behalf
also.
of yourself as well. Okay. Go ahead and proceed.
Chair Moody, Vice Chair Cook, and members of the committee. I'm Susie Bell Gosley, testifying as a member on behalf of the League of Women Voters of Texas in support of 1362. We appreciate the opportunity to appear before you today and your undivided attention. We thank you for allowing the League of Women Voters to express our position on this bill. We support this bill wholeheartedly. And I actually, Chair Moody, do not remember ever having this bill. And I've only worked for the last 20 years on death penalty, but I don't remember it. By 2005, 30 states had either abolished the death penalty for all offenders or at least for those under the age of 18 years old. New brain science now reveals that even an 18 to 21-year-old has not fully developed the adult brain where they can understand and be accountable for as an adult. An 18-year to 21-year-old has not grown up to be a full adult and should not be culpable. The newest brain science is unequivocal that the human brain does not mature fully until the mid-20s. One of the areas of the brain that matures late is the prefrontal cortex, an area important in impulse control, risk-taking behavior, and judgment. Therefore, some have suggested that 21 would be a more appropriate age, both because of the rights and responsibility conferred by society at that age. Even in Texas, a person under 21 cannot buy cigarettes and the other items that were mentioned by Representative Wu, because it's believed that they do not make wise decisions about their health. There are over 3,000 limits throughout the country on behavior for people under 21 because of the recognition that people under that age do not have an adult brain. The League of Women Voters, in addition, supports a moratorium on all executions in Texas, while an official study of the capital punishment system is conducted. We would appreciate your serious consideration of that proposal. Thank you for your attentiveness, and I'd like to thank Representative Wu for filing this bill and for his excellent presentation. Thank you.
Chair calls Calvin Tillman. Calvin Tillman. All right, we'll just switch him to not testifying. Chair calls Raul Schoeneman. Professor, welcome back.
Thank you.
I have you registered as Raul Schoeneman, testifying on behalf of yourself, neutral on House Bill 1362. Is that correct?
That's correct. I'm testifying as a resource witness on the bill, and I have prepared written testimony for the members of the committee.
Perfect. We'll hand that out. Thank you.
Good afternoon, Chairman Moody and distinguished members of the committee. My name is Raul Schoeneman. I'm a clinical professor at the University of Texas School of Law, where I'm co-director of the Capital Punishment Clinic. And I think my remarks will be very brief. I've provided the committee with written testimony, and I've attached three documents in support of my testimony that I think may be of interest to the committee. The first, Exhibit A, is a resolution that was adopted by the American Bar Association in 2018. And so this is the largest, of course, professional organization in the legal profession, and it called on all states that retain the death penalty to raise the age limit of death eligibility from 18 to 21. So that was promulgated by the ABA in 2018. More recently, in 2022, just last year, in August of last year, the American Psychological Association issued a very similar resolution, this exact same rationale for raising the age of death eligibility from 18 to 21. And that rationale has already been explained by both of the preceding witnesses. Finally, the third attachment to my written testimony is a compilation of state and federal laws, including laws here in the state of Texas, that really reflect a recognition, a social consensus, essentially, that individuals don't achieve the level of maturity and responsibility to exercise all of the rights and privileges of being a citizen until they're age 21. So it's reflected in various licensing requirements, age restrictions that have already been set out, I think, well by Representative Wu. And so those are the documents I provided to the committee. I think the previous witnesses have already explained the rationale for why states have been are being encouraged to raise the age of death eligibility for death sentences. Essentially, what this bill would do is forbid the imposition of a death sentence on a teenaged defendant. It would bring an end to the teenage death penalty. And unless there are further questions from the committee,
members, do we have any questions? No. Thank you. These are extra. I don't want to waste them, so why don't you take those? And let me go back to my list here. Chair calls Elizabeth Henneke. I have you registered as Elizabeth Henneke, representing the Lone Star Justice Alliance, in favor of House Bill 1362. Is that correct?
That is correct.
All right, go ahead and proceed.
Nice to see you all again. I'm going to be brief because a lot has been covered. Chair Moody, the reason that you recall this is because you and actually Representative Leach and at the time Representative Dave Phelan all supported this halting of the execution of Billy Joe Wardlow, who at the time was an 18-year-old man who I had the pleasure of representing through as an amici, who was facing an execution and was ultimately executed. The issue that my issue in the case was to represent a series of scientists, namely Dr. Steve Strakowski, John Eden, Michelle Dice, and Dr. Kelly, all of whom believed that the test used to determine that he was eligible for the death penalty was not scientifically reliable. So I'm here to talk a little bit about that test because it is my opinion, as it was the opinion of my clients in that case, that we are currently and have in the last 2 years executed people according to a test for future dangerousness that is no longer reliable. Does that help jog your memory?
It does, and I knew there was something that we had talked about this at length, but I didn't think it was a bill, and I certainly, Mr. Wardlow's story is one that is going to stay with me, not just due to that conversation, but in the wake of his execution, there's also a lot of issues that we raised. So.
That's, yes, I almost said Your Honor. I'm used to being in court.
Not going to stop you.
So you've heard questions about future dangerousness. I'm going to focus my testimony specifically on how we determine that. So in Texas, in order to receive the death penalty, as you've heard, the jury must find that someone is going to pose a future danger. The test most commonly used to determine future dangerousness is one for a test of psychopathy. And specifically, the test is, I wrote it down, psychopathy checklist, revised. That checklist looks at things that I'm going to ask you questions to consider teenagers, okay? So the first one is impulsivity. Have any of you ever had a teenager? You know that they are inherently impulsive. It also looks at poor behavioral controls, lack of future goals, proneness to boredom, and need for stimulation. Those are actual questions from the test for psychopathy. It is for this reason that the doctors and experts in the field have now determined that those are, in fact, hallmark features of adolescence and young adulthood. And they have concluded resoundingly that those individuals under the age of 21 should never have the test of psychopathy applied to them because it is simply not reliable. And that's because teenagers, these young adults up to the age of 21, will inherently, by their very characteristics of being their age, test positive. Now, it's almost amusing because if you've met a parent of an adult, of a teenager, you know that they will tell you that their children are often psychopaths. But that is actually what the test shows. And yet that is the test that we use to determine future dangerousness and lead someone to execution. And so here, I'm going to give you some concrete numbers and then I'll close. What we now know is that 85% of people between the ages of 18 and 21 who commit even violent offenses will desist from any crime by their mid-20s. Only 5 to 6% of those who commit even violent crimes before the age of 21 will ever commit another serious crime. But what we also know is that there's no test to determine who is those 5 to 6%. It's like looking at a needle in a haystack. And so for this reason, that there is no reliable way to determine who is actually going to commit future dangerousness, I would urge you to eliminate the death penalty for those under 21.
Is that part of the material you gave us? Was the statistics that you just laid out?
It doesn't, but I will provide you a copy of the brief that we spread to the United States Supreme Court with that material.
No, that's fine. That buzzer is startling. I wasn't ready for it. Thank you for your testimony.
Yeah, thank you very much. I'm happy to answer any questions offline should you have them.
Yes, let's do that. Chair calls Kevin Trahan. I have you registered as Kevin Trahan here testifying on behalf of the Texas Defender Service in favor of House Bill 1362. Is that correct?
Yep.
All right, go ahead.
So good morning. As I said, my name is Kevin Trahan, and I'm here today on behalf of Texas Defender Service, where I work as a staff attorney. And our mission is to fight for the end of mass incarceration and excessive punishments in Texas with a focus on individuals who are sentenced to death. So yeah, I won't go back into what everyone else has said about the emerging brain science that we now know that people up to 21, perhaps a little bit older, are much more susceptible to peer pressure and impulse control than we once thought. So this bill, as I said, would really put Texas in step with the prevailing scientific view. And rather than break new ground, it would simply update Texas law to reflect the scientific community's understanding of brain development and its application to the state's minimum age for death penalty eligibility. I think it's also important to note that it would also conform the law to current practice in Texas. So of the 45 people sentenced to death in the last 10 years who are currently on death row, only 2 of them were under the age of 21 at the time of their offense. But while it's rare for the state to seek the death penalty for someone under 21, it still does occur. So in the most recent death penalty case in Texas, the state sought the ultimate punishment for a person who was 19 at the time of the offense. Yet consistent with modern practice, a Lubbock County jury rejected the death penalty and said to sentence the person to life without parole. So conforming the law to current practice like this would just ensure that justice is meted out fairly and not arbitrarily, as is the goal of 18th Amendment law. So for these reasons, I urge you to vote in favor of HB 1362.
Members, any questions for Mr. Trahan? Thank you for your testimony. Chair, next call is Kristen Cuellar. All right, Ms. Cuellar, we show you testifying on your own behalf and that you're testifying for the bill. Is that correct?
Yes, that's correct. My purpose today is to provide a written...
Pull the microphone down just a little bit.
Sorry. My purpose today is to provide a written statement by Richard Burr and to share some of his comments with you.
Perfect. Just want to clarify that you're testifying on your own behalf. This is your testimony, correct?
Well, I'm
regardless of where
sharing
you got
some
the information.
I mean, it is, but I'm sharing some comments from him, so...
Yeah, it's part of the written documents, but your testimony that you're giving today, your verbal testimony will be on behalf of yourself. Is that correct?
It is, yes.
Thank you.
Yes, so Richard Burr is an attorney in Texas who's been practicing capital defense law for 42 years, and he represented Billy Joe Wardlow, who was executed by the state of Texas on July 8th, 2020, for a crime he committed when he was 18 years old. Mr. Wardlow's clemency application summarized the reasons that he should not have been executed due to the immaturity of his brain at the time of this crime. And those reasons are equally compelling today in support of HB 1362. Billy Wardlow killed 82-year-old Carl Cole during the course of a poorly thought out and naively motivated robbery at Mr. Cole's home in Morris County in 1993. The motive for the robbery, which was to take Mr. Cole's truck and drive to Montana, was to enable Billy and his girlfriend to escape the hopelessness they felt as a result of years of emotional and physical abuse in their families. Based primarily on his confession, the jury convicted Billy of capital murder and sentenced him to death after determining he posed a danger to others in the future. And as you've heard, legal developments and research in the neurosciences since the time of Billy's trial in 1995 show that there is no way that anyone can determine with any reliability that an 18-year-old will be dangerous in the future. Since the U.S. Supreme Court Simmons decision in 2005, advances in neuroscience have led to two highly relevant findings concerning the brains of late adolescents like Billy Wardlow. First, the unformed character of 18-year-olds is associated with the lack of neurological maturity of their brains. Second, there is no appreciable difference in brain maturity and in the brain functioning related to character formation between 17-year-olds and people under 21. These developments would have had a profound impact on whether Billy Joe Wardlow's death sentence should have been carried out. The jury's determination that he would be dangerous in the future was the pivotal determination leading to his death sentence. We know now, but we could not have known in 1995 that it is impossible to any degree of scientific certainty to make this determination for an 18-year-old. And in the 25 years that Billy Joe Wardlow spent on death row before his execution, he demonstrated that he was not a danger to anyone whatsoever. In 2020, in the summer of 2020, when Mr. Wardlow was facing execution, he submitted an application for clemency to the Texas Board of Pardons and Paroles and Governor Abbott. And nearly 60 members of the Texas House and Senate communicated to the board their interest in taking up this question of the appropriateness of sentencing or executing 18 to 20-year-olds at the time of their crimes. In this current session, you now have the opportunity to do what that legislative body could not do and let the execution of Billy Wardlow be the last of anyone who was 18 at the time of their crime in Texas.
Thank you for your testimony, Ms. Cuellar. Members, any questions? Thank you.
Great, thanks.
Is there anyone else here that wants to testify on, for, or against House Bill 1362? Hearing none, Chair recognizes Mr. Wu to close on the bill.
Thank you so much. I want to just, I know we talked a lot about Billy Wardlow in the testimony, but I want to read something to you. This is a story from Texas. This is Johnny Frank Garrett. He was in Texas. He was executed in February 11th, 1992. All right. Developmentally disabled, Johnny Garrett was only 17 at the time when a nun from a neighboring Amarillo convent was raped and murdered. I'm going to skip a little of some of this. Desperate for leads in the case, the police turned to a local claimed psychic who contacted the Amarillo Daily News and claimed to have a vision in which she had seen the killer. She described the killer as a teenage male associated with the name Clyde. And Clyde turned out to be the name of Mr. Garrett's dog. Happened to share the same name. And I'm going to skip a whole lot of this. But ultimately, 2 police officers testified that after they had written down Garrett's essentially forced confession, he would refuse to sign it until after he consulted his counsel. The jury ultimately returned a guilty verdict and the death sentence shortly after. Appeals made to a variety of state and federal courts proved useless, and Garrett maintained his innocence until his dying breath, including Pope John Paul II also had requested that Mr. Garrett's death sentence be commuted as well. In March of 2004, a cold case DNA testing identified Leoncio Perez Rudella as the rapist and murderer of Narely Bryson, another elderly Amarillo victim killed 4 months before the murder of Sister Benz. In the investigation after Sister Benz's murder, prosecutors and police were certain the 2 cases were committed by the same perpetrator. In both cases, the murderer left behind a white shirt at the crime scene, and black curly hairs were found on the victims linked to Rudella. Another set of previously unidentified fingerprints in Sister Benz's room were matched to Rudella. Upon his arrest, authorities learned that back in his native country of Cuba, Rudella was a former prisoner inmate who had served a prison sentence for rape and murder. When he was finally interviewed, he admitted to not only the rape of Miss Bryson, but also to having raped a nun in a later attack in Amarillo, and recognized his shirt among the evidence in a police photograph of the scene of Sister Benz's murder. This is an innocent man that our state executed. And one of my point of reading this is simply to say there is no clemency, there's no pardon, there is no exoneration for someone who's dead, someone who's already been executed. This is not the only innocent person that our state has executed. And what my argument to everyone on this committee is that the sentence of life without the possibility of parole is sufficient for someone who is under 21. Because at minimum, that gives us a chance to see who they really are when they mature. It gives us a chance to exonerate them if they are innocent. And it gives them a chance to understand fully what it means to the people around them if they did the crime, right? But not only that, from a moral perspective, from a policy perspective, in this body, it would be a significant cost savings to the state, because we spend something around like $2 million a year for people who are on death row, and opposed to, whatever it is that we spend on just a regular prison. So I think there's a strong moral argument to do this, and also a policy consideration to do this, and I hope you will give it careful consideration.
Members, any questions for Representative Blue? Hearing none.
Thank you. That close.
Right. Thank you, Mr. Wu. If there's no objection, House Bill 1362 will be left pending.
Thank you.
Any objection? Chair hears none. House Bill 1362 is left pending. Chair recognizes Chairman Guillen to lay out House Bill 1603.
Thank you, Mr. Chairman. Members, House Bill 1603 seeks to authorize the appointment of an attorney pro tem for the state in cases where the state is not represented by counsel at trial. As y'all may know, Article 2.07, Section G of the Code of Criminal Procedure previously required the mandatory appointment of an attorney pro tem for the state in municipal and justice courts. However, this provision was repealed during the 86th legislature. As a result, there's been some confusion and uncertainty regarding the appointment of an attorney pro tem in these courts. HB 1603 seeks to address this issue by authorizing judges to appoint an attorney pro tem for the state if the state is not represented by counsel when the case is called for trial. This provision would provide clarity and ensure that the interests of the state are adequately represented in these cases. This concern was brought to me by municipal judges that have struggled with this over the last couple of years. I can help answer any questions, and we do have somebody here to testify and help answer questions as well.
Members, any questions at this time? Thank you, Chairman Guillen.
Thank you.
Chair calls Kathleen Person. Ms. Person, are you testifying on behalf of Texas Municipal Courts Association?
Yes, Chairman, I am.
And you're testifying for the bill, is that correct?
Yes, sir.
You may proceed.
Thank you, Chairman Cook and members of the committee. Just briefly, I'm here on behalf of Texas Municipal Courts Association. My day job is a judge for the Temple Court, and I'm also a judicial council member. And we're here supporting, TMCA is supporting House Bill 1603. I think the chairman, and thank you to the chairman for carrying the bill, laid it out beautifully. I think probably the only thing I would add would be just the scenario of, we're in a regular Class C court. The case is called. You have a victim. You have an officer. You have the opposing party, a defendant wanting an answer. And if the state isn't represented, everything comes to a grinding halt. And it's just an attempt to make it clear that a pro temp attorney can be appointed to handle that scenario, move the case forward, and not have it get reset and start back over again for everyone involved. So it's really just a fairness issue for those involved. I'd be happy to answer any questions.
Members, any questions for Judge Person? All right, thank you for your testimony.
Thank you for your time.
Is there anyone else here who would like to testify on, for, or against House Bill 1603? Hearing none, Chair recognizes Chairman Guillen to close on the bill.
Thank you, Mr. Chairman. If there's no further questions, I close, and I'd ask for your favorable consideration.
Thank you, Chairman. If there's no objection, House Bill 1603 will be left pending. Any objection? Chair hears none. House Bill 1603 is left pending. Next, Chair recognizes Chairman Guillen on House Bill 1896 to lay out the bill.
Thank you, Mr. Chairman. Members, revenge porn, also known as non-consensual pornography, is the act of distributing sexually explicit images or videos of a person without their consent. This can happen in several ways, such as a jilted ex-partner sharing intimate images of their former partner online or through social media, or a hacker gaining access to someone's private images and sharing them without permission. The consequences of revenge porn can be devastating for the victims involved. It can lead to humiliation, shame, and a sense of violation of privacy. In some cases, it can even lead to loss of employment or professional opportunities. It can damage to personal relationships, and in extreme cases, even threats to personal safety. Moreover, the advent of artificial intelligence and deepfake technology has added a new dimension to the problem of revenge porn. These technologies can be used to create highly realistic and convincing fake images and videos of individuals that can be used for malicious purposes. The threat of artificial intelligence revenge porn is significant, as it can be used to create fake images and videos that are virtually indistinguishable from real ones. This means that victims of revenge porn may have to defend themselves against fake material that is extremely convincing, making it even more difficult for them to clear their name and restore their reputation. HB 1896 would add revenge porn that is created by artificial intelligence to the existing revenge porn criminal and civil liability statutes. This bill is essential to addressing the threat of artificial intelligence revenge porn by acknowledging the role of computer-generated visual material in producing intimate visual material and prohibiting its wrongful use. We can send a clear message that these actions will not be tolerated in our society. We need to ensure that our laws keep up with the ever-evolving nature of technology and protect individuals from the harm caused by these nefarious actors. I can help answer any questions if you all have any.
Members, any questions for Chairman Guillen at this time? I do not believe we have any witnesses. We'll give you just a moment. Is there anyone here that wants to testify on, for, or against House Bill 1896? Hearing none, the Chair recognizes Chairman Guillen to close on the bill.
Thank you, Mr. Chairman. We did submit for the record some testimony from some people that have been victims of this. And if there's no further questions, I'd ask for your favorable consideration, and I close.
Thank you, Chairman Gillian. Is there any objection to House Bill 1896 being left pending? Hearing none, House Bill 1896 will be left pending. Next, Chair recognizes Representative Collier with regard to House Bill 382. Chair recognizes Representative Collier to explain the bill.
Thank you, Mr. Chairman and members of the committee. Given how recently the Texas legislature legalized hemp and specific CBD products, there is still a need to clarify the current statute in order to protect consumers from unintended consequences. An individual who purchases a CBD product currently runs the risk of unintentionally possessing marijuana, which is still illegal in Texas, if the label misrepresents the THC concentration within that product. If that consumer were to be stopped by law enforcement, they could be charged with the unlawful possession of a controlled substance, regardless of their reasonable belief that they purchased a legal CBD product. The inability to tell the difference between a legal substance and a substance with an illegal THC concentration poses a serious concern for consumers. Depending on the weight of the product, they could be prosecuted for felony possession and face significant fines and jail time. HB 382 seeks to protect consumers by providing a rebuttable presumption to defend against charges involving the possession of a controlled substance if 3 specific conditions are met. The product's label purports that the product is a legal consumable hemp product, the product contains a controlled substance, and the consumer purchased the product from a retailer the person reasonably believed to be authorized to sell consumable hemp products. When these 3 conditions are met, law-abiding consumers will have protection from the serious legal consequences that can follow a possession charge. By creating a clear defense to unlawful possession charges, HB 382 will provide consumers with necessary legal protections as Texas continues to evolve with respect to its marijuana policy. I believe there are witnesses here. I'm going to tell you right now, I just saw that there were 7 registered against, and I haven't heard from anybody. So this is going to be my first time listening with you as to why someone would be opposed to this very reasonable bill. And with that, I ask for the right to close.
Thank you, Representative Collier. Members, any questions for Rep. Collier at this time? Hearing none, we'll move to testimony.
Thank you.
Chair calls Sarah Mae Jennings. Ms. Jennings, I show that you're testifying on behalf of the Texas Fair Defense Project and yourself. Is that correct?
Yes, that's correct.
And you're testifying for the bill.
Yes.
All right, you may proceed.
All right, thank you. Thank you, members. My name's Sarah Mae Jennings. I'm the interim co-executive director and policy director at the Texas Fair Defense Project. I'm here to express our support for House Bill 382, which creates an affirmative defense to possession of marijuana when the individual reasonably believed they were in possession of hemp. A possession of marijuana conviction is a drug conviction for which the collateral consequences can be severe. Collateral consequences of having a drug conviction include disqualification from public housing, disqualification from student financial aid, disqualification from certain types of employment, and sometimes even disqualification of passport privileges. These collateral consequences are often far worse than the criminal punishment itself. House Bill 382 creates an affirmative defense to a possession of marijuana allegation when the individual reasonably believed that they were in possession of hemp. This bill seeks to avoid criminal convictions and the stemming array of collateral consequences for individuals who unknowingly possess marijuana when they believe they were only in possession of legal hemp product. Thank you. I'm happy to answer any questions.
Members, any questions for Ms. Jennings? All right, thank you for your testimony.
Thank you.
Next, chair calls Jesse Williams. Mr. Williams, I show you're here testifying on behalf of the Texas Cannabis Collective and yourself. Is that correct?
That is correct, sir.
And you're testifying for House Bill 382.
I am testifying for House Bill 382.
You may proceed.
So we've started learning over the last couple of years that police don't exactly understand this the way we thought they'd understand this. There has been really any formal training to be given to them. When this goes in front of DAs, we now have consumers, consumer level, who think they have a legitimate product they bought from a legitimate, reputable dealer, the storefront, and we're seeing this in major store brands now. My group tends to rail against what we call gas station CBD, but there's people buying it from reputable retailers. And if a police officer pulls them over, does one of their little test kits, and this turns up positive, they're going to go to jail for the night, especially if it was something like a gummy. That's a felony charge. You're going to jail immediately. Now you've got to try to fight to get out of jail, face bond, to go in front of a judge and explain, hey, this product had a QR code. I was able to scan it, look at the certificate of authenticity, a lab report that showed me this was a legitimate hemp product, but I'm being told now that this is marijuana and I'm facing felony charges. And they could spend a year or more fighting this charge easily. I wrote up about an article, I got a quote from the Texas Observer, where they asked me about this. And it's going to provide, this bill would provide consumer protections. And this can not just be also for consumers, but we would look at retail shops, because under the bill that does hemp in Texas, original bill, House Bill 1325 from 2019, the retailers are held responsible right now if a product is hot. But that would mean that retailers would have to go and open almost every container and test everything to ensure every product that goes on their shelf is a legitimate product, despite they were also purportedly told through legitimate outlets that these products were legitimate hemp products. So now they face the brunt of this if a consumer who buys it into the line faces this issue as well. I personally believe it's completely unreasonable that someone who's a victim of fraud has to face a penalty for somebody else's actions. We've heard this whole day about people who get defrauded by purchasing activities, things that they thought they were getting that aren't what they are. Like I said, I don't think anybody who's a victim of that should be the one facing the penalty for it. I'd hope you guys don't think so either. I do think this bill could go a little bit farther. We do need to give some training to our police officers, our DAs, about how these QR codes work, what a lab report looks like. They're not very complicated. They're very simple to read. That way they can understand what they're looking at and if this is marijuana or hemp. And I'm open for any questions.
Members, any questions for Mr. Williams? All right, and just want to confirm that all of your testimony that you gave today was with regard to House Bill 382, is that correct?
Yes, sir.
All right, thank you for your testimony.
No problem.
Is there anyone else here that would like to testify on, for, or against House Bill 382? Hearing none, the chair recognizes Rep. Collier to close on the bill.
Thank you, Chairman. In 2020, there was a man who spent a month in jail because he was accused of carrying hemp, marijuana, but he had 3,000 pounds of hemp, legal hemp. You can't tell what the difference by just looking at it with your naked eye. It has to be tested. So what this bill does is provide a defense to prosecution. So you can rebut that claim and have your evidence shown in court that you had legal substance in your possession. So with that, I ask anyone who has concerns to please come see me. And you guys, please call me if you have a question. I'm more than happy to work with you. I've done that on other issues. And with that, I ask for your favorable consideration.
Members, any questions for Rep. Collier? Can you just give us an idea of what you anticipate would be provided, like say if someone was charged and, as far as using this bill as a defense, how do you see it being utilized?
Well, just like that. I mean, if you're charged with, I think the example was very good. I purchased at the local smoke shop. I think it says, I thought it said it was 0.3 or whatever the, concentration is supposed to be. And I purchased it, but I get stopped and they say, oh, wait, this is not, we can't tell the difference. So we're going to test it. So I get stopped, but because it is, you can't prosecute me. If you was told that it was one thing. It told you it was the right concentration, but really it wasn't. And when they tested, they were like, oh, you got 0.5. That's not legal. And you're like, well, it said 3. It said I bought it from, I go here every weekend or whatever. And because of that, you're in possession of an illegal substance. But you relied on this retailer to provide you with legal products. And if they don't have a legal product, then you can get in trouble for it. But this is a defense, saying, I didn't know. I go here all the time. The 3 conditions have to be met. It was mislabeled. they're reputable, and I didn't know. And that will give you a defense. Now, it's not going to say you're not going to get arrested, because you will get arrested.
Right.
But you can defend it against it by meeting those 3 conditions.
Thank you. Members, any other questions? All right, thank you, Rep. Collier. Is there any objection to House Bill 382 being left pending? Chair hears none, therefore House Bill 382 will be left pending. Who else do we have? Is Ann still here? Is Rep. Johnson still here? Okay. Oh, God, that's so small. Oh, okay. Somebody get your stuff. You ready?
I'm ready.
Okay. All right, Chair lays out House Bill 227, and I believe we have a substitute. Is that correct?
We do.
All right. Chair offers that committee substitute to House Bill 227 and recognizes Representative Johnson.
Thank you very much. Chairman Cook, this afternoon, members, thank you for allowing me the opportunity to present House Bill 227. This is actually a companion bill that has already gone through the Senate and passed there this morning by Senator Whitmire. Members, the absence of effective regulation on surety bonds is posing a serious risk to public safety. The reason I say that is if you went to get through an arrest of an individual charged with murder, you brought that individual into a courtroom, you went through probable cause, the judge heard from the prosecutor about risk, the judge made their assessments on that individual, the defense made their position, and the judge said, this person needs to be held at $50,000 bond. You would hope and expect that that number meant something. But what we have seen in the last few years in Harris County, that it doesn't, if you happen to be a friend of certain bail bonds in the Harris County area. Because as one of them said when I was at the bail bond hearing, pushing for this concept of a 10% floor, was, yeah, if it's a friend of mine, I'll just go and get them out. I want, and I appreciate the opportunity to explain maybe how we got here and some of the history on why this is important, because I've had the opportunity to be in the criminal justice system for almost 20 years. As my time as a prosecutor, I have listened to thousands of jail calls. And almost immediately, the first thing anybody wants to talk about after they've been arrested and incarcerated is, hey, friend, can you come get me out? In the old days, and when I say old days, I'm talking just 10, 20 years ago, it would be, can you go get me out? And they would say, well, I've called around the bail bonds. This is what we need. You have a $50,000 bond. We have to put $5,000 down. And then you need somebody that lives in this county and has collateral, like a home or something else to put down, to be there to vouch for you and then get you out. I would hear those grandmothers say, look, baby, when I get you out, if I do this for you, because I lose that $5,000, you're coming home, you're getting right, and you're going back to court, and you're not going to have any trouble. In essence, we created a public-private partnership between the public safety system and the court setting bond and a for-profit bail bond industry that has the ability to make $5,000 from grandma for putting up the extra $45,000 and calling and making sure that somebody actually comes to court. Once that case is resolved, the bail bondsman will get back their money, plus the $5,000 that they got as a process fee or margin. The challenge is that what we've seen in Harris County over the last decade is a court case of O'Donnell, and what this had to do with was the idea of misdemeanor bail. And so let's say that 3 people get arrested on Friday night for a DWI. Person number 1 gets arrested for DWI, never offended before, has $500 in their pocket, and you set a bond at $500. They can make that cash bail with the sheriff, and they can go home with a promise to come back. Person number 2 gets arrested, does not have $500 cash on them, and calls their best friend or loved one and says, "You're never going to believe it. I got arrested for DWI. Can you get me out?" And they say, "I don't have $500 for you, friend, but I called a bail bondsman, and I can give them $150, and they will put up the rest of the $500, and I'll get you out." Person number 3 has no money, has nobody to call, and stays in custody over the weekend. By the time we get to Monday, these 2 people who have gotten out are not going to come to court until Friday. They'll have time to process their case. But for me, the person that didn't have the money, sitting in jail on Monday, when the defense attorney comes and says, "Look, you got charged with DWI. I don't have the full offense report yet. I don't have the breath test information, but you can't get out because you don't have $500. And they may say, "I got to go to work. I got to get out of here. How do I get out of here?" "Well, the state's offering you time served." "Well, I'll take it." The federal court told us in Harris County that is wrong. You cannot hold that person because they can't afford $500, because you're going to put them in that position of maybe taking a conviction, when because the other folks have money and access to it, they can get a different disposition. And so what we saw in Harris County is all 3 of those individuals, most of which would normally be going to the bail bondsman and giving them the $150 processing fee, going about their case and moving on. Most of those people started getting general order bonds. You don't have to pay anything. We'll let you out because you're not a risk. It may be that the bail bond industry hurt financially. Then you had Harvey, and then you have COVID. Whatever the reason, what I can tell you and what you can see on that graph is that over the last few years, we have had, and I gave you a couple of stories from the Houston area as well, we have had a bond crisis in Harris County. We have had people and rhetoric about the fact that bonds are not high enough, that bonds need to be higher, and we have seen public pressure being put on our courts to increase our bond amount. What you see there in that graph is over the last 5 years, for 4 years, they have continually ticked up to a point that I can tell you, as a former prosecutor, is insane. We are seeing people that are charged with offenses getting $150,000, $250,000, $2 million bonds, and then when it gets reduced from a $2 million bond to a $1 million bond, the public is outcrying, and I can't believe you lowered the bond, because there is this public rhetoric that somehow it is the judges that are letting people out. If you look at one of the other articles that I gave you about the bail bond crisis, you'll actually see that the majority of folks that were charged with murder, who were alleged to be out on repeat bonds, they were not out on judges' general order bonds. They were out on for-profit release, bail bondsmen who had gone and gotten them out. And so as I would see people argue and say, "Hey, how did this person get out?" And I would look at the images of the filing, I would see multiple bonds. I would see multiple bail bondsmen on it, but I don't know how much they paid. And in the old days, it was that 10%. What we started hearing is that some of the bail bonds, and not all of them, but some of them started giving 1-2% payment plans. There is a notorious case, which is also referenced there, about an individual that calls from the jail to his buddies and says, "I just need you to come up with a few $100s cash." That resulted in the death of an off-duty police officer at Grotto in House District 134. Last year, Senator Whitmire and I went to the bail bond board, and we said, "Do us a favor. We hear that some bail bondsmen, not all of them, are giving payment plans, as I heard, not even requiring any cash at all, and are making decisions that are superseding the judge and the prosecutor in the case. At least let's go back to what we knew as true, which is at least you had to put down 10%, $5,000, a commitment of skin in the game, and at least stabilize and make them go there. The bail bond folks, including Mr. Good, who I'm sure will testify today, said, hey guys, you can't do this. The legislature needs to tell you if you can do this. The legislature needs to tell you if you can require 10%. And that's why we're here. I'm glad to tell you that the bail bond board actually said, yeah, guys, we want you to do 10%. And started kind of, as I hear, putting them on the mark for, are you doing 10%? This is purely anecdotal, but you'll see that in this last year, these bonds have started to come down. My hope and my expectation is that the judges can get some stability in knowing that their judgment of $50,000 will no longer be superseded by a for-profit individual with no transparency and no accountability to the voters. And that when they say $50,000, at the very least, it means $5,000 cash. And so what we're asking for in this bail bond bill, which I hope is the beginning of a robust discussion on the infrastructure of what we need in the criminal justice system, because we don't need people sitting and waiting. We need cases processed. But at the very least, we need the judge's word to mean something. And it has to mean something about public safety and not about an individual who may make a decision for their own pocketbook. We have a number of witnesses who are here to testify, including Judge Mike Fields, who has been on the bail bond board for more than 8 years and is now retired, and including a sitting felony judge, Judge Colleen Guido. Both of these individuals can testify on the bill to answer your questions about what you have about the system. And then we also have the father who is the victim of a crime in Harris County, Mr. Paul Castro. He, over the last year, has really experienced some of the challenges in the criminal justice system, and he is very much, and his son, are very much part of the reason why we have filed these initiatives to, again, try to push back to make the system recognize public safety and not profit margin within criminal justice. Thank you, and I ask for the right to reserve to close.
All right, any members, any questions for Representative Johnson at this time? Thank you. All right, first, the chair calls Brian Hawthorne. Sheriff Hawthorne, excuse me. Sheriff's registered for. Sheriff Hawthorne, we showed that you've registered twice. You were very eager to testify on House Bill 227. So with your permission, clerk will remove one of those entries.
Absolutely. Please remove the one that had me not testifying. But they were both for the bill.
All right. Yes, sir. Yes, so you're Sheriff Brian Hawthorne, and you're here on behalf of the Sheriff's Association and yourself. Is that correct?
Correct. I'm Brian Hawthorne. I'm Chambers County Sheriff, just east of Harris County.
And you're testifying for the bill?
And I'm testifying for the bill, also on behalf of the Sheriff's Association of Texas. I'll be very brief. What Representative Johnson has just spoken of, we see quite a bit, especially in non-bail board counties. So counties like myself and others that are a population of under 110,000, you may not have a bail bond board. The sheriff essentially is kind of a one-man bail bond board. So you have a list of different bail bond companies that you may operate. Some are extremely professional, some are not as professional. One of the problems that we have seen is if you get a high bond, and she was using the $50,000, so I'm going to stick with the $50,000. $50,000 bond normally would take $5,000 for the family or a friend or somebody to make that bond. Well, if they don't have that bond, the bond company will say, well, you know what? I'll take $2,000 and then you pay me another $500 every week. Well, what happens when that $500 payment doesn't come along, especially after the second or third week, they go to the court and they want off the bond. Now they're off the bond. He comes back into the jail. He's in jail, and the family is now out $2,000, $2,500, or whatever that dollar amount is. So we support the 10% requiring it. This is really all about families and grandmothers that are doing everything they can to try and figure out how to get their grandchildren out of jail that have gotten themselves in trouble. And we actually see this bargaining of accepting a lower amount than the 10% is a very common issue in there's 235 jails that sheriffs run. And this is a Harris County scenario, but we see it across the state. That being said, I'll take any questions or
Any
thank you all
questions
for the opportunity.
Any questions for Sheriff Hawthorne at this time? Thank you for your testimony.
Thank you.
Thank you for your service. Next chair calls Ken Good. Mr. Good, I show that you're testifying on behalf of the Professional Bondsmen of Texas and on behalf of yourself and testifying against the bill. Is that correct?
Yes, sir.
All right, you may proceed.
Again, my name's Ken Good. Thank you so much for allowing me to speak to you for just a few moments. You know, at first blush, you know, you would look at this bill and you would say the bonding industry would surely be in support of this.
Yes.
I mean, the bonding community is going to make more money. But I'm here with the message that this is bad public policy, and let me tell you why we believe it's bad public policy. You've just heard a lot of evidence about the O'Donnell case in Harris County and that's driving a lot of what's happening in Harris County. What you didn't hear is that the Daves case from the Fifth Circuit reversed O'Donnell, and there's not even any jurisdiction, and Harris County will not approach the court to vacate it. And so a lot of the things that you've heard presented about the O'Donnell case is no longer correct anymore because it's been reversed by the Fifth Circuit. There's three types of release that we allow in Texas for pretrial. One is a surety bond, that's our industry. The second is a personal bond, and the third is a cash bond. Each one of those carries different failure to appear rates. The lowest failure to appear rate is the bail industry. If you use a surety bond, you have the highest likelihood of appearing for court. If you use a cash bond, the failure to appear rate is twice as bad. And if you look at the Harris County statistics on a personal bond, the DA's report from several years ago said there was a 50% failure to appear rate. The Police Officers Union did their own report for just a week and found a 70% failure to appear rate. And then Harris County CourtWatch.com downloaded 2 years worth of data from the district clerk's office and found an 80% failure to appear rate. And those are for personal bonds. The bail industry in Harris County, with a revolving door going on, with everything going on, still has a 10% or less failure to appear rate. So it is still doing its job to this day with the revolving doors going on all over the place in Harris County. This bill will make it more difficult for defendants to get out of jail. This is not the Harris County local rule. The Harris County local rule only applied to violent offenses. This is across the board. We know it will increase the cost because Harris County, the sheriff, right after this, or several months after this local rule went into effect, requested an additional $25 to $28 million in funding for the jail, which he referred to as unsustainable jail overcrowding. There are other states that have looked at this issue. The vast majority of states do not regulate payment plans or regulate what is even charged. The few states that do regulate payment plans allow a 3%, a 30% down payment, which is what this is about. The complaint is we're only charging, or there's bondsmen that are only charging 3% down payment. 3% of 10% is a 30% down payment, which Connecticut, which does have a substantial and robust regulation of payment plans, allows that. So this is inconsistent. This is nothing like anything that's been looked at anywhere else. So why am I saying this is bad public policy? We've had a revolving door of personal bonds in Harris County for many years. The problem for misdemeanors had rolled over to the felony courts. And as those increased, we started having a public uproar. They started then setting higher bonds. What we have, there are offenses that the courts across Texas normally deny bail, but in Harris County, they're not. They're granting bonds instead of denying them. If we wanted to apply this just to the restrictions in the Constitution where they could have denied bail, where the majority of state does, the bail industry would support that and would help provide language, but they're wanting to do across the board, which we do not think is in the best interest of the state. Thank you.
Members, any questions for Mr. Good? Chairman Darby.
Question. The bill author laid out a scenario whereby you would do the payout provision, and you would collect a percentage. Let's just say you collected the 30%. And then you would receive some periodic payment thereafter.
Yes, Your Honor.
to comply with the payout plan.
Yes, Your Honor.
From your perspective, what happens when the defendant defaults in that? Do you have any information relating to your industry or your company's
Yes.
response, and how many of those have had to go into court and say, we want to revoke the bond, we want off?
Yes, yes, sir. First of all, I would say the payment is not the only thing that industry does. The higher the bond, the more security, and as she had explained, is collateral they're going to look for to ensure that the defendant appears for court. I teach at the continuing education course for bondsmen. We instruct the industry. They cannot surrender a bond for lack of payment. So if they're doing a payment plan, they cannot surrender the bond for lack of payment. Courts can't take away probation because you haven't made your payment on your fines and fees. And so we use that analogy. If you're taking a payment plan, you cannot surrender that bond for lack of payment, just like a court will not put them back in jail for not paying their fines and fees. So we tell the industry that they cannot do that. We don't do that.
You tell them they can't, but and your company doesn't, but are you aware of any companies that do?
No, Your Honor. I mean, no.
Well, you can call me Your Honor.
Oh, I'm always going to call you Your Honor. I apologize. That's what I'm going to default to. But no, we do not surrender bonds for lack of payment when there's a payment plan, because we tell them that the courts can't put them back in jail for not making a payment to them. Then why are they going to put them back in court for not paying you?
So you're suggesting the only recourse would be to continue to work with the defendant to contain whatever bond fee you're going to charge for bonding that defendant out?
There's case law that is reported on grounds for surrendering a bond, and they're very limited. But if they move and they didn't leave any forwarding address, or if they haven't been in contact with you as they're required to do, there are like 2 or 3 or 4 grounds for surrendering a bond. And the biggest reason why we surrender bonds, they've been rearrested and they're back in jail.
Are there statistical data points that you have that suggest that in Harris County there are only, out of, I don't know, 6,000 cases, bonds, that you've only had 3 that surrender? You have a petition to surrender?
Look, Harris County has been a substantial problem for a period of time, not only for PR bond use, but because of the climate. You know, you can file a surrender, and the judge is even going to consider it. And so, yeah, I mean, the courts, we're kind of getting better because, you know, the bail industry is kind of your first line of defense. If we're seeing something wrong with the defendant, like the families coming to us and saying the defendant start using drugs again, or they've come to us and said, we're the indemnitor, we do not want to be the indemnitor anymore because they've started using drugs again, then we will notify the court of that. If the courts in Harris County, which is the problems that we've been having recently, they won't even consider the surrender. They won't even look at it. And so it's not only are bonds not being granted for what the allegation was, they're not being done even when we're pointing out to the court that this is a public safety issue.
So you don't see it as a problem that a bond has been set for a specific amount of money, and you've allowed that defendant to get out of jail for less than the financial commitment that probably the judge understood would be required in order to securitize, if you will, his release. You're just simply allowing a payment plan, and then you're telling us that you don't really enforce the payment plan.
No, Your Honor, that's the risk that they take if they do that. But they can enforce the payment plan. They can enforce the payment plan like any other breach of contract. What we're saying is you can't enforce it by putting them back in jail. I mean,
by putting them back in jail, or just simply asking to be removed from the bond? You're not putting them in jail. You're simply saying you want off the bond.
Well, when we surrender a bond on a 1719, all we're doing is requesting a warrant. If we're if we're filing a surrender, there's only 2 types of surrender. One of them is we're notifying the sheriff to let them know that they're in another jail and here's where they are, and they need to know that where they are so they can go get them, because we can no longer fulfill our promise to bring them to court because they're in custody somewhere. The second one is a request for a warrant. We're not off that bond until we bring them return the county to where they were before we posted that bond. And so those are the only two types of surrender there are. Now, what your question was about a payment plan, the bail industry's been using payment plans for decades. Look, 4 years ago, the complaint was we're too expensive. Now the complaint is we're working too much with families to get people out of jail. That's what we deal with, is families, so that we get people out of jail. And then and we're not posting a bond for $5,000. We're posting a $50,000 bond. And we're taking collateral or indemnitors to protect us on a $50,000 loss. We're not writing a bond for $2,500. We're writing it with the risk of having to pay $50,000. And so in Harris County right now, if a personal bond forfeits, no one's looking for those people. But if our $50,000 bond forfeits, we have incentives to go find them, because if we don't get them back to court as quickly as possible, then we have to pay Harris County $50,000. And that's the reason why we're the only ones being held accountable right now. That's the reason why we are the only ones that have a 10% or less failure to appear rate, because we're the only ones that they're making do their jobs. No one else is right now.
Okay, thank you, Mr. Chairman.
Any other questions, members? Mr. Scaslon.
So I guess my only concern is I was listening, and, Representative Johnson and I had spoken before this on this bill. Walking through, are you at all concerned that violent criminals are going to be easier let back out on the street when we give them a payment plan that's more palatable for their lifestyle, when in reality they need to be locked up because it puts the entire, area at risk for a repeat offender or anything like that? Is that not a concern?
No, it is a concern. And let me tell you, if you look at the defendants across the spectrum, the types of defendants, I've used this with my daughter. You have your first-time arrestees, and then, they listen to their friends, they listen to their family. As they get arrested more often, they're going to start peeling off. They're going to lose their friends first, but their families are going to stick with them for a long time. And so as long as you've got family that's standing up for a defendant, you've got your best chance of turning them around. And then they're going to get to the point where they keep getting arrested. They're going to lose their family as well. And that's where you get to your hardened criminals. And what this bill will affect is we're here where we still have a chance to get these people who have families still involved to turn around, because it's going to force some of those people to say, I can't help you anymore. I can't do this anymore. And you could have saved some of those people. And this bill will stop that.
I guess I'm not drawing the parallels. Because for me, someone staying in jail rather than paying bond, I don't understand how that keeps them from reconnecting with family or from, changing their ways in the future. I just don't draw the parallels on there.
Well, the concern we have is, we can't detain everybody. And so we have to make those choices. That's why we said, we think the real cause of this problem is because Harris County has quit detaining people that the Constitution allows you to detain. I've started referring to Harris County on murder, where you get one free murder before they're going to detain you. And that's not the bail industry that's doing that. And so I think a natural compromise, because it would address the Harris County situation, which is not a problem anywhere else, is let's limit this to the constitutional provisions where the courts are authorized to deny bail, and they're not doing it in Harris County. But instead, this isn't even the Harris County local rule, which applies to 17 offenses. This is across the board and applies to every bond ever posted in the state, whether it's a small county, whether it's a large county, whether it's a criminal code county, whether it's a bail bond board county.
Okay, thank you.
Thank you, sir.
Mr. Good, can you tell me a little bit about your association, just like what it's made up of?
Yes. So I'm an attorney. I specialize in bail law. I've been doing this for 20-something years.
Texas.
I'm on the board of directors.
Now, I want to know what the makeup of the membership is.
Yes, the Professional Bondsmen of Texas is made up of property bondsmen and agents for corporate sureties for 254 counties, 56 counties. I keep forgetting the number of our counties that we have. But, we have two different types of counties. In Texas, we have bail bond boards that's any county over 110,000, or population of 110,000. Anything less than that is a criminal code county, unless they decide to become a bail bond board in their discretion. And bonds no matter what type of county you are, you have an agent for an insurance company or a property bondsman. A property bondsman is someone who's writing bail on their financial statement. A corporate agent is someone who is designated by the insurance company to write bail on their behalf.
Yeah, so apply those to the types of bonds you talked about earlier when you talked about surety, personal cash.
The surety bond is can be posted by both a property bondsman or an agent for a corporation. The cash bond is just cash. We put some regulations in place last session on charitable bail funds. Those are cash bonds as well. And then personal bonds are free bonds where you're just agreeing to show up on a promise. And so our statute defines them as a bond without surety. The only distinction that I didn't mention is that in a criminal code county, you have to have a license by the Department of Insurance to post bonds, property and casualty license. In a bail bond board county, a population of over 110, you are exempt from that license requirement.
You know, if either one of those categories go off of bonds more often, when you talk about, I think you said property bondsmen, like what I think of just the local bondsman versus the insurance company sureties?
I would say the majority of the counties probably don't deal with surrenders very often at all, if at all. Probably the biggest surrender that we use now is to notify when somebody's been arrested on a new charge to let the court know where they're located. And when they bring them back to the county, the bondsman is responsible for paying the transportation fees. And then I would say probably it's used more often in our larger counties because it's just we have more bonds there, and we want to make sure we take care of business. And so we bring, when we notify the court that there's a problem, if the court agrees with us and issues a warrant, that warrant can be used to return them to custody.
Okay. And I think you're using the term loosely, but you're saying property bondsman is, again, like the local bondsman. I'm trying to distinguish between the local bond. Just let me finish my question. Just try to answer my question, not all this other superfluous information, please. So what I'm talking about is the local bondsman versus the New York insurance company, okay? So that's kind of what I'm going to put them into two different classifications. And so with regard to the local bondsman, what is most likely to occur with regard to surrenders? Are you saying that they do not go back in to ask a judge? Because we're going to hear from judges after you get through. And so you're saying they don't go and ask for permission to be removed from a bond?
I would say in the majority of the counties, it does not happen very often. Property bond, you can have a property bondsman is just a local bondsman who writes on their financial statement.
Okay, so let me stop you there. So the local property bondsman is generally not a corporation. Is that fair to say?
Cannot be a corporation. It's just an individual. And then an agent.
And then if you look at this bill is specifically talking about a corporation may not act as a surety. So we're definitely talking about non-bondsmen, right?
Yes, sir.
Okay,
We're only talking about agents who've been designated, who can also be local people, who can write for the insurance company. If I'm a bondsman, I can have two licenses if I'm, here in this county because it's a bail bond board. I can have a property license so I can write on my financial statement, but I can also write as an agent for an insurance company. That bill says it only applies to corporations, so it would only apply to one of my two licenses, which we have other people here that will talk about how we want to ensure that if we're going to have a rule such as this, that it applies to the entire industry and that we have an enforcement provision so that we want our industry to comply with what the legislator wants us to do, if that's...
And the last question I have is, you went through some math earlier about, let's say it's a $100,000 bond and it's a 10%, 10% fee as contemplated by the bill. So I wanted to check your math earlier. You went through some numbers where you talked about what percentage may be required to be put down.
I was talking about percentages on failure to appear rates.
Okay.
So in Harris County, we started noticing a failure to appear rate problem dealing with personal bonds. The DA was the first to notice it. She did a report saying that the failure to appear rate was at over 50%. The Police Officers Union in Houston did a report just analyzing 1 week's docket of cases for all the misdemeanor courts for personal bonds, found over 70% failure to appear rate. And then HarrisCountyCourtWatch.com downloaded 2 years worth of data from the district clerk's website using the same formula and found an average 80% failure to appear rate on personal bonds.
Last question I have is earlier at the end of your testimony, you talked about under what scenario that you would be willing to work with the author on. Can you restate that for me?
Yes. I believe the problem in Harris County is that the constitutional provisions that allow courts to deny bail They're not denying bail like they are the rest of the state. And so they're granting bonds. The criticism is that the bonding community is giving them payment plans. And so there's like 4 or 5 grounds: capital murder, 3 strikes, the courts can deny bail. And I think if we limited the bill to those provisions, that would satisfy the concern for Harris County, and we're more than happy to work with the author for that and to provide language to
You're
make
talking
sure.
about certain crimes or what?
Yes, certain crimes that the Constitution, we've had elections where the voters have agreed that the courts can deny bail in 4 or 5 situations. One is capital murder.
Do you know if your bondsmen, as part of your association, feel differently in Harris County versus a Tarrant County or Dallas County bondsman?
If we, on that, or are you talking about on payment plans in general?
No, just going back to, is this, I guess, what I keep hearing, this sounds like a Harris County issue, and so I'm asking is, should this be a bill that's bracketed to just Harris County, more than 2.5 million or whatever that number is?
I think it's a Harris County problem. And, but I think if we fixed it in the way that I've suggested, that would, it wouldn't affect the rest of the state. But I think if you fixed it in that way and bracketed it, then it would address Harris County because it's not affecting the rest of the state. So yes, but I don't know if we as an industry like brackets, we want it to apply to everybody the same. So when we're teaching our classes, we say these are the rules. We have bondsmen that operate in multiple counties. And so when we do that, we tell them, if you're in a bail-bond county, in a criminal code county, then you need to train all your employees to one set of rules.
Thank you.
Thank you.
Chair, next calls Paul Castro. Mr. Castro, we show that you're testifying on your own behalf and you're testifying for the bill. Is that correct?
That is correct.
All right, you may proceed.
Thank you. Distinguished representatives, my name is Paul Castro. I ask you to listen to a real-life horror story and let that guide your vote on House Bill 227. On July 6, 2021, a convicted felon murdered my son David Castro in a road rage incident after an Astros game as I madly drove away trying to escape the paroled felon who chased us. David was and will forever be 17 years old. He was set to start his senior year where he would have led his percussion section at Westside High School. He was a good kid. Our life indelibly changed that night. Thanks to the hard work of the Houston Police Department and 100-plus tips called into Crime Stoppers, his killer was identified and arrested within a month. Our family breathed a sigh of relief when we heard that bond had been set at $350,000. The thought of the accused killer being free while awaiting justice was harrowing. We were told by the DA's office that our wait for in Harris County could be as long as 4 years. We rested, assured that the accused would have a hard time raising 10%, $35,000. Not even a month after the arrest, I received an automated call on the Vine network on a Friday night, informing me the killer had posted bond and was on the street. No monitoring device, no supervision, because pretrial services was closed for the weekend. Even though we had been assured that he wouldn't be able to raise the funds, the killer was not only loose, but he was without any supervision. Over the next few weeks, I learned what had happened. A loophole in our bond system. Through that loophole, a subset of bondsmen used questionable tactics to bail out dangerous individuals. Many, like our killer, who are repeat offenders at discount rates, sometimes as low as 2%. David's bondsman is the person who admitted that she sometimes took no money down from defendants. David's killer, a twice convicted felon, was set free for pennies on the dollar. After the killer's bond release, a key witness retracted her testimony, imperiling the case. Doubtless she feared for her safety. While out on bond, the killer violated the terms of his bond on a Friday night at midnight, being gone for 8 hours. Pretrial services didn't bother to notify the DA for 2 weeks. We learned that the killer went to the ER for toenail fungus. The system failed again. Every night for 17 months, I feared the killer would come to kill me or a key witness. Every night, I checked closets when I came home to see if he was waiting, knowing the system would not protect us. All of this could have been avoided had the killer still been behind bars, unable to raise the 10% that the judge set for him. The shooter has since pled guilty to David's murder and is serving a 15 to 30-year sentence. We had to settle for a short sentence, in part because the witness's retraction, that retraction happening after he was released on bond. We took a plea agreement for fewer years in order to get this murderer off the streets. In a time when Harris County has 1,000 accused murderers or murderers on the streets, out on bail or uncaught, families call out for your protection. Our family prioritized the public's immediate safety over any sense of proportional justice. I ask you to do the same today. Ignore the pleas of the bondsman lobby and support House Bill 227. As has been stated, this is a multifaceted problem. This bill is part of the solution. No other family safety should be compromised by discount bonds.
It's like you timed that about perfect. So, Mr. Castro, very sorry for your loss.
Thank you
for having the courage to be here today and testify before the committee. We appreciate you being here. Members, any questions? Ms. Morales.
Mr. Castro, I'm from Houston, representing Houston. Thank you so much for your testimony. And I know it's so hard, but thank you so much for your advocacy, because I know this will help so many families. And did you need any more time?
No, actually, I landed the plane. So.
Perfect. Thank you so much.
Members, any other questions? Thank you, sir.
Thank you.
Next, we'll hear from Judge Colleen Gatto. Judge, we have you testifying on behalf, is that correct?
Yes, sir, and I'm just testifying on the bill.
Perfect. You may proceed.
Thank you all for having me here today. I'm basically here as a resource if anyone has any questions about how things are done down in Harris County when it comes to setting felony bail. I am the presiding judge of the 337th District Court, obviously hearing felony matters. Little background on me. Came out of law school at the University of Houston. I was a prosecutor for a decade after interning there. I left the DA's office as the chief of the human trafficking section. I then went and practiced indigent defense for 4 years, and then now I'm a felony district judge. As the committee knows, the Texas Constitution and Article 1715 of the Code of Criminal Procedure set out very clearly what judges are to consider when it comes to fixing a bail amount. There's been some testimony today here about the denial of bail, and I know this committee knows well that thanks to the Texas Constitution, there's a very limited amount of times where a district court judge as myself may deny bail. One of those is for capital murder, but that's only if a hearing is held and if the prosecution provides proof evident that not only will the defendant be found guilty, but that the death penalty will be the resulting sentence. So that's one instance. The other instances are under Section 11A of the Texas Constitution. Those are for things that you sometimes hear repeat offenders. We call them true habituals, people who have been to prison twice on 2 separate occasions, or people who have been to prison before for a violent offense, something that y'all would probably refer to as a 3G under the code. The thing about 11A is that not only does it require a hearing to deny bail, but then the Texas Constitution only allows the denial of bail for 60 days. After 60 days, there's not a lot of evidence that's in on most of these felony cases. At that point, the Texas Constitution requires that bail be set under 11A. And you come to 11B, which is where most of the denial of bail in Harris County is happening these times. 11B says that if someone is out on a felony bond, and if it is proven at a hearing that they violated a condition of that bond related to community safety, then, see that yellow light? That's helpful. Only then can the court deny bail. So just as a precursor for the denial of bail. 1715 governs the rest of it. There's a lot of things that the courts look to, including that it be sufficiently high to give assurance that everything will be adhered to, the community safety, as well as what the defendant's ability to make that bond. It is set out in stone by y'all in this book and through our Texas Constitution what we have to consider. The amount of payment that is made to the bond companies is nowhere in this book for us to consider. If y'all have any questions about how things happen down there or what we look to when we're setting bail, I'm happy to answer them.
Chair recognizes Representative Morales.
Yes, ma'am. Thank you so much. And you're a constituent, so welcome.
It's nice to be down here.
I'm not a lawyer and, never defended anybody or anything like that. But my initial thought would be, why are these people even why are they not denied bail? But you just explained that so well. Thank you so much. So would amending the Constitution be helpful in this situation, or is that just out of the question?
Well, no. So I do believe that there is maybe a bill pending in the Senate right now regarding the denial of bail. The way that I explain it when I talk to members of the community is you'll see on like Law and Order in places like New York, they'll say, well, the state or the government moves for remand, and the judge says, granted, and then there's no bail. That's not here in Texas. The Texas Constitution is very pro-bail. And so it sets out very limited circumstances where a district court judge can deny bail. And in all of those circumstances, the prosecution must put on a case and a burden must be proven. It's not always beyond a reasonable doubt. It's usually a preponderance of the evidence or something like that. They all require a hearing and then a decision to be made by the judge. So there is no just gavel and bail denied. That's not allowed under the Texas Constitution as it is currently written.
And in the case that was in Mr. Castro's case, I mean that didn't fall under this guy's that bail would be denied. So
my understanding of Mr. Castro's case, I was not the presiding judge. I'm not sure I could speak on it if I was, is that the defendant had been to prison twice before on 2 different occasions, making him what would have been a true habitual. So if the state had requested an 11A hearing to deny him bail, and if the state had met a burden of proof, they could have denied the defendant bail for 60 days. And after 60 days, then bail must be set. My only guess, as someone who's been in the system for 17 years, is that provision of the Texas Constitution was made a long time ago, when evidence was forthcoming, when there wasn't ballistics, there wasn't DNA, there wasn't a backlog of things that the crime lab needs to do. 60 days doesn't buy you much of anything these days. So with my basic understanding of that case, that is the only way that he would have been denied bail, and it would have been for a very short period of time.
Thank you so much.
Yes, ma'am.
Just want to clarify that all of your testimony that you're giving is in regard to this bill, not the Senate bill. Is that correct?
Not at all. No, sir, I have no opinion on that or this bill. I'm just here to provide information.
Right. So just, I wanted to clarify one statement that you made. I mean, in the Castro case, the bond was set at $350,000. Are you saying, I think you've already said this, I just want to clarify that when you went through the process in your mind, if that would have been you as a judge, you would not have factored in what the defendant would be required to pay to the bondsman. Is that correct?
It is not something that I'm allowed to consider under here. I will say, just having only done criminal law in Harris County for a while, I do think we all have in the back of our minds that 10% was the amount charged. That was just from my time as a defense attorney, but it is not something that I take into account.
Sure.
I suppose it would be helpful to know when you're setting a number what the number means, but that is not something that the legislature has listed as something that I can take into consideration, or the Texas Constitution.
In your opinion, should it be?
I think I was told not to give an opinion.
Fair enough.
All I could tell you is that, I trust y'all.
But it would be helpful information, I mean, as someone that's in that position.
Certainly. I mean, I think the most information that a judge can have, and to this end, I'll tell you this. Harris County is so overwhelmed by volume that when I was practicing, defense attorneys would come up to the bench, and they still do, and they say, hey, judge, I want a reduced case for this type of case. I do not do that on murders, sex assaults, sex assaults of children. I say we need to go on the record, and everybody needs a chance to take a pause so I can get the maximum amount of information related to this case, related to your client, related to the community, and all of that. So I guess this is my way of saying the maximum amount of information that you can give judges to make a determination under 1715 and the Texas Constitution is always good.
Thank you, Judge.
Yes, sir.
Chairman Darby.
Judge, thank you for your testimony. Just to follow up on questions that I'd given to one of the previous witnesses about this kind of payout plan, if you will, for the initial 10% fee. Have you, in your experience, seen bonding companies asked to be removed from the bond for failure of the defendant to pay the as-agreed plan of payout?
That has not ever been listed on a surety surrender. To my knowledge, it's possible, but I have not seen that personally.
Well, what are the reasons for surety surrender other than failure to pay? Could it be?
Well, it has picked up a new case, is back in the custody of the jail. We've been told by the family members that they are, not where they're supposed to be. They haven't been checking in with the bonds company the way that we've requested. Information from family members that they're using drugs again won't come to the meetings that we have scheduled with them.
So you don't track the reason for asking to be removed from the bond? You just simply...
In terms of statistics?
Yes, statistics. No. Is it a high, is it in light of the total number of bonds that are being posted, is it a high number?
No, sir.
How would you characterize it?
I would say that I get a request to be for a surety surrender weekly, but I have 1,000 pending felonies in my court, and I'm the second lowest docket in Harris County. I get them often, but compared to the total amount of people who are on bond, I would say it's not a large percentage.
Okay. Thank you for your testimony.
Yes, sir.
Members, any other questions for Judge Gato? Thank you for your testimony. Thank you for being here.
Appreciate y'all.
Thank you. Chair, next call is Roger Moore. Mr. Moore, I show that you're here testifying on behalf of the Professional Bondsmen of Texas and on behalf of yourself against House Bill 227. Is that correct?
That's correct, Mr. Chairman.
You may proceed.
Thank you, Mr. Chairman, members. It's been interesting listening to the questions that have been addressed to previous witnesses. Bondsmen are in the business of making sure that their clients show up to court, and they are putting their own resources at risk. Even if they write through an insurance company, they have a contract with the insurance company whereby they personally are going to be liable to the insurance company if there are any forfeitures. So it is in their best interest to make sure that they're on top of their clients. They generally require them to check in either weekly, sometimes daily, depending on the seriousness of the charge or the size of the bond. They want to make sure they know where they live, where they work, who their relatives are. They require co-signers, that is indemnitors on the contract, so somebody else has skin in the game. They often require collateral to minimize the risk that they have when they sign on the dotted line saying, I'm going to be responsible for this defendant. It is rare for a bonding company to surrender a bond in most cases. And when they do, it's only because they've exhausted all of their in-house tools to get the defendants back on track. I mean, typically would haul them back in, counsel them and say, look, unless you straighten up and fly right, I'm going to have to go to court and surrender this bond and ask the court to put you back in jail. But that's not something the bonding companies want to do. They want their clients to be successful, make all their court appearances, and either go off to the pen or the local the local jail, or be found not guilty, or be put on probation. Any of those things would terminate the bond at that point, but short of that, they're not looking to try to surrender those bonds. Also, the whole notion of having bonds financed with some kind of premium is not something that bonding companies want to do in most cases. They'd rather get all their money up front. But the fact is that the economy is such that many, many of their clients would simply not be able to get out of jail at all if they had to come up with all of that fee that they were quoted up front. And so the bonding companies will try to get as much as they can and have a payout period as short as possible, while in order to go ahead and get that defendant back to work and working with the families. The problem that I have with this bill and with the association has with the bill is twofold. One, it's overbroad in that it applies to all offenses from Class C misdemeanors all the way up to capital felonies. And we're really talking about only serious felons who ought to be examined closely because they might be a risk to the community. But the second problem we have is it only applies to corporate sureties. And as you've heard, there are both corporate sureties and what we call property bondsmen who write on their own assets. In Harris County, there are 55 corporate surety licenses and 17 local bondsmen who are licensed as property bondsmen. So if this bill were to pass in its current form, those 17 property bondsmen would be free to still continue to have payment plans. But the corporate sureties would not be able to do so. And that's true across the state. In most counties, the overwhelming majority of the bondsmen are property bondsmen, not corporate sureties, and they simply wouldn't be under this provision at all. So we'd like to see it, if it's going to be changed, to have it apply to all forms of surety bonds, and only to the most serious, only to the most serious kinds of offenses. I see my red light is on, so.
Members, any questions for Mr. Moore? Thank you, sir.
Thank you.
Thank you for your testimony. Next, Chair calls Mario Garza. Mr. Garza, we show that you're testifying on behalf of the Harris County Bondsman Association and yourself against House Bill 227. Is that correct?
Yes.
All right, you may proceed, sir.
Yes, my name is Mario Garza. I also sit on the Harris County Bail Bond Board in Harris County. You've heard from a lot of, well, you've heard from attorneys and judges, but I thought it was important to hear from a real bondsman who does the job every day. The risk, how we evaluate risk. We are dealing with people. Again, the bail bond environment is very different than what it was 5 years ago. There were things that used to happen when violent offenders got charged with a case with a violent criminal history. Judges used to hold them zero bail, deny bail, those type of things. We were okay with that. In fact, as a person that has to live in Harris County, I'm okay with that. I feel for people like Paul Castro and victims of that who have been victimized by a criminal justice system is no longer holding anyone accountable. As you know, the numbers of failure to appears and that sort of thing. Some bondsmen, myself, I'm a surety bondsman. I have a corporate surety, but I also write very conservatively because I am responsible for that full amount of that bond at the end of the day. So when I write, that is my risk evaluation. We don't have a crystal ball. We are not able to determine who's going to go out and reoffend, but we try to gauge that to a minimum. For instance, the questions that were asked about bonds that are surrendered and defendants that we want to be placed back in custody, there's a lot of factors there other than just the payment. Sometimes they don't check in, sometimes they've moved, they didn't update us on an address, they left the county. These are all things that we use to evaluate to say, you know, we no longer want that liability because it's become too risky. As Judge Guido said, that she doesn't see a lot of those. It's like Roger Moore just said, a lot of us don't want to place a defendant back in custody. But sometimes it's the only option because family has requested it. We see that they're violating conditions, curfews, things of that sort. So again, I am a bondsman. I've been a bondsman for 15 years. Also to note, we've lived with the 10% rule for the last year in Harris County, and crime has not gone down. It has not affected the crime problem one bit. In fact, it's gone up. So this is what a 10% would look like just in Harris County, which is your largest county in Texas. So if it looks like that now, what would it look like across the state, across every type of case? You're only dealing with 17 type charges. So I think it's important that you hear from a bondsman. And if there are any questions, I'm more than happy to answer them.
Members, any questions for Mr. Garza? Just have one of the final statements that the previous witness made was that it should apply to all sureties. Do you agree with that? Since you kind of have a foot in both areas, you said you're a property bondsman and
no, I'm just a corporate surety.
Okay, corporate surety. Okay.
But I think that I don't see the difference. I think it's something that should
apply across the board.
If it's a 10%.
Well, I mean, if this law were to be passed, in your opinion, should it apply only as drafted to corporations or to all bondsmen?
I think it would be unfair to property bondsmen because their liability would be much lower. So I don't think it should. I think it should the way that it's written, but I think it's unfair. So
explain to me, what do you mean?
Well, corporate sureties, our liability, you know, because we are backed by corporate sureties, we tend to have a little more leeway with our liability. As a property bondsman, their point system is always gauged. The sheriff's always having to rein it in and say, hey, you've hit your limit, things like that. So I don't think the 10% is a good rule.
For property?
Yeah.
Okay. And you're an agent for an insurance company, is that fair?
Yes.
Okay. And where is that insurance company?
It's Bankers Insurance, and they're licensed out of Florida.
Florida, okay, great.
Yes.
All right, any other questions for Mr. Garza? All right. Thank you, sir. Thank you for being here. All right, last but not least, we have Judge Michael Fields. Judge Fields, we show that you are retired district judge, and you're testifying on your own behalf today, and you're testifying for the bill. Is that correct?
Retired county criminal court at law judge, testifying on the bill and as a resource.
Okay, we have you for the bill, so do you give the clerk permission to change it? Because right now it says you're testifying for the bill.
Testifying on, and do you
give her permission to make that change? Because in the system now it says for.
Yes, sir, I understand, and I do give you that permission.
1 second. All right, our records now show that you're neutral, and you may proceed, Judge.
Thank you, and I do still sit as a visiting judge on occasion. I was the chair of the Harris County Bail Bond Board for nearly 8 years while sitting as the judge of Harris County Criminal Court at Law number 14. I've done extensive work as a criminal defense lawyer and a prosecutor, both in Harris County and around the state, Mr. Chairman. I do have some things that I'd like to address that were said both by Mr. Cook, by the last bondsman who was up, and maybe to expand a little bit on some of the things that Judge Guido was able to say. With respect to this idea that there's a get a murder free policy in Harris County, that's just not an accurate statement. Judges are required to set bond, as you now know, by the Constitution. The amount of bail that can be set depends on a number of factors contained in 1715. And so when you consider those things and you set, and unfortunately, Mr. Castro, I really do feel for you and your family at the loss of your son. In that instance, that judge had to set a bail, set a very high bail, and could not anticipate that a bondsman would then come back and undercut that bail by charging less than that 10% rate, which is what we're accustomed to in Harris County and around the state, really. One of the things that was not addressed, and I'm jumping around, y'all, because you've heard a lot, and I'm sure that you'll come back and ask me to clear up some things if you need them cleared up. One of the reasons why I saw a lot of surrenders was in immigration cases. Our Constitution applies equally to folks whether they're citizens of the United States or not. If a person posts a bond, pays the 10% to a surety, and then has an immigration hold, that surety can then come in and surrender that bond because they are in immigration custody without having done the proper due diligence to ensure that they're not going to be held in immigration custody. Now the immigrant family is out the 10% or whatever the percentage is, and the person is in custody. I used to make those folks give that money back, but a lot of times that doesn't happen, and so that family's just out the money. With respect to this idea that property bondsmen should pay less than surety bondsmen in terms of this 10%, here is how that works. A property, and you've asked that question a few times now. A property bondsman, say, puts up a CD, some non-exempt property. Let's say they put up $500,000 worth of property, CD, property, whatever have you. They can write up to 10 times that amount, right? So now they have the ability to write, let's say, $2.5 to $5 million worth of bonds, if they have the right type of history. As they write up that bond and they take up that $500,000, their ability to write is limited. And so they have to run off, as they say, that money so that they can free up that $500,000 that will cover the liability on the 2.5 that they can write, if that makes sense. With a corporate surety, their ability to write is limited to the ability of the insurance company to pay. So they have a nearly unlimited ability to write bail. Now, going back to this O'Donnell matter, in Harris County, the Harris County criminal courts are under the O'Donnell ruling, and I'll stop if you'd like me to, are under the O'Donnell ruling, which there's a consent decree. What you do here today, and Representative Johnson's bill is going to become very important shortly, because it's true. O'Donnell is most likely not going to be the law of the land if challenged. Note that it hasn't been yet, but the court has said that, and has leaned very heavily, the Fifth Circuit Court of Appeals, into saying that this younger abstention, which would keep the federal courts out of state business where there's law applying, should have been applied. They would have applied it, most likely, and O'Donnell would probably go away. Now we're going to have a whole lot of folks out there on bail again. There is an argument that consistency will make it so that everyone knows exactly what to expect. That's what this bill does. It gives us consistency across the board. How does that tie into the property versus corporation thing? Consistency is consistency, and I do agree with that there should be consistency irrespective of who you write for, yourself or a corporation. Everybody should be treated equally. We really don't want the government involved in contract law too much, but where it has to be involved in those limited cases where judges must set bail. And remember, even though O'Donnell goes away, judges still have the ability to set personal bond in a large swath of cases. So this misnomer that, oh, judges are going to have to set bond and bond's going to have to be posted on everything, that's not 100% accurate. Judges can still set personal bond on nonviolent offenders, which comprises the most of what we see in county criminal courts and a lot of what we see in district courts. It's on that limited group of folks where very unfortunate things happen to families that we need that consistency, some would argue, to make sure everyone is treated fairly. I was here last legislative session saying money doesn't make us safer. And I agree, money doesn't make us safer. But it does tend to increase in a person's willingness to show up. Because as was said earlier, their family is now on board. It's a private-public partnership that makes sure that person shows up. And we do have those bail bondsmen who will make sure that they get into court. You asked a really good question, sir, about whether or not we've seen people get their bonds surrendered because they can't pay. And the answer is no, maybe. You can write down whatever you want as your reason for surrendering that bond, so long as it comports with what the statute says. That doesn't necessarily mean that that's what it is. It just means that you wrote down what was statutorily necessary. Now, in Harris County, there's a checkbox form that we sign off on saying, this person surrendered. We want A, the clerk to issue a warrant, B, the sheriff to issue a warrant, or C, neither of the above, right? So let's say a judge gets one of these things, this surrender, and says, you know what, I'm not going to surrender this bond. What does that mean for the bail bondsman? It means that he has, as my old contracts professor used to say, a lead pipe cinch defense to a forfeiture. So if the judge refuses to allow the surrender, there's no more liability on the part of the bail bondsman, how I remember it when I was on the bench. Maybe it's changed. The person can still be arrested, but the bondsman is off the hook for the overage, if I'm making sense, right? Because they've now surrendered. They've offered the surrender. The judge denied it. They can use that denial in their defense on the forfeiture. That's how that works. And so, you know, with all due respect to the bail bond industry, and I'm not making an opinion one way or another, they've written a lot of the bail bond law. They have an extremely powerful lobby. Some of you might know that. They know how to get around in this system, and they've done a very good job of doing it. And that's no offense to them. It's just the way that it is. So what Representative Johnson is offering, it seems to me, is a way to level the playing field and protect the public by ensuring that people show up in those limited number of cases where we have to see bail set. I have no opinion one way or another. That's your decision to make. That's the public's decision to make. I just wanted to be here as a resource for you if you need me.
Any questions for Judge Fields? Chair recognizes Chairman Canales.
Thank you, Chairman. So you made a comment at the beginning that I just want to clear up. You said that if somebody posts a bond for somebody who is undocumented and they go to immigration services, that bondsman can get up the bond?
What I said was if the person is then taken into immigration custody.
How do they get off that bond then?
They offer the surrender.
Through what, a verification of incarceration?
Sometimes.
So I think the law was changed 2 sessions ago. That's completely inaccurate, just so you know. You can't get off. For somebody's been placed in immigration custody, it is specifically in statute that you cannot surrender your bond because of that, just so you know.
Yes, sir, I know.
Any other questions for Judge Fields? All right, Judge Fields, I just wanted to clarify one thing. You said that the bill gives consistency. Were you talking about as drafted, or you think it should apply to both corporations and property?
I do think that it should apply to both corporations and property bondsmen. There are some things that can be cleaned up, but they're minor.
Great. Thank you for your testimony. Thank you for being here.
Thank you.
All right, is there anyone else here that would like to testify on House Bill 227? Hearing none, testimony is closed. The chair recognizes Representative Johnson of Harris County to close on the bill.
Thank you very much, Chairman. And I wrote down a lot when Mr. Good was talking. I think there are a couple of keys here. He talked about surety, personal bond, a cash bond, and talked about the no-show rate. It's not the no-show rate, it's the reoffend rate. And it's the fact that this industry, like it or not, makes a profit the more you reoffend. If you have 3 or 4 cases and you make 3 or 4 bonds, that's additional profit every time they come in. And the question here is about public safety. I will give it to us. I think we have to have robust, tough discussions about where we want to go on public safety and bail. I'm proposing this piece of legislation to deal with the fact that right now, our system creates a public-private partnership by which there are private corporations that can make a profit off of making a decision on when to get somebody out. It doesn't sound like a couple of the people that came in and talked about notifying and calling and getting them to come back are the ones that we're talking about that were the problem, that would say, well, if it's a friend of mine, I'm just going to get him out, or I'm going to supersede the judgment of the judge. But we did hear the statement about the economy and then making a decision about working with families at different time in the economy. That's the point. We don't want the for-profit bail bond industry to make a decision about their business model and the economy that supersedes the judgment of the judge in the actual case. And that is why I'm asking for the stability for the court and for the judge's decision to mean something. I also have noticed the last 2 times I've been with Mr. Garza, he always says, it's the judges, it's the judges, it's the judges. I am glad you got to hear 2 judges, one of which said he's retired now, been on the bench for a long time. But I'm glad you got to hear those Harris County judges and see the way they do things. They are professional, they follow the laws that we give them, and they are not responsible for whether or not crime is being prosecuted. Continuing to blame the judges about a crime wave in Harris County is like blaming the referee for Altuve being in a slump. They don't prosecute the cases. They don't bring them to trial on time. And you've heard them talk about the fact, I can set a no bond, but nobody is ready to try these cases at day 61. And so we're back in the same issue. I am glad that we are having an honest conversation about the entities and the manner in which we infect it. And I'm also glad to tell you this is one piece and this is on this bill, but I'm also pushing for courts because we want to undo the backlog. This is a holistic approach around criminal justice reform, and I do think that this is an important part and would appreciate your favorable consideration of this bill.
Any questions for Representative Johnson? We have Representative Bowers, and then we'll come back to Morris.
Thank you, Mr. Chairman. Thank you, Representative Johnson. And I missed some of your layout due to another committee running simultaneously. So I've got a few questions, and just for you to try to catch me up a bit. How will this bill affect pretrial detention?
So I passed out a sheet that talks about a stair-step level. I've heard some folks say that look, if you do this, more people are going to be detained. What this is intended to do, because I don't want more people being detained. I want people to get in the system and get out. That's why I want to open the system on the other side. What I do want is the consistency for the court to know who might be released and who might not be released. And if you get to a point where folks are not able to make the 10%, which is the expectation, $1,000 on a $10,000 bond, then the judge can always set the bond at $2,000 and make it $200. And so again, it comes back to the judge can make the decision about where the bonds need to be to stabilize the system on where we are in pretrial. As was mentioned earlier, there are a lot of folks that are out. There are a lot of folks that are out despite the fact that the bond numbers have increased significantly over the last 4 years. That tells you part of the problem, that the judges placing a high bond is not keeping anybody in jail. And they also spoke out of both sides and said, everybody's getting out, but then said, but the sheriff is asking for millions more dollars to hold people. Those are inconsistent statements. we need to deal with that issue. But if there's a concern about people not being able to be in, that's why you pick an amount of money that they can make. And that's one of the questions to the judge. What can you make? The judge can't control, clearly, if a bail bondsman decides to cut a deal with a friend.
Thank you. And so the next question is, do you anticipate, and I think I heard a little bit about this from your last witness, but do you anticipate an increase in cost for defendants or an increase in risk for surety companies? And I think he was speaking to that right when I walked back in.
So the increase in cost would only be going back to what I think Judge Guido at one point said from having been around the system for 17 years. It's just what in the back of my mind, it's the norm. We all have believed in Harris County that the norm was 10%, and most people followed that. So if you put a $20,000 bond on somebody, you are anticipating the family's going to have to come up with, and they will lose $2,000. That sets that level. And again, that's the same for the families. The issue is where you have somebody that has a $20,000 bond and they'll say, I'll start making payment plans. And I'll tell you, Chairman Darby, one of the things I've seen is when folks aren't paying their bill, they're also not answering the phone. And you can surrender and say, I've lost touch with them. So you can have other reasons of why when somebody is no longer participating.
Rob, one more question, please. So with not all communities being equal, do you anticipate that this bill will limit access to surety bonds, and how will it impact low-income communities?
So again, it goes down to the judge in the county. If you're a judge in a different county, a different situation from Harris County, all the judges get to set. The only thing that I'm asking for your consideration is having a floor of consistency of 10%. So that if a judge in a county wants to set $1,000 bail on third-degree evadings in a small county, again, that's only $100 that would be required to be the skin in the game on that amount through a surety. So this all goes back to the judge. If the judge and the sureties don't believe that the county can afford $10,000, then drop it to $5,000, drop it to $2,000. That's the beauty of if we keep this system, the judge controls the dollar amount, not the corporation that can decide some folks get to do a payment plan, others don't. That happens to be a friend of mine.
Thank you.
You're welcome.
Representative Morales, and then we'll go with Chairman Canales.
Thank you so much. I've learned so much being on this committee. So we both live in Harris County, and crime is an issue. Is the overall goal of this bill to reduce crime?
Yes.
Because I haven't seen anything that we've talked about today that shows me where this will reduce crime, especially when someone mentioned earlier that this 10% rule is already in place in Harris County. So I would like to see data that shows how this would reduce crime. And then in the case of Mr. Castro, I don't feel 100% that this would have helped his situation. So that person was able to come up with a certain percent of, whatever they paid the bondsman. But had the bondsman said, you have to give the 10%, I feel like there could have been a way that he still could have gotten the $35,000 and been free. So I haven't seen anything that shows where this is going to help reduce crime, and that's what I would like to hear.
If you'll help me make sure I answer all the questions. First off, I've seen a human trafficker given a $100,000 bond and walk in and pay cash. So money, just as was said, I think by Judge Fields, money bonds don't make you safer. There is a conversation, I think, for us to have about how do you set this up and how do you set things to make it safe. But in the system we are in now, which we have created and we continue to enable, this public-private partnership between for-profit companies that have the ability to go unlock the door to the jail based on what somebody gives them and let somebody out, then you have to determine how do we make this work holistically. As I mentioned, not on this bill, but I have a bill for more courts in Harris County. Commissioner's Court has now approved additional courts in Harris County. We haven't gotten we got one new criminal court in the last 40 years in Harris County last year. We've gone from 2.5 million people to 4.5 million people. We literally do not have enough courtrooms and judges and folks to prosecute the cases. That is an overall infrastructure issue, and we've got to deal with that issue. Back to this, my question would be, and this was one of the frustrating things when you asked Mr. Good about data. How do they not have data, right? That's one of the issues in the committee substitute is the request for transparency. So that if they make the bond and they say, I made a $75,000 bond, that they also say of which $7,500 of that was paid on behalf of the defendant. That would answer your question about Mr. Castro saying, we don't know how he came up with $350,000, but we hear. This would actually provide some transparency to tell you what each bail bondsman is actually taking from the party that's supposed to have skin in the game, or are they giving them a pass and saying that's a friend of mine? That is one element of this bill so that you can look at the information in the public filing and know exactly what was in there. My thing is like on one of the cases that I gave you where somebody was in jail and was asking for their buddies to go get them out. And as he said, hey, the harder this gets, the more family gets involved. That's not my experience. The harder this gets, the more you just hang out with your hardened criminal buddies. And that's what happened in that case. On a jail call and saying, do me a favor, if you can come up with some cash, this particular bail bondsman will get me out. My belief, anecdotally, is that when all I have to do is come up with $250 or $500 cash, that's a quick, money-rich crime. That's a burglary of a habitation to go pawn a bunch of property, or that's pulling a gun on somebody at an ATM. It's a lot easier for a buddy to come up with $250 than it is for $5,000. I have heard it on those calls. Usually by the time that you collect that money, you got other stuff you got to take care of. But I do believe that what we're seeing on reoffending, and one of those articles notes it, the majority of the people that are reoffending are not on judges' release bonds. They're on surety bonds. And the surety bond, if you look at their business model, the more times they reoffend, the more notes they get to write, the more profit margin they get to bring in their processing fee. Maybe that's not right. Maybe we have to totally relook at it and figure this out. But that's anecdotally what I see having been in the criminal justice system, and part of the things that are frustrating me and why I'm glad we are having this very complex conversation about what do we want to do to try to rein this in. Thank you.
Chairman Canales.
Thank you for your passion and your interest. So the judge gets to set the bond, correct?
Correct.
And he can set cash bond?
Set the bond, and then either somebody could pay cash if they have that cash, but if they don't have that cash, as you know, they can go to a bail bondsman who will say, pay me a fee and I'll put up the rest of your cash.
Have you ever seen a bond that says $100,000 cash only?
I have.
So the judge can demand it's cash only then?
No, I'm sorry. I've seen somebody pay $100,000 personally in cash.
You've never seen a bond that says it's $100,000 cash bond? The judge can't determine whether it's cash or surety?
I guess they can.
Well, I'm telling you, I have. So,
Okay.
So that's one. So the judge can tell you it has to be a cash bond.
Okay.
100%. You need to put it up, or it can be a surety bond. But the judge can also do exactly what you're saying. And you may not see it. It may not be a frequent practice, but I'll tell you that a judge can tell you that the bondsman has to verify with the court that that person paid the 10%. And you may not have seen it, but I have.
Okay.
So I just want to bring that to your attention. It may not be a common practice. Maybe we need to educate judges. Maybe some judges don't know they can do it. But the reality is your concern is well within the discretion of any court to set a bond to say you need the bondsman or the surety that bails you out has to verify with this court that they have received it. And all those people have licenses, and if it's verified that they lied, they're done with their business. So I just wanted to bring that to your attention because I've personally seen a judge do that.
I appreciate it. I would appreciate your help if that is something that can fix it, if that is something that's different in Harris County. All I can say is when we've gone through Harris County and the bail bond board, this was the issue and why Senator Whitmire and I went to them about 10 months ago to say, look, we're hearing 1% and 2% from some folks and we want stability.
I would just leave you with the thought that if you look at the code and what a judge, he can put an ankle monitor on you, put you in home arrest, make you breathe into a breathalyzer. He can set it cash. He can set it surety. He can verify that the bondsman paid. I'm just telling you that I think that whether in the event that somehow your bill does not make it, I would tell you that there's ways to fix what your problem is.
Thank you, Chairman.
Any other questions for Ms. Johnson? I just had one. What does the author say about the issue of whether or not it should apply to all, like with property top bondsman versus the surety?
So when we put in the request for corporate surety, I understand that if they wanted to apply across the board to those other entities that do property, what we were trying to avoid was our charitable bail. And we were trying not to have charitable bail caught up in something else because they usually pay the full cash amount. And so we were trying to draw a distinction between what we created last session on charitable bail and what is traditionally considered as a surety or corporate or property bail.
So your intention is not to judge the people that are pledging their property differently than the insurance companies?
Our intention is if somebody is willing to go out and open the door without the full amount of cash and is taking a shorter percentage, that they be consistent and that they all, whether it's property or corporate insurance, as was described, that they at least require that the party put 10% skin in the game and not do payment plans of $250 at a time, which in my belief can lead to get rich quick, aggravated robberies at an ATM to get your buddy out.
It seems like the way it's drafted, it's just replying just to the corporations, which are generally going to be more the insurance companies than the local property bondsmen. I guess the numbers that somebody said for Harris County was 17 are property and 55 licenses for corporate. So, but it is correct that your bill currently would only apply to those 55 insurance companies. Is that how you intend it?
That's not how I intended, but if that's his belief and Mr. Good wants me to work on it or make that change, I'm happy to talk about it. No matter what it is, the corporation that's putting down the money, we don't want them to do payment plans that incentivize quick, get cash quick criminal acts.
Yeah, and I certainly don't have any bail bond experience. So, but I'm just saying the way I read it is it says corporations, and so corporations would be the insurance companies. A lot of these local people that use their balance sheet and show I have this much property, I have $1 million, I can write $10 million. That person generally is not going to be a corporation.
Our presumption on the corporate surety was that it would cover both. If they don't believe that it does cover both, I'm happy to talk to them about it.
Perfect. Thank you, Ms. Johnson. Any other questions for Rep. Johnson?
Thank you.
Thank you. Close.
Thanks. I close. Ask your favorable consideration.
Thank you, ma'am. All right, is there anyone else? Any other questions? If not, the committee substitute for House Bill 227 is withdrawn, and if there's no objection to House Bill 227, it will be left pending. Is there any objection? Chair hears none. Therefore, House Bill 227 is left pending.
Chair lays out HB 1709 and recognizes Chairman Canales to explain the measure.
Thank you, Chair, Vice Chair. This is a very simple bill. It basically says if there's a...
We've heard that before, sir.
No, this gets real simple. This one's real simple, I promise you. Is if there's an order or a judgment from a magistrate, there needs to be something that lets me know which magistrate signed that. We've already passed a version of this with search warrants in the county where I live. There was rogue police officers running around with search warrants with just a scribble on them. They were not real search warrants going into homes. And basically, at the end of the day, if a judge signs something, it should have their name. Judges are much like attorneys and doctors and myself. You can't read my signature if you wanted to. So nobody knows who the heck signed it. And so all this is saying is if there's a valid order, the judge should at the very least have their name on the bottom of it so we know who the controlling authority that issued the order is. That's it.
Thank you. Members, do you have any questions? No? Okay. We do have let's see, Rick Thompson. Okay.
Right.
You may correct that.
I'm sorry, which bill is this?
This is 1709 relating to a special bill of review to reform a final judgment. Oh, okay, here's what we did. Okay. You're right. Hey, Terry, come back up.
You asked for 1709?
Yeah, I apologize. Yeah, we've got two of your bills, so it means your layout on the next one's going to be really short because we've
This
already
isn't
heard
even a
it.
more simple bill. I'm just kidding.
So let's reset.
Apologize.
No, it's okay. 1709, knowing that the description you gave before was not 1709.
It was an incorrect.
But now you're going to give us a correct.
Yes, sir. So I will give you the description.
What happens when you have so many good, simple bills?
Yeah, no, this is what happens when you've been up since 5 in the morning. So 1709 basically falls in line, but special bills of review under the Texas Rules of Civil Procedure are 4 years. When they apply to bail bondsmen on the special bill reviews, they are brought to 2 years. And all this does is bring them in line with the 4-year statute. I guess you could say limitations to bringing a bill of review. It just brings it in line. There's no reason why they should be at 2 years and not 4 years. And so every other civil case says it's 4 years. And so this just says we're going to bring them in line. I don't know where along the line it became 2 years, but it just brings them in line with the rest of the code.
Okay. Members, do you have any questions for Chairman Canales before he gets away? No? Okay. Now, Chair calls Rick Thompson. Sorry for that confusion. I have you registered as Rick Thompson, representing the County Judges and Commissioners Association of Texas in opposition to House Bill 1709. Is that correct?
Yes, sir.
Okay, go ahead and proceed with your testimony.
Good afternoon. I'm Rick Thompson with the County Judge and Commissioners.
That's it. Sorry.
This is tough enough, okay?
It's a long. Look, we're trying to get things moving here. No, sure. Go ahead. Sorry.
We believe current law serves as a good motivator for bondsmen to protect their investment and collect those absconders. Increasing that grace period from 2 years to 4 years lessens their incentive and creates some additional opportunities for those folks to reoffend. So, thank you. I'll be happy to try to answer any questions.
Rick, thank you very much. Members, do we have any questions? No? All right. Thank you, sir. Is there anyone else wishing to testify on for or against House Bill 1709? The chair sees none. We'll recognize Mr. Canales to close on the measure. All right. Thank you, Representative. If there's no objection, HB 1709 will be left pending. Is there objection? Chair hears none, and HB 1709 is left pending at this time. This time, Chair lays out House Bill 1712, which I've heard about before.
Yeah, you have. It's like Groundhog Day.
Recognizes Mr. Canales to explain the measure.
Once again, here's the rerun. So this bill basically makes sure that a magistrate's name is on whatever order, so we know who the heck signed it.
Okay. Sit tight real quick. Is there anyone present wishing to testify on for or against House Bill 1712? Chair sees none. Recognizes Mr. Canales to close on the measure.
Close.
All right. Members, if there's no objection, House Bill 1712 will be left pending. Is there objection? Chair hears none, and House Bill 1712 is left pending at this time. Chair lays out House Bill 2306 and recognizes Mr. Hefner to explain the bill. Now, Mr. Hefner, you also have two bills in the committee today, so take a look at the bill book before you start. House Bill 2306 is the one that we have in front of us right now.
2306. Thank you, Mr. Chairman. I appreciate that Mr. on the Hefner part there. Thank you all for hearing my bill today. I'll be brief here. This bill aims to update Texas voyeurism laws, otherwise known as the Peeping Tom Law, to tackle offenses only made possible by modern technology. Had a constituent of mine that came to me with a story that as a father kind of disturbed me a little bit. A drone with a camera was seen flying real low over his backyard, spying on his daughter, actually his granddaughter. They followed the drone back to the owners of the drone's home, and it turns out this guy was listed as a registered sex offender. And so while we can connect the dots on the offender's intentions, the worst part about the story is not really what happened, but that he was also able to get away with it because our Peeping Tom laws are not updated to our current technology. House Bill 2306 aims to correct this loophole by making it clear that the offense of voyeurism can be committed with the assistance of electronic devices. My bill does not touch burdens of proof. It only provides clarification. As a result, no matter if the actor is hiding in a tree, or using a drone, or using a hidden camera, or any other method using technology that both currently exist or is yet to exist, if it can be proven that the person has committed voyeurism. Offenses like what happened here don't need to go unpunished, and we want to make sure we crack down on this stuff. So with that, I'd be happy to answer any questions and reserve the right to close.
Thank you, Mr. Hefner. Members who have questions? No? All right, let me just hang out real quick. Let's see, is there anyone wishing to testify on, for, or against House Bill 2306 at this time? Chair sees none, and so I recognize Mr. Hefner to close on the measure.
Thank you, Mr. Chairman. I close.
If there's no objection, House Bill 2306 will be left pending. Is there objection? Chair hears none, and House Bill 2306 is left pending at this time. Chair lays out House Bill 3659 by Representative Hefner. Chair lays out a committee. Chair offers up a committee substitute to House Bill 3659 and recognizes Mr. Hefner to explain the bill and the changes made in the substitute.
Thank you, Mr. Chairman and members. Thank you all for hearing this bill also. The committee substitute to 3659 will provide needed transparency and reform to civil asset forfeiture, a procedure that, while necessary, can be abused. While state agencies are already required to submit reports to the Attorney General's office, they're only required to do so yearly. And the Attorney General only posts aggregate amounts, meaning citizens cannot see how much their local individual law enforcement agency has seized throughout the year. My bill will correct this by requiring both monthly reporting and requiring that the AG's office publish both aggregate amounts and the amounts seized by individual agencies. Law enforcement agencies already track and report what we're requiring in this bill to the AG. The only new requirement is a number of how many cases were challenged or how many were just signed over. They will simply have to do it monthly instead of yearly, and the AG must make all details public, not just aggregates. Though the personal information of law enforcement officers involved will not be made public. On top of the new transparency requirements, my bill also requires that in order for property to be seized, it must be worth at least $2,500, not including money used for a sting operation. The bill also requires that the burden of the state to prove the asset in question is related to a crime must now be satisfied with clear and convincing evidence instead of a preponderance of the evidence. As Chairman Moody mentioned, there is a committee substitute to 3659. The original bill had a floor of $5,000, and after talking with some of my local law enforcement, we lowered that threshold to $2,500 and added a provision ensuring that repossession of money used in a drug buy sting operation is not subject to the floor. And so by taking these steps, we feel we will make significant progress in both curtailing civil asset forfeiture abuse and increasing transparency in the act. So thank you all for your time, and I'd be happy to answer any questions. Reserve the right to close.
No, thank you, Mr. Hefner. I know you've been working with stakeholders for quite some time.
Yes, sir.
On this issue throughout the interim as we headed into session. So I know that's why it took a while to get all the pieces put together to file, but thanks for doing your best to get everybody together. It's an important issue. Members, do we have any questions? Okay, we do have a couple witnesses on this. Chair calls Sergeant James Smith. Sergeant, I have you registered as James Smith, representing yourself and the San Antonio Police Department in opposition to House Bill 3659. Is that correct?
Yeah, that is correct. And thank you, Mr. Chairman, rest of committee members. I know it's been a long day and you still have a lot more to go. But as I said, yes, I represent San Antonio Police Department. I've served almost 30 years in that capacity and almost over 15 years as the asset forfeiture sergeant. I have to humbly respectfully oppose this bill as part of the department because I don't agree with the premise that asset forfeiture is broken. Chapter 59 has been vetted over the years, and there's always been tweaks to it. This is a very drastic change to Chapter 59. I feel very rest assured that knowing my counterparts, not only San Antonio Police Department, but other agencies throughout the state are doing things the correct way. The AG can get into our business at any time they want, and there's also penalties, criminal and civil, against officers if they're doing something the incorrect way. But what this does, this bill, I know I'm going to run out of time, but even with the dollar threshold, one of the things we do in Bexar County in conjunction with the Bexar County DA's office and with our police department, one of the most important aspects of forfeitures is that we can seize vehicles on the 4th DWI. If they have 3 prior convictions anywhere within the country, we can file on that 4th one. What we do not put a dollar amount on that car. If that car is wrecked, it has 0 value, up to $2,500, and a lot of these DWI vehicles, they're junk because they can't get insurance and they have to get these cheap cars. But from my perspective, from the city's perspective, and the DA's perspective, we have to take those criminal instruments off the street. These people are going to continuously drive those vehicles. We don't have that ability. If that car is worth $500, the way this law is written, even with the substitute, that's going to eliminate us from seizing those cars. What if those cars are used in burglary habitations? Those cars are used in a burglary of buildings. They're used for trafficking. A lot of these cars aren't very expensive. I just don't see where this fix is needed. Things aren't broken. There are going to be one-offs. We all know that. We can't legislate every bad behavior out there, but people are doing things the correct way. When it comes to that report, I handed y'all what our annual report does look like that the representative alluded to. If you have to have this every month, it's going to create a administrative burden from our perspective, even as a large department, but let alone trying to get that data, because there's a lot of extra things in there that would have to be reported every month. And operationally, and I believe there would be a fiscal impact. I don't know what that would be at the AG's office. I don't know if they have the individuals available to review these documents. I just don't hear about the issue of transparency being a problem, and let alone the whole asset forfeiture laws. Back to clear and convincing, we've had that argument in other legislation up here. It's not needed. Once again, not broken, one-offs every once in a while. I don't hear about them anymore, but clear and convincing, there's only 2 cases I know in civil law where it's used. And I'm not an attorney, that's in patent law and also that of child custody. But once again, I go back, I apologize.
That's all right. Go ahead. No, go ahead, finish your thought.
No, and I believe I already said it once, I just don't feel the system's broken. Good law. I'll answer any questions anybody might have, and I know it's late, so I don't anticipate any.
Oh, it's not late yet, Sergeant. No, I appreciate your testimony. I usually try to encourage folks to sit down and work through issues. To me, it sounds like kind of categorically you don't think there needs to be any work done in this arena, which is fine. And I'm not here to tell you otherwise. That's your opinion, and I'm happy. Is there space? You think there's space to talk through any changes with the author?
Especially on the dollar amount. I mean, everything that we seize, what it says in here, we're not able to seize it if it has an aggregate value of less than $2,500. We already heard some testimony in here today. It's those small dealers that we're getting out there. And we have a $1,000 threshold with the county. It's an informal agreement. Well, it's a formal agreement because by the time you publicize, by the time you...
it's not worth it.
Yeah, the process serving, and that's just an in-house, but we can still file on it, just like I said.
Bexar County they kind of informally worked with law enforcement inside the county to say, look, we're not going to pursue these if you bring them, so no need to bring them, essentially. Is that how that happened?
If it's $1,000 or less, because the process serving, other issues may end up costing more money, other than, like I said, the vehicles. If it's wrapped around a pole, a tree or something like that, we're filing on those DWIs. And I think that's essential. That's saving lives out there. Yeah. I don't know how to quantify it, but it's definitely saving lives getting those vehicles off the road. And with the fentanyl crisis going on, every little bit, we get comfortable and we forget how big the cartels are. Just for example, I always like throwing the stat out. The Sinaloa cartel itself has more employees than Apple and Google combined. I mean, it's out of control. They spend over $1 billion just on bribes every year. And it's just, this is not the time. This is the time I think we need to even strengthen forfeiture laws. I like what's being done on some of the street racing, things like that. And that's another area. A lot of these cars may not hit that threshold, but those people are being very, very dangerous out there, and lives are going to be killed. But if we still have that $2,500 threshold, we're not going to be able to take a lot of those cars and get them off the street.
All right. And Sergeant, I appreciate, thank you for letting us know what you're seeing out there and offering your opinion on the matter. Members, do you have any questions for the Sergeant?
If I could.
Yes, sir.
It always comes back to about protecting innocent owners. We do that every day, and I know my counterparts do the same thing in here. I can tell you of a case just yesterday. The drug dealer in his room had $10,000 in change, and money was taken also from a roommate. I returned that money immediately because she had nothing to do with it. The officer, out in the field, put them together, but we separated and we protected her innocent owner rights. We do that every day. Same thing with cars, innocent owners there, lien holders and such. But we take that level very, very high to protect innocent owner property rights.
Thank you, Sergeant.
Thank you all.
Appreciate your time. Chair calls Derek Cohen. Derek, I've got you registered as Derek Cohen, representing the Texas Public Policy Foundation in support of House Bill 3659. Is that all correct?
That is correct, sir.
All right, go ahead and begin your testimony.
Excellent. Thank you, Mr. Chairman. We appreciate the work done by this committee as well as the work done by the subcommittee that has been appointed to look at this issue as well. I do appreciate Representative Hefner bringing forth this bill, HB 3659, because of that, it's a good incremental step towards some of the other ideas that have been floated, again, both in this committee in sessions past, as well as the subcommittee in this current session. So while nobody will disagree that the actual fruits of criminal activity should be taken away from the bad guys, we're not even discussing that here. That's one of the problems. What we're discussing is a mere suggestion of a criminal activity that need only exist in a civil document. Oftentimes, that's just enough to get these procedures started, and then we actually see that those particular things run costly legal bills. We're not even talking here about what this money is spent on. There is a modicum of transparency in that regard. You always hear the horror stories. I think it's like 30 years ago now about the margarita machines. But we have cases within the last 5 years of, $700,000 on laptop bags. These are not law enforcement expenses, and this is something that we should look at as well. So how much civil asset forfeiture is happening in Texas? Well, honestly, without this bill, there's really no way to say. Are we talking we have $34 million, but is 5% of that pursuant to a criminal charge? Is 95% of that pursuant to a criminal charge? We simply can't say without that granular transparency as as seen in this bill. You are going to hear several things, maybe have already, that kind of distract from the practice of forfeiture. The first is that you can't forfeit property without a criminal charge. Obviously, that is not the case. All you need is an allegation of a criminal nexus within that civil document. Any reform would ban law enforcement from seizing legitimate evidence. This comes from conflating seizure and forfeiture. Obviously, grabbing evidence, even grabbing contraband per se, is governed by not only this, but other forms of other places within the Code of Criminal Procedure. You'll hear that sometimes this would somehow contradict the ability to interdict with the cartels or stop fentanyl. And simply, that is just not the case. We have the current issues with the cartels and fentanyl under the status quo. Also, and when you have to, say, unwilling mules, what are we going to do if they have money in a truck or what have you? We obviously have many abandoned property laws that would apply to that as well. This is a bill that's so popular. Both parties have it in their platform. I think that the addition in here of what was $5,000 and a $2,500 floor is going to stop some of the more pernicious pocket change abuses from happening. But overall, I think this bill represents a really good step in the right direction.
All right, Derek, thank you very much. Members, you have a question for Derek? All right, thank you so much.
Anytime.
Appreciate it. This is obviously a conversation we've been having for some time. Is there anyone else wishing to testify on for or against House Bill 3659 at this time? Chair sees none. Recognize Mr. Hefner to close on the measure.
Thank you, Mr. Chairman. I'm just going to close.
Okay. I appreciate your time. I know you've been working on this. Obviously, you know, encourage you to continue to work with
Yes, sir. I know you and I
partners
work
in law
together on-
enforcement, and I mean, that's really what that's the balancing act you got to do when you're working on this stuff. So.
Yeah, I think, I think most of our law enforcement guys are doing things the right way, and we want to get the ones that may not be doing it right and not hurt the ones that are doing it right. And I appreciate your help on this issue as well. And
yes, sir.
Look forward to moving
Members,
it
do you have
forward.
questions for Mr. Hefner before we let him go? No. All right.
Thank you all.
Let's see. Committee substitute to House Bill 3659 is withdrawn at this time. And if there's no objection, House Bill 3659 will be left pending. Is there objection? The chair hears none. House Bill 3659 is left pending. Wow. We've moved quickly. Do you want to do this one? Chairman Herrero had an emergency he had to attend to, so we hope everything's okay with that. But he did have a bill he asked us to hear, and so I'm going to have Chairman Leach lay that out for him. Let's see. The chair lays out House Bill 3260 by Chairman Herrero and recognizes Chairman Leach to explain the measure.
Thank you, Chairman. It's my honor, and Vice Chair as well, it's my honor to lay this bill out on behalf of Chairman Herrero today. This is House Bill 3260. Members, this bill will allow a statutory county court to order the expunction of arrest records for eligible individuals acquitted of a crime disposed in their court. Current law allows individuals eligible for an expunction whose case was disposed in a district justice or municipal court to petition for an expunction in the court that handled their case. However, currently, an individual eligible for an expunction whose case was heard in a statutory county court can only petition for that expunction in a district court, leading to undue, unnecessary delay and expense for individuals trying to move on, rebuild their lives after criminal justice system involvement. House Bill 3260 by Chairman Herrero seeks to help individuals acquitted of criminal charges in a statutory county court to avoid the burden of approaching a new court and a judge to petition for an expunction. And with that, Mr. Chair, I'll reserve the right to close on behalf of Chairman Herrero.
And would you like to field questions on Mr. Herrero's bill, or no?
I can certainly try. If you want me to.
No, we do have a witness that's here to testify. No, thank you, Chairman Leach. I appreciate you doing that. We know that those things come up from time to time. Chair calls Sarah Mae Jennings. Sarah Mae Jennings. Okay, all right, that's fair. We're going to change her to not testifying. Is there anyone else wishing to testify on, for, or against House Bill 3260? The chair sees none and recognizes Chairman Leach to close on the bill.
Thank you, Mr. Chairman. Close.
Thanks, Jeff. If there's no objection, House Bill 3260 will be left pending at this time. Is there objection? The chair hears none. House Bill 3260 is left pending. This time, Chair lays out House Bill 2055 by Representative Venton Jones and recognizes Mr. Jones to explain the measure.
All right.
This isn't your first bill layout, is it?
This is my first bill layout.
Glad I asked. No, go ahead.
Well, thank you, Chairman Moody, Vice Chair Cook, as well as the members of this esteemed committee. Before I begin, I would like to thank you, Chair Moody, for being a joint author on this important piece of legislation. This is a cleanup bill that would strike the unconstitutional language from Section 21.06 of the Penal Code put in place in 1973. Simply put, everyone deserves equal treatment in the eyes of the law without fear of discrimination or harassment. HB 2055 would finally bring our statutes in line with the Supreme Court decision in the case of Lawrence v. Texas by eliminating those sections that exist within our current state law. Lawrence v. Texas is a 2003 landmark decision of the U.S. Supreme Court in which the court rules that most sanctions of criminal punishment for consensual adult non-procreative sexual activity, commonly referred to as sodomy laws, are unconstitutional. Ever since the Lawrence v. Texas ruling, because of current Texas state law, Texans are still being harassed and discriminated against. Being a part of the LGBTQ community is not a crime. It is unconstitutional, and there is no reason for the statute to linger in our penal code. Simply put, everyone in the state of Texas should be afforded equal treatment. It is time to remove these laws and provide equal rights and protections for all Texans. After 50 years, it is time to remove the language and do away with discrimination. And members, before I close, I want to say that I don't feel that this bill should be controversial. I don't believe that you or any members on this panel should be arrested for being with the person that you love. I don't believe that you should be punished for being able to show love to your spouse. I don't believe that your entire existence should be criminalized, whether you are gay or straight. With that being said, I ask all of you, why is it okay for me to face arrest or my community to face arrest and be deprived from the people that I love, that we love, and that our existence can be criminalized? Thank you so much, and I believe we do have witnesses that are testifying, and I do reserve the right to close.
Yes, sir. We do have some witnesses. Mr. Jones, I do want to I appreciate you allowing me to join author your bill. This is an effort that I have authored myself, but certainly I think your voice is incredibly important in this conversation, so I'm proud to be a joint author on your bill. Members, do you have any questions on this bill? Save them for later? Okay. All right. We'll get to the public testimony then.
Thank you so much.
Chair calls Megan, is it?
It's Behoon.
Behoon? Okay.
Deceptively simple, just like it's.
Great. Megan Behoon, that's how I have you registered, and I have you registered on behalf of yourself for House Bill 2055. Is that all correct?
That is correct.
Great. Go ahead and begin your testimony. Thank you.
Thank you, and good afternoon, Chair and committee members. My name is Megan Behoon, and I'm here today to speak in favor of House Bill 2055, which seeks to remove unconstitutional language from Texas Penal Code. As a queer Texan, this section of Texas Penal Code has been a constant fixture of confusion, difficulty, and frankly, wasted time. I am old enough that I had this section of code wielded against me for simply existing in public with my girlfriend. Even when the language was in effect, it caused confusion and misunderstanding. I received citations in Georgetown, Texas, for simply walking down the street holding her hand. The Lawrence decision brought some relief as it declared this section unconstitutional. But that was not the end of the confusion experienced by police officers, county officials, schools, and due to this continuing confusion, the general public in my day-to-day life. Because this section simply has a small notation that has declared it unconstitutional, many people do not understand that this section is not applicable Texas law. I have experienced clerks, police officers, school officials believing they were enforcing Texas law, slowing the works and causing additional expenditures of public funds through hours spent gaining access to things as simple as forms at a public school. This spends valuable, limited public resources on upholding outdated and unenforceable language that does not meet our need as Texans. As I mentioned, this reaches out to everyday Texans who cite this section of penal code when seeking to explain to me that my family simply living in the neighborhood is a crime in Texas. I have had well-intended landlords who said they just didn't want to risk a crime being committed on the property, citing this section as recently as 2019. We are more than 20 years from this section of Texas Penal Code being deemed unenforceable. Justice Kennedy stated in the decision that Texas statute furthers no legitimate state interest which can justify this intrusion into personal and private life of the individual. That was true in 2003 and remains true in 2023. It is long past time to remove this language from the Texas Penal Code to protect Texans and reduce the confusion and waste caused by this outdated language. Thank you.
Megan, thank you. I can say from experience in El Paso, our city faced a lawsuit over the confusion and misapplication of this, and where they had to go through at cost to city taxpayers, training of all law enforcement about why this shouldn't be enforced. So I know some of the other witnesses might testify on that or remember that instance, but this is not like to your point, it's not theoretical that this is happening and misapplication is happening. It is happening in multiple communities, and ultimately, because it's unconstitutional, that's going to be at taxpayer expense when it's done wrong, when it's done incorrectly. So that's something that we do need to consider. Members, do you have any questions? No? Thank you so much.
Thank you.
Chair calls Mary Elizabeth Castle. I have you registered as Mary Elizabeth Castle, representing Texas Values Action in opposition to House Bill 2055. Is that correct?
Yes, sir. That's
okay.
correct.
Go ahead and proceed with your
Good afternoon, Chairman Moody and members of the committee. My name is Mary Elizabeth Castle. I'm Director of Government Relations for Texas Values Action, and I'm testifying in opposition to 2055. Our main concern that we bring every year with this type of legislation is how it affects the Health and Safety Code, which has very important provisions on how we teach kids about sex. It has provisions about how in the Health and Safety Code we teach kids under 18 about the risk and dangers of engaging in homosexual activity. This would include information as the following. According to the CDC, gay, bisexual men who have sex with other men accounted for 83% of primary and secondary syphilis cases where sex partner was known in the United States. Gay, bisexual men and men who have sex with other men are 17 times more likely to get anal cancer than heterosexual men. Gay, bisexual men and men that have sex with other men have a higher chance of getting viral hepatitis, including hepatitis A, B, and C, which are diseases that affect the liver. And the list goes on. But the most important part is making sure that our kids have all the information that they need possible in order to make healthy decisions. And if we introduce this bill into law, then it would take away that very important information that they need to make advised choices, which includes in the Health and Safety Code also teaching that abstinence is the preferred choice. Thank you.
Chairman Leach.
Thank you. Thank you, Mary. Does Texas Values have a position? I honestly don't know the answer to this question. Does Texas Values have a position on whether or not an individual who engages in homosexual conduct should be classified as a criminal under Texas law?
So I'm not sure of that position, but of course our position is that that goes against the values of our organization of homosexual
I understand
conduct.
that there's differing values. There's differing thoughts. There's different faith perspectives on all of these issues. But my question is very, very pointed and simple. Does Texas Values believe that an individual who engages in homosexual conduct is a criminal and should be a criminal under Texas law?
So you know our organization for a long time because you're a faith and family champion with our organization.
Yes, proudly so.
And get 100 every year. So you understand that, we don't criminalize anyone, but we do have to say that as an organization, we do not stand for that behavior. But the main point of my testimony is that every time this law is introduced, it's not even about that. It's about the Health and Safety Code, which goes to the education parts and removing that important information for kids under the age of 18.
And Mary, I'm proud to work with you on a lot of bills this session, and I proudly have those awards that I've received from Texas Value on my shelf here in my office in the Capitol, and you do great work, and I'm proud to partner with you in that. I'd like an answer, and not only from you, but from other organizations or individuals that might oppose this, because I am searching for the right thing to do here. And when it comes to, and maybe I'm misunderstanding what the legislation does, but right now I believe that currently in Texas statute, those individuals are and can be criminally convicted. We're criminalizing by way of this old statute that is no longer constitutional, this activity. And the question that we need to ask ourselves is though we may disagree with it, and though we may have different views about relationships and marriage and sexuality, is this something that we want to criminalize in our state? And I would just like, you don't have to give it to me now. I'm not putting you on the spot. I'd like to get an answer to that.
Thank you, Chairman. I appreciate that. And let me do this because there's 4 sections to the bill. The first section is the repealer language of the penal code, and I didn't hear you. I'm trying to be very clear. Didn't hear you testify about anything related to Section 1.
Correct. Like I said, we don't deal with criminal law anyways, so that wouldn't be part of my testimony. Yeah.
Y'all have before. That's okay. We don't have to talk about that right now.
Yeah.
That's okay. Section 2 is the health and safety code provision. It says that it's talking about materials that are used in educational programs, and this is the current language. And it's a short bill, so let's just parse it out, because I think Chairman Leach asked a very important question. Let's kind of get down to it. The materials in the education programs intended for persons younger than 18 years of age must, and the way the bill works is it strikes the 1 because it strikes the entirety of Section 2. 1 would just read now, emphasize sexual abstinence before marriage and fidelity in marriage as the expected standard in terms of public health and the most effective ways to prevent HIV infection, sexually transmitted diseases, and unwanted pregnancies. The part that the bill would strike is, and state that homosexual conduct is not an acceptable lifestyle and is a criminal offense under Section 21.06 of the Penal Code. So that's Section 2. You said that is where your objection lies, and your objection also will lie in Section 3. We'll get to that in a second. So not that I'm going to rewrite the bill as we sit here, but if Mr. Jones would tweak this where the language state that homosexual conduct is not an acceptable lifestyle, period, in a sentence, because you'd have to eliminate the part that says and is a criminal offense under section. If you're doing the repealer criminal language, you'd have to strike that part because it no longer exists. There's no cross-reference. But let's say reinstate the other language, state that homosexual conduct is not an acceptable lifestyle, period. So let's say if we did that, let's go to Section 3, which is the instructional elements, and it's going to be the same language, right? The part that's being stricken from there is emphasis provided in a factual manner and from a public health perspective that homosexuality is not a lifestyle acceptable to the general public and that homosexual conduct is a criminal offense under Section 21.06 of the Penal Code. Again, if all the language is reinstated except for that last part that is referring to the criminal law repealer, that's really the objection you're raising in your testimony, right? In the health section, because in Section 4 is just the implementation date. Section 1 is criminal repealer, Section 4 is implementation date. Section 2 and 3 is where you raise the objection. Am I understanding your testimony correct?
So yes, the gist of my testimony is that section, but even more importantly, like you said, Section 3, where we get to Part 8, where it says provide it in a factual manner and from a public health perspective. I mean, if this bill were simply just about not criminalizing it, and not trying to hide information or paint over the reality of these issues, then it would be a different, story. Maybe we wouldn't have to testify against this bill, but it deletes very important information about factual manner and from a public health perspective, which is very important.
And so those are, Section 2 and Section 3 are educational components referring to sex ed. And your testimony is, we'd prefer that language stay. You would agree with me, though, if we had the repealer criminal language, you would have to excise the part that says and is a criminal offense under the Penal Code. I mean, right, it wouldn't read correctly otherwise. Right. But the rest of the language is really the heart of your objection to this bill.
That's correct.
Okay. What I do want to drill down on this because I think it's the question that Chairman Leach is trying to get to is and again, we won't put you on the spot. I'd like to know if Mr. Jones comes back to us and says, we'll go back and tweak Section 2 and Section 3 based on your testimony today. Is it something, and I'm not asking for you to go and tell everybody vote for it. I'm just saying, would you be able to weigh in with this committee and say, our concerns about this bill have been addressed? Is that something you would be able to engage with us on?
I'm not sure. And then my question would also be, like, would that even be a possibility? I've testified against this bill 4 years running. So I don't know if that's a possibility to be workable. I think the intention is to go to the heart of the issue of the education part and to overall gloss over some of the concerns that we have in society about these behaviors that people just need to be aware of.
I've actually offered to redact this in prior sessions. And so this has been a conversation we've had. And maybe, I don't think particularly with you, so I don't want to.
Yeah,
say
probably
this
before I started.
with others, but I think, and I want to just, do Chairman Leach?
Yeah, I do want to, but I'll defer to you.
No, that's all right. That's kind of, I want to crystallize it because, like I said, this came to me from a very real world, taxpayer problem that we ran into with someone enforcing the criminal provisions that are no longer constitutional. So, on the educational front, that's a different, it certainly is a different discussion. Willing to hear you out on that. But, the core of the bill is really the repealer language, in my opinion. Now, of course, I don't want to speak for Mr. Jones, but that's what I'd like to get to if it's possible. Mm-hmm. And so understand and respect your opinion. You have every right, and there are going to be members that are going to be all over the place. And some people may not like that I would want to do that or be willing to do that. But it's something that I'm trying to drill down because we have talked about this for multiple sessions. And I do think I believe there's some consensus here. And so I want to figure out how we can get it there, But Chairman Leach.
Yeah, thank you, Mr. Chairman. I think that's well said, and I appreciate you diving into the specifics of the bill. And Mary, I want to reiterate to you and everyone that's here in the room, my fellow members and those listening online, I want to affirm you and your work. And I see Jonathan Covey in the room here, and I enjoy working with you. And in no way am I trying to put you on the spot. I am almost in a sense thinking and processing out loud here. I think that's why we have public hearings, is for us to find the right public policy. And I know Representative Jones wants a bill to pass, and so I think Chairman Moody puts this in perspective. There needs to be maybe some changes, some amendments for us to discuss. At the end of the day, one of the things I care a lot about, and I know other members on this committee do too, is the over-criminalization of our state. And I believe so strongly, and the longer I've been doing this, believe even more strongly that we have gotten really good in this state about criminalizing behaviors that we may just disagree with, about criminalizing people that we're mad at instead of people that we're afraid of. And I don't think that's the right course for this state. And in fact, we've done a number of things, Mr. Chair, over the last few sessions to retreat from that. And so I just want us to think deeply as legislators before we ultimately vote on this is let's be real careful. Let's be real careful and cautious and slow and prudent about picking and choosing activities that we might disagree with and deciding to criminalize those things in our state. Because once we go down that road, it's a real slippery slope that I don't think is good for our state. So let's just think deeply. I know we are. And Mary, I appreciate you answering our questions today.
Great, thank you.
Members, any other questions? No, thank you very much. I appreciate the conversation. Thank you so much. There we go. Chair calls Gary Schumann.
I'd like to thank everyone here for the opportunity to speak again. My name.
Let me just clarify real quick. I have you registered as Gary Schumann.
Correct.
Testifying on behalf of yourself and the Austin LGBT Chamber of Commerce in support of House Bill 2055. Is that correct?
That's correct.
All right, go ahead and proceed.
Again, I'm Gary Schumann. I'm the founder of the law firm Saverick Schumann Johnson McGarr with offices in Austin, Dallas, and Boulder, Colorado. I'm a founding member of the Austin LGBT Bar Association, and I've been involved in legal advocacy projects for years, and I've been here on this bill or its equivalent many times now. I'm currently the board chair of the Austin LGBT Chamber of Commerce. In 1973, Texas passed a law called the Homosexual Conduct Statute that essentially made homosexual conduct a crime, even between consenting adults, even in the privacy of one's own home. However, in 2003, the United States Supreme Court in the Lawrence case held that the Texas Homosexual Conduct Statute was unconstitutional. John Cornyn, who was the Attorney General at the time, refused to defend that statute on behalf of the state of Texas, and they had to get somebody from the district attorney's office in Harris County to go up to try to defend it. The Supreme Court in Lawrence said it could not be defended and held that the state of Texas has no legitimate state interest in this statute. But despite this statute being held unconstitutional over 20 years ago, this statute, this law, is still on our books. What House Bill 2055 does is take this unconstitutional law off the books. Why does this matter? I'm here in my capacity as the board chair of the Austin LGBT Chamber of Commerce. We have approximately 500 business members in Central Texas. We've certified here in Austin alone over 60 LGBT wholly owned businesses. These are law firms, dental practices, accounting firms, real estate agencies. We are supporting LGBT-owned businesses, and we help recruit businesses into the state of Texas. Having a law like this on our books, making homosexual conduct illegal, is an affront to those efforts. Right now, we're currently putting together a group to go to Ireland to help bring in international businesses into our state. How do I explain to them that Texas has a law on its books making what goes on in the privacy of one's home illegal? How do I explain that? It's an embarrassment. It is an embarrassment, and I'm tired of being embarrassed. It's been 20 years since the Supreme Court held that this law is unconstitutional, and I would beg y'all finally, please, after all these years of coming back, please vote this out of committee. Let's get this onto the floor, and let's finally have this discussed and debated. And the prior person testifying talked about health issues, and that's long been, the state interest is in health. The world has changed. Right now, it's called U equals U. If you're undetectable, you can't transmit HIV. People on HIV meds can't transmit HIV to anyone else. People who don't have HIV are on PrEP. It's pre-exposure prophylactic. It's a pill you take, and you can't get HIV. So my friends, people in my social circles, gay men, we're not worried about HIV anymore. We're not going to get HIV. Why? Because we know about this, and we're educated. Our community's educated. Wouldn't it be something if high school students, if college students, if people in the general public had this knowledge and had this information that they don't have to worry about getting AIDS anymore? Wouldn't that be something? Wouldn't it be great if we could talk about these sorts of things? Education is important. Having the statute reversed is important, so we can have these important communications and conversations that will save lives. Thank you all very much.
Thank you, Mr. Schuman. Members, do you have any questions before? No? Thank you, sir.
Okay, thank
you for your time. Chair calls Jonathan Covey. And sir, I have you registered as Jonathan Covey, representing Texas Values in opposition to House Bill 2055.
Yes, sir, Mr. Chairman. And I don't have a lot to add to what. That is a rather disturbing noise.
It's really jarring. You know, it belonged to Pub Ed. It belonged to Pub Ed before we stole it from them.
I think they played a trick on you.
Sorry.
No, Chairman Leach, I appreciate your heart, and Chair Moody, I wish we were on the same side on more issues because I really like you a lot, but I appreciate your heart as well. I wanted to just see if I could just kind of answer, some of the questions y'all are asking too. I don't know that organizationally we have a position on whether or not that you should have the criminal language in the code. From my understanding, Lawrence v. Texas, as well as I guess Obergefell, says that it's not illegal. Homosexual conduct, it's not illegal. So, and from my understanding, it's not it's not being enforced in Texas, even though I understand from what previous testimony said, there's a lot of mistakes that are being made, a lot of unintended consequences of people getting hurt. So I guess what I'm saying is, if Representative Jones was have that conversation, we'll sit down. But I just, I think our main concern is Section 2 and 3 with the education part of this. So.
Thank you. No, I do appreciate you weighing in on it, and I hope you all have a chance to sit down and talk, because I do think there is consensus around some of this, and been a long conversation over many years, and you've got even people as conservative and as prominent as Senator Ted Cruz that have commented on this statute in the wake of other judicial decisions and say maybe this would be a wise thing to do, because if a court case comes down, the fact that we haven't taken it off our books is instantly going to make it a crime again.
Right.
This is more, now I think it has become not just an issue related to unintended consequences of people not knowing how to enforce it, but if we end up in a situation where it was revived through a court case, it's live.
Well, I think that's
and then it's real.
Kind of the point with Jonathan Mitchell's kind of writ of erasure fallacy type of thing. It's like if a court enjoins a statute, it doesn't necessarily get automatically taken off the books. So it's still sitting there. And then, so this is kind of the opposite of that. It's like, the statute is still here. The court could revive it. So I understand what you're saying.
Yeah, so that's one of those things, and we're only here every 2 years. Well, hopefully only here every 2 years.
More or less sessions.
On average, I guess. And that's something I think that does sit in the back of some of our heads is just let's maybe be forward-looking too, because we don't really want, I don't think anybody, well, I don't know. I can't speak for everybody. I think most people would be shocked to know that at this time, that there was a time when this was a criminal sanction that was actually held constitutional. But those privacy rights are the ones that are being currently litigated and what we consider, being protected or not. So that we're in the midst of that judicial debate, wherever you fall on it, it's happening. And so we need to be responsible as legislators as to what could happen if a court decision came down that would revive something like that.
Right. And just to be clear, I don't know organizationally where we would be if a court decision came down on that, because organizationally we don't support homosexual conduct and we'd be opposed to it. So, but anyway.
Well, and like I said, I think Chairman Leach made the good point. He's like, you can be against a lot of things by the dictates of your faith, your philosophy, however that is, doesn't mean that they have to equate to, not everything we think is immoral and is illegal, right? There is a distinction between the two. And so that's something that I think that's the policy decision that we kind of need to get down to here. So thank you for your
I appreciate it.
Do you have any other questions? No? Okay.
Thank you.
Thank you, Jonathan. Thanks, John. Chair calls one of Ms. Morales' constituents, Linnea Blackwell. Is it Linnea or Linnea? Linnea. Linnea, okay, great. I have you registered representing yourself and in support of House Bill 2055. Okay, go ahead and begin your testimony.
My name is Linnea Blackwell, and I'm here on behalf of myself and in support of HB 2055. I identify as a lesbian woman. For the first 17 years of my life, I grew up in a Pentecostal household where being gay was seen as a quote-unquote sin. I never truly felt seen or like I had the language to articulate who I was to my family and friends. As you all know, the Supreme Court ruled in 2003 that the Penal Code 21.6 was unconstitutional, and it's important for Texas to update its books. Language matters. The archaic language in the Penal Code states that who I am is wrong, even criminal. The current statute is simply not true, legally. Penal Code 21.6 emboldens people who spread lies and disinformation about my community and creates more traumatic experiences like mine growing up. The Penal Code should be written to protect people, not perpetrate hate and outdated stereotypes of same-sex relationships. Who I am is not deviant, and it's important that it not be taught as an unacceptable way of life. Thank you for listening to my testimony, and I hope y'all support this bill.
Thank you very much. Yes, Ms. Morales.
Linnea, thank you so much. I'm so proud to have you as a constituent, and support you, hear you, see you. Thank you.
Thank you.
Members, do we have any questions, comments? Thank you so much. Appreciate your testimony. Chair calls Steve Rudner. Okay, maybe he had to. Steve Rudner. Okay. I'm going to switch him to not testifying. Malcolm Harlan. I have you registered as Malcolm Harlan, representing yourself and testifying in favor of House Bill 2055. Is that all correct?
Yes, sir, correct.
Perfect. Go ahead.
Honorable Chairman and esteemed committee members, I express my sincere gratitude for the opportunity to speak in front of you today. I stand here before you as Malcolm Harlan in full support of HB 2055. As a proud Texan, I cherish my home state. My love for Texas stems from my upbringing on my aunt's ranch in my formative years in Decatur, Texas, where eagle fight never dies. I'm a law-abiding citizen. I pay my taxes. I love God and I love my family. I'm also an American who deeply values the freedom that has allowed our nation to prosper and has allowed me to be the person who I am today. In addition to the precedent set by the Supreme Court by Lawrence v. Texas, I support HB 2055 because it resonates with core American values, especially those espoused by Thomas Jefferson, a founding father and the third president of this great nation, whose administration was responsible for the expansion of this country through the Louisiana Purchase. Firstly, Thomas Jefferson was the principal author of the Declaration of Independence, which, as we know, proclaimed independence against British rule on July 4th, 1776. This outlined the principles of individual liberty and self-governance. HB 2055 embodies these principles, advocating that two consenting adults should have the liberty to love one another, particularly within the sanctuary of their own home. Secondly, as the author of the Virginia Statute of Religious Freedom, which passed on January 16, 1786, Jefferson laid the groundwork for the First Amendment protections for religious freedom and the crucial separation of church and state. HB 2055 upholds these values by preventing religious influence from dictating the lives of consenting adults. Lastly, Thomas Jefferson was a staunch advocate for limited government. As a leader of the Democrat-Republican Party, he championed for the principles for limited government power, individual freedom, and prevention of government overreach. HB 2055 echoes these ideals by serving as a check and balance for excessive government intrusion into the lives of consenting adults. Just as I am granted the freedom to practice my faith, the same freedom to choose my lifestyle and love whomever I desire should be extended to my fellow Americans, myself, and all Texans. And why the history lesson or refresher, some might ask? Well, I think it's important to look back on what went well and what didn't, so we know what to do better when tomorrow comes and also when to meet in the middle. I now conclude with a quote from Jefferson. The care of human life and happiness, and not their destruction, is the first and only object of good government. I extend my gratitude to you and the committee for sponsoring this bill and protecting freedom. Thank you. That's it.
Thank you so much. I appreciate your testimony. Members, do we have any questions? No. Thank you. Chair calls Reverend Aaron Walter. Aaron Walter. Okay, we'll switch the Reverend to not testifying. Is there anyone else wishing to testify on, for, or against House Bill 2055 at this time? The chair sees none, recognizes Mr. Jones to close on the bill.
Right. Thank you so much, Mr. Chairman and members of the committee. First off, I sat there and I listened and I thought a lot about what I was going to say as I was preparing to close. And I think it's important to realize that LGBTQ people are more than just sexually transmitted diseases. The point that was made before you members so eloquently laid out the rest of the bill was that we are people just living with HIV, STDs, or viral hepatitis. But when you think about someone in my situation, not only a lawmaker, but also as a black man, as a gay man, and also as somebody who put whatever hat on that you want to. I've spent my entire life being defined by things so uneducated as that. Because even members on the panel, women, Muslims, Latino community, some of those same things are said about our communities. And this isn't about any of that. This is about dignity, and respect and changing a wrong that is on the books right now. And so if you all would like to have a conversation about education and updating that, I am more than happy to be able to do so and work with the committee to be able to do that work. But I'm going to say it's so disappointing to see that we're still in that place, because when you talk about LGBTQ people, we are your sons, we are your daughters, we are your cousins, we are your family members, we are your friends, and I am your colleague. And this bill wasn't brought to me because this was just something that needs to be done. It was brought to you because this is my life. And there should be no reason that I shouldn't be treated just as equally as each and every one of you. And with that, I close. Thank you so much.
Thank you, Mr. Jones. Yes, yes, Ms. Morales, you have a comment or question?
I just have a comment. Thank you so much for your passion. It's clearly evident here, and you made history when you became a member of this House, and I think that you'll make history with this piece of legislation.
Thank you so much.
Thank you.
Yes, Mr. Bojani.
Just want to make a comment. Congratulations on your first layout of the bill. You did an awesome job.
Thank you very much.
You spoke from your heart, so thank you again for your passion. And I stand with the LGBT community as well. It's important, like you said, me being the first Muslim, one of the first Muslims elected, and just I've fought through that. And we're at the beginning, we're all humans first.
That's right.
We need to remember that. And we're legislators, we're colleagues. I certainly respect you and all the other members of the community. I stand in support with them. Thank you
so much.
Yes, Ms. Bowers.
Thank you, Mr. Chairman, and thank you, Representative Jones. Just want to say that I see you, and I love you and support you. I'm proud of you, and I just want to thank you for being a courageous warrior and standing up for what you believe, and just know that a lot of us do stand beside you and stand with you.
Thank you so much.
Thank you.
Mr. Leach.
Yeah, thank you, Chairman. Thanks, Representative. I want to encourage you to sit down with some of the folks who whose testimony may have disappointed you or offended you today. I understand. I get it. I appreciate your passion and your courage for bringing this bill and fighting for what you believe in. I do believe that you have an opportunity to pass a really, really important bill. And I also believe that there are some folks who you think might be against you in all things right now, but they're not, and they're smart, good, decent people who want the best for Texas. And I actually believe very strongly that there is, if a conversation is had, that there is a workable solution that can be meaningful and that can make a big difference, and that will not be opposed by any reasonable Texan. And so I just want to encourage you to foster that conversation, and any way I can help, let me know.
Absolutely.
Thank
and I'm definitely more than willing to have that conversation.
I know you are. Thank you.
Members.
Thank you very much.
All right, you get an A+ for your first bill layout, Mr. Jones. If there's no objection, House Bill 2055 will be left pending. Is there objection? The chair hears none, and House Bill 2055 pending at this time. For everybody here, we have reached the time in our hearing where the only bills left are the bills authored by members of the committee. And tend to, Mr. Schatzline has a couple of those. Mr. Cook has one that probably accounts for the majority of the folks that are still here. We're going to hear that right after Mr. Schatzline's bills, and mine will go at the back end. And then we'll vote on bills for members of the committee just so you know what we're doing. And if you're back there in the staff world listening, that's the order we're going to go in, and then we'll vote bills once we're done. So at this time, the chair, if this is your first bill layout too? Man, you got a high bar to meet now. But you get two, though, so that's impressive. Chair lays out House Bill 3183 by Representative Schatzline and recognizes Mr. Schatzline to explain the bill.
All right. It's exciting. Thank you all so much. Thank you, Chair Moody, Vice Chair Cook, members of the committee. I appreciate the opportunity to introduce House Bill 3183, which seeks to protect the innocent against false jailhouse informant testimony. We owe it to our constituents and all Texans to ensure trials are fair and rooted in evidence and fact, not unverifiable, and in many cases, false testimony based off of the incentivization of a shorter sentence. According to the National Registry of Exonerations, jailhouse informants have contributed to at least 13 wrongful convictions in Texas, and those are just the ones that we know of. House Bill 3183 requires pretrial admissibility hearings before a jailhouse informant testimony can be used in serious violent felony cases. Experts and other witnesses are screened by judges. Just like paid expert witnesses, jailhouse witnesses are compensated by the state, coached on their testimony by government lawyers, and they convey inside knowledge about the crime that may sway juries. House Bill 3183 would also require a cautionary jury instruction if jailhouse informant testimony is admitted. HB 3183 is a refile of Representative Krause's bill, which passed out of this committee unanimously last session and was voted out of the House with 143 votes in favor last session. Lastly, I would like to say that without full transparency, truth is not possible. Without access to the truth, justice can't be served. HB 3138's intent is to ensure the integrity of our judicial system. Members, at this time, I'll be happy to answer any questions that you may have, and if there are none, I reserve the right to close.
All right. Thank you very much. Other than you referencing Representative Krause, I think you did a great job. No, he worked very hard on criminal justice reform issues, and we appreciate you carrying this bill forward. Any questions, comments, members, before we move to testimony? We do have a witness registered on this bill, so if you just go ahead and hang tight. Call Gary Udashin. Oh, I'm sure I messed that up.
Close. Udashin.
Udashin, okay.
Thank you.
I have you as representing the Innocence Project of Texas and in favor of House Bill 3183. Is that correct?
That's correct.
Go ahead and proceed with your
Okay,
testimony.
thank you, Mr. Chairman. I do represent the Innocence Project of Texas and the National Innocence Project. I am a board member of the Innocence Project of Texas and a volunteer attorney. I was board president for a long time. We deal in the Innocence Project with getting people out of prison who are wrongfully convicted, but we use the experience we have with that work to identify the causes of wrongful convictions, and we come to the legislature and argue in favor of bills like this that will help to avoid wrongful convictions in the future. And as was alluded to earlier, false testimony from jailhouse informants is one of the leading causes of wrongful convictions, both in Texas and around the country. And just in the last few years, I'd say the last 4 or 5 years, the Texas Court of Criminal Appeals has reversed and vacated convictions of 4 Innocence Project clients who were convicted based upon false testimony from jailhouse informants. And so that's an example of real live people who didn't commit the offenses they were convicted of, who were convicted because jailhouse informants were giving false testimony. What this bill really does, it gives the trial judge the ability and the opportunity to conduct a hearing, to bring out all of the information about the jailhouse informant, and then to decide whether there's a sufficient level of reliability and accuracy, potential accuracy in that testimony for a jury to hear it. Much like is done is with expert witnesses, scientific evidence. This is the sort of thing that jurors are not necessarily well equipped to evaluate, but a trial judge with the experience the trial judge has can determine whether or not the evidence should be presented to a jury, or if it doesn't have a sufficient level of reliability to be presented to a jury. So this is a bill that is going to avoid wrongful convictions. And so I would urge this committee to do like this committee did last session and pass this bill and send it to the House.
Thank you very much.
Thank you.
Members, do we have any questions? Yes, sir. Representative Shatson.
Could you speak to the case on John Nolly?
Yes, sir, I'll be happy to. John Nolly is one of the 4 cases that I referenced, and John Nolly is an exoneree, an Innocence Project exoneree that was convicted of a murder out of Tarrant County, where the primary evidence against him, and in fact, I believe it's clear he would not have been convicted, but for a jailhouse informant claiming that Mr. Nolly confessed to him that he committed this murder. It was then determined that that informant had in fact lied in his testimony, and the Tarrant County District Attorney's Office joined with the Innocence Project in presenting an innocence claim, and Mr. Nolly was found to be actually innocent of that murder, and I believe this bill is named after John Nolly very appropriately. Thank you.
Thank you very much. Members, do we have other questions? Okay. No?
Thank you.
All right. Is there anybody else wishing to testify on, for, or against House Bill 3183 at this time? Chair sees none. Recognize Representative Schatzline to close on the measure.
Thank you, members, for your time, and I ask for your favorable consideration. I close.
Thank you. All right. Efficiency, I like it. If there's no objection, House Bill 3183 be left pending. Is there any objection? The chair hears none, and House Bill 3183 is left pending at this time. This time, Chair lays out House Bill 4061 by Representative Schatzline. Chair offers up a committee substitute to House Bill 4061 and recognizes Representative Schatzline to discuss the bill and the substitute and the differences between.
I am back. Okay. Once again, thank you, Chairman Moody, Vice Chair Cook, and members of the committee. I appreciate the opportunity to introduce House Bill 4061, Brooks Boundary, which seeks to protect victims of sex crimes from their offender. This one is what I believe to be one of the most important bills for those who have been wronged through sex crimes. This is a big deal because this is actual constituents that's reached out, and you're going to get to hear from them today. Chapter 62 of the Texas Code of Criminal Procedure already has provisions that limits offenders' access to locations such as schools. However, there are no current protections for the residences of their victims. House Bill 4061 prevents individuals on the sex offender registry from being within 2,500 feet, that's 0.47 miles, of the residence of a victim of any offense for which the person is subject to registration under Chapter 62 of the Texas Code of Criminal Procedure. The committee substitute for HB 4061 makes just a couple small changes to the bill. First, it specifies that if a victim moves into an area that is within 2,500 feet of an offender's residence, then the offender does not need to move. The second change takes out the immediate effect of this bill upon passage, with 2/3 of the members supporting it. This is to make sure that the constitutionality of the bill is intact, as several residency restriction laws around the country have been challenged based on the timely notice the law is going into effect. Victims of these unthinkable sexually oriented crimes often face a difficult path to physical and emotional recovery that for many never truly ends. And you'll hear from the family of one of those victims here shortly. It's crucial that Texas reforms this process and ensures that victims know that they are protected at their place of residence. Representatives, we've been tasked to craft and pass legislation that ensures the safety of the most vulnerable in the state of Texas. And this bill does just that. As a proud father of 3, and as a Texan who deeply cares about protecting the next generation, we can't afford to give 1 inch to those who seek to harm a child. And that's what this bill does, is it lays out another layer of protection for these victims as they move forward in their process through counseling, through walking through the aftermath and the trauma that they've experienced. And so members, at this time, I'll be happy to answer any questions you may have. If there are none, I reserve the right to close.
Thank you, Representative. Yes. Your fellow freshman colleague is going to grill you now. That's
right. I love it.
Thank you. Thank you, Chairman. Thank you, Representative, for bringing a very thought-out bill here. A couple questions. in terms of the necessity for something like this, a simple protective order, would that check sort of scratch the itch you're going for here, or is there a reason that you think that would be insufficient?
That's a great question. So even if granted a protective order, they would only, the offender would only be barred from approaching this victim. He wouldn't be barred from living in the vicinity of the victim, which just isn't an adequate level of protection for those victims once this takes place.
Okay, so this is really focused more to where they can reside relative to where their victim can reside.
Correct. The same, and it's the same idea that we don't allow sex offenders to live within a certain distance from schools. We just want to protect that victim once this has occurred.
Would it create perhaps even unintentionally a situation where sort of the victim and the perpetrator sort of forever, the rest of their lives, kind of have to keep tabs on each other to know if they're violating something like that?
Yeah, that's a great question. So one of the things that we've heard is, is this going to allow for offenders to know the location of their victim? And that's a really important fact to discuss. After discussing this with our sheriff's department, in modern technology, the reality is offenders, if they truly want to find their victim, they're going to be able to do that. But what we know is that when we're going through TDCJ and when these victims are notified that their offender has been released, then we know that there's going to be parameters for where these people are able to live. This would simply say, hey, you can't live in this location. They would give no reason to why they couldn't live in that location. It could be because it's near a school. It could be because it violates another level of their probation. But the reality is it wouldn't give away the address of where the victim lives.
So you don't think that a potential concern where these two individuals who probably never want to be around each other again, at least on one party for sure, have to sort of forever always keep sort of tabs on the other? That's not a concern for you here.
No, and that was really the heart behind our committee substitute, where we wanted to make sure that, it doesn't even disable the victim from moving where they want to move, because, it's important that we maintain their freedom to do as they wish as well.
Thank you, Representative. Thank you, Chairman.
Thank you. Members who have any other questions before we move to testimony? No? Okay. All right, we do have some witnesses registered. Start with Robin Stevenson. I have you registered as Robin Stevenson, testifying on behalf of yourself and in support of House Bill 4061. Is that correct?
Yes, sir.
Okay, go ahead and begin your testimony.
Okay, good afternoon to the chair and to the committee. I would like to begin by saying thank you, Representative Schletzman, for hearing my cry and authoring House Bill 4061. I'm sorry, I'm going to be very emotional.
It's okay, take your time.
Also known as Brooks Boundary. My name is Robin Stevenson, and I live in Rowlett, Texas. I am in support of House Bill 461, and I request that the law for sex offenders be changed. While this law currently focuses on the protection of children, this law does not provide a protection for a victim once the sex offender is released from prison. I am praying that there will be a hedge of protection around the victim to where it would be unlawful for the sex offender to come within a 2,500-foot radius from the victim's place of residency, especially a permanent or temporary residency next door to the victim. I am the mother to a child who fell victim to sexual assault. Sorry. My daughter was 14 years old when she was sexually assaulted by a 37-year-old man who lived next door to us at his parents' house, who'd never left and never moved out. He received a 10-year prison sentence and later was released in December of 2022 after serving his full sentencing. He was allowed to return living next door to us, to our family and my daughter, as a registered sex offender. And I'm sure he has no plans to move ever again. I would like for each of you to imagine you if this was your daughter. You have watched her battle the triggers this trauma has caused her over the years and praying that she would get to a happy place in life. You realize the dreams your daughter have been shattered by the sex offender returning, living next door to her. I'm sure you're thinking, as I did, how is he allowed to return living next door? I thought for sure the law would protect her from protect this from happening, but I was wrong. Not only is my daughter a prisoner of her own mind, she's also now a prisoner of her own home. She cannot go outside to the front or the back of the house because her sex offender will be there. He is a constant trigger for her trauma. My daughter would love to have been here, and I wish she was here, but she's in therapy. In order to protect my family from this registered sex offender, we now have to move. We didn't cause a crime, but we were the ones paying for his crime in so many ways. I keep asking myself, why do we have to move? Why do we have to uproot our lives in order to protect the victim when the law should be doing this? The victim has done nothing wrong. Buying a house and moving from our house, the house of which we raised our children, will be challenging. We have lived in this home for 30 years. We have good neighbors, minus this one. I pray that each of you vote in favor of House Bill 4061. I, along with my daughter, Brooke, want to personally thank you for your time and this opportunity to speak on behalf of Brooke's boundary. I will be available to answer any questions you may have. Thank you, and God bless.
Ms. Stevenson, thank you very much.
Thank you.
Thank you for coming forward and sharing your story. I can't imagine how difficult that is for you to do, and thank you for speaking on behalf of your daughter as well.
Thank you.
Do we have questions? Yes, Ms. Bowers.
Thank you, Mr. Chairman, and thank you, Ms. Stevenson. It is nice to see someone from home. I do live in Rowlett as well. I, want you to know that I want to thank you for your courage to be an advocate for your child. And I can't imagine, because I do have a daughter of my own. And I want you to know that you've got neighbors that'll be keeping your family and your family uplifted in prayer. Y'all live in a neighboring district, it seems now. But just know that I do appreciate Representative Schatzline's bill. Again, I appreciate you coming from home from Rowlett to share your story and to stand up for your child.
Thank you so much.
Thank you.
Appreciate that.
God bless you.
Thank you.
Thank you. Member, yes, Mr. Representative Schatzline.
Robin, I just want to say, I've said this before, but I'm going to say it just in front of this committee and everyone here. Your bravery is incredibly inspiring. I just want to say thank you for coming to us with this. This is what makes great policy, is when parents rise up and say enough is enough. I did have a couple clarifying questions. So how are victims able to communicate with TDCJ about offenders moving into their area?
What we have done is that when he was in prison, we would get a notice every so often saying he's up for parole, and we were able to make comment to that. When he was getting ready to be released from prison, that's where we got able to be notified that he was going to be released from prison. And we were able to provide, that information about, basically to inform us that he was going to be out, in our community. I don't know where he was going to be, but he was going to be out, and I didn't know where he would land.
And then one follow-up question. Have you reached out to anybody about potential non-legislative solutions, and how did they respond?
Yes, sir. I contacted an attorney. It was the 1st of January, sometime after the year turn. And when you were asking the question about the protective order, I asked about the protective order. I asked about a restraining order. And he was telling me that it was unfeasible to make him move, but these orders would only protect to a certain extent. But, to that extent, it wasn't one that, he would be leaving the home, and it would be one that would be happening forever. And he's the one that brought it to my attention that the law didn't protect the victim once he serves his full sentencing.
Thank you. Thank you so much for your courage and coming up and testifying on behalf.
Thank you guys for listening. Appreciate you.
Thank you. Questions? No? Okay. Chair calls Larry Stevenson. I have you registered as Larry Stevenson, testifying on behalf of yourself in favor of House Bill 4061. Is that correct?
That's correct.
Go ahead and please begin your testimony.
All right. Well, good afternoon, Chairman and the committee. And so again, thanks for hearing me out, and certainly really appreciate Representative Chatchland for picking up this request and running with the House Bill 4061, also known as Brooks Boundary. So I'm Larry Stevenson. I live in Rowlett, Texas, and I'm certainly in support of this bill, 4061, and I'd like to see this law for sex offenders obviously modified to further protect the victims of these awful crimes. The law currently does a good job of protecting potential victims around schools and daycares and things like that. But, once a sex offender is released from prison, there is a gap there around the victims, unfortunately. And, how else can you explain the fact that a guy who sexually assaulted my daughter, when she was 14, can just move right back in next door? And, once his prison sentence is complete. And that's obviously why I'm standing here with you guys today and see if we can fix this. Sexual offenders, in my research, they have a reported reoffense rate of over 50% given a certain amount of time. And we know that percentage is low because so much of this goes unreported. And, my daughter's attacker, he certainly falls into that category. He'd sexually assaulted several minors prior to Brooke. I didn't know this until we got to his sentencing trial, and these young ladies showed up and showed appreciation and thanked us for our courage to come forward and told us their story. And I was just like, are you kidding me? I was like, I certainly sympathized with them because it was a familiar story, but I was also angry. I was like, why didn't you go forward with it? Why didn't you press charges? Why didn't you, you could have done so much. You could have helped Brooke, right? And, but, the answer was always the same. It was fear. And that fear of, of their attackers, it's what paralyzes these victims. And that's what we're dealing with right now. It's just fear. It's, I didn't really realize this until my daughter's, attacker moved back in right next door. And, it's, the fear is there every time we step outside. And it's just, it's not right that I have to go out and peek around the corner every time before I go out to make sure he's not in his driveway messing with his car. Or when I go out to go into my garden, I have to peek around the corner when Brooke wants to go out and help me pull weeds or something like that, that he's not out standing by his fence. That shouldn't be how we have to live, and she shouldn't be, again, a slave to her house and risk further traumatization and setback in her recovery. And I know this House bill will address that, and hopefully, she can get back that freedom that we all should have of moving around our neighborhoods and our homes, safely and without anxiety. Her attacker robbed Brooke of her self-worth, her self-esteem, and her purity at a very young age. And, and he's been holding that hostage now for over 10 years. And she's working every day. She's recovering. She's been through a lot of treatment to get that back, but she's nowhere close to standing on her own 2 feet to confront him yet. And, it's really certainly not fair that she has to do this and figure this out, with his presence looming over her every day. And it's, so I believe, your support of 4061 will take a huge step in helping Brooke recover and other victims that, may find themselves in a similar situation. And so thank you on behalf of my daughter, Brooke, for letting me speak today. And I'm look forward to answering any questions you might have.
Thank you, Mr. Stevenson. Representative Chatline?
One question, again, thank you. Thank you so much for having the courage to come up and testify and be bold for your daughter. It's inspiring, and we're praying and believing for her recovery. Just one question clarifying, how has the reintroduction of this offender moving in next door affected her recovery?
Well, her recovery's been ongoing for 10 years. She's been had inpatient visits in a hospital 10 different times to deal with mental issues and to deal with addiction that she's resorted to cover up. That's, and so, but she has gotten better. I mean, this is 14 now to, where she's at now, 24. So, but I did, she battles her demons every day. And once, I had socialized with her that Todd was up for probation and everything, but I was doing, I was speaking with the probation board, doing everything I can to make sure he served his entire sentence. And there was certainly that anxiety level I could see raised. And again, these last 3 years, as he's been up for probation, he's continued to abuse at times and things that I think, so, I've been dealing with it for 10 years. Is there regression? It feels like it. Certainly does. We're still dealing with it. It's been 10 years. I mean, she's made steps forward, but we've certainly taken steps back. And now that I see her and see how she reacts, when I step out, if we step out and he steps out, or we're backing up, and you just, it's there. She puts up a tough facade. She does. But through conversations I've had with her therapist, where I'm invited in, and Brooke's willing to let me come in, that there's real fear there, and her and they, so, how do they deal with it? How do people deal with it? We try to cover it up, I guess, a lot, and so it's not helping things, if that's what you're asking.
Thank you.
Yeah.
Members, do you have any other questions for Mr. Stevenson? No? Thank you, sir.
Thank you.
Chair calls Mac McCurry. I have you registered as Mac McCurry, testifying on behalf of yourself in opposition to House Bill 4061. Is that correct?
That is correct, sir.
Okay, go ahead and begin your testimony, please.
I'd like to thank this opportunity here for this very uncomfortable experience. I totally feel for the family. However, I feel that this bill, in their case, does not appropriately or adequately address the situation here. This bill creates more questions than answers. And as Representative Schatzline outlined in paragraph J, where it talks about the 2,500-foot stipulation for any offender to go for any reason into the 2,500 feet from a residence of their victim. So as we know, and you had said 0.47 miles, is basically from here to I-35. And we know in urban areas, that can be a lot of dwellings, a lot of people. So when a offender, somebody on the registry, can travel through this area and for whatever reason gets caught in that area, then they have violated that. They have no way knowing. And as you mentioned, how does one identify this area? You definitely don't want an offender constantly searching out where their victims are. As you indicated, it's easily done now with social media, et cetera. So I don't think that's healthy for the offender, and it definitely, in the case of the victim, that's definitely not the burden that they need to have on them. So there's also cases where the offender is a juvenile in the home, and in the course of the education and whatnot of the court system, the juvenile gets released and is approved to go back to his residence after counseling, family treatment, et cetera. So how does that address that right there? So that's kind of tough. Do you say, no, you can't come back home? And there's also lots of times where the offender moves back into the area or moves, period. And like what you had indicated, that having to figure out this 2,500-foot circle, 1,000-foot circle, whatever it is, stipulated, if you look at cities that have created these ordinances, you have all these bubbles, these circles, where they can and cannot live. And so when you add this in there, those bubbles get smaller and basically pushes people out. So I appreciate this opportunity. I know it's something that y'all don't want to hear, but this is our process of being able to rebut. And I appreciate it. Thank you for this committee, and God bless Texas.
Okay. Yes, Chairman Leach.
Who is our? You just said this is our opportunity to rebut. Who's that?
I'm sorry. I think as a general population. as citizens, et cetera.
Okay, so it's my understanding that this bill, as it provides as the default, it's a 2,500 foot perimeter, which this is for anyone who's convicted of a sex offense and has finished their time in either being incarcerated or on probation. Is that right? Great. And this prevents. I've got a question, but I just want to. This prevents an offender from living within 2,500 feet of their victim. And you're just so I can clarify, your position is that is too onerous on the offender?
Yes, sir.
What about the victim?
Oh, it's definitely in their case, this family case, moving next door. I mean, that would be horrific, for that. Honestly, it would be. And so, but like I said, in an urban area, you could have 10,000 people in this 2,500 feet. And so this person may not even know this and moves in, to this area. And so is it 2501? Is that acceptable? But so a lot of cases, the person may not even, time has passed 10, 20, 30 years. And so you can't, you may not even ever run across this person.
Well, should the burden not be on the offender to ensure that they're not within a certain distance of the victim? Should that not be the burden of the offender instead of the convicted, I should say, not instead of the victim?
I can't answer that.
You don't think that an offender could, upon his or her release or the end of their probation period, figure out where the victim resides and ensure that they're not within the lawful residential distance as required by law? You don't think that an offender could figure that out?
Well, I'm sure.
Or you don't think that they should have to? What's your position?
Well, if a person is incarcerated and upon release, as it states in the statute there's certain things that they have to comply with. And so that would be one of them. It's like, oh, by the way, when an offender, this is from my knowledge, when an offender is released, most likely they're released on parole, they would have to have a plan of where they would have to be returned to. And that accommodation or that housing would have to be approved by the parole board. And so in that process, they said they wanted to go live, with whomever or wherever. And that process, they would review that and they would come up and say, no, you can't live there because that's too close to a school. You can't live there because that's too close to a park. And you can't live here because your victim is within that radius. So you're going to have to find somewhere else to go. Mm-hmm. So in most cases, that would be the case. Now, when you go, say, 20 years down the road, a lot of times that the offender is probably not thinking about, where, because they, I would hope that the offender has not constantly Googled this person, their victim, and followed them. So they would have to go, and say, make a conscious effort to say, all right, where does this person live? Is it in this state? Is that state? Is it in this neighborhood, that neighborhood? So it's.
You don't think the victim, when the offender's released, you don't think the victim is going to be asking and wondering and scared about where the offender lives? That, to me, should be a lawful burden that's on the offender, not the victim. And what this law is doing is ensuring that a victim knows under Texas law that the default is that offender, when he or she is released, cannot live within 2,500 feet of where the victim resides. That provides that assurance, that safety, that security for the victim. I want to know, final question, is it your position that an offender cannot do that or should not be required to do that? What's your position?
Cannot is a strong word.
I agree.
should not, I think it would be incumbent upon the individual and in the circumstances and in what the court. So there's some offenders who have absolutely no regard, period. And that's why they committed the crime in the first place. And there's others who have committed, and there's a wide range of offenders on the list.
Yeah,
And so,
I'm well aware. I just think that we should be more focused on what the victim wants and needs as opposed to the offender.
So
that's my point.
Right.
Doesn't seem like you agree, but thank you.
Vice Chair Cook.
It sounds to me like that you're not disagreeing with the intent of this bill. Is that fair to say?
I understand, yes, I understand the intent of the bill.
No, that's not what I asked. Do you need me to repeat it, or do you want to answer my question?
Please repeat.
Okay. So is it true that you generally agree with the intent of what Representative Schatzline is trying to accomplish?
I don't think he does.
Okay, I do not, sir.
You do not, okay.
Correct.
So in your particular situation, you're a registered sex offender from the state of Florida, correct?
No,
You're not?
no,
Did you get convicted of sexually assaulting a minor in the state of Florida?
no,
So these records are incorrect?
yes, sir.
Have you ever been arrested for assaulting a minor, sexually assaulting a minor?
Yes, sir.
Okay. So since you're trying to mince words, tell me what happened in that scenario.
I would rather not
Well,
explain it in committee.
Well, I want to know because the reason it's relevant is because you lived in the state of Florida. You
No.
obviously, okay, maybe that's the word. So you never lived in the state of Florida, correct? So you were just staying or vacationing in Florida and sexually assaulted a minor?
No,
Okay. So
No,
under
that-
what circumstance did you assault a minor in the state of Florida?
none.
Okay. Why were you prosecuted in the state of Florida?
I was not.
Okay. What state were you prosecuted in?
Here in Texas.
Okay. And did you move to Florida after that?
No,
Did you ever reside in the state of Florida?
No.
Were you ever on their sex offender registry?
yes,
Okay. And why is that?
before that, for that assault.
But why did you have to register in the state of Florida?
The state requirement for travel.
So if you take a vacation to a city in Florida, you have to register as a sex offender, is what you're telling me?
That's correct.
All right. And then in your particular situation, have you tried to make efforts to not live near your victim?
I have absolutely no idea where the victim is.
Okay. So that's why I'm going to go back to my first question. It sounds like you're not objecting to the purpose of what he's trying to accomplish. It sounds to me like you have an issue with being able to comply with the proposed statute. Is that correct?
That would be an accurate statement.
Because you don't think it's a good idea for someone to serve a 10-year sentence and move next door to their victim, correct?
No, that's incorrect. I do not agree with that statement.
Well, tell me what you disagree about that statement.
For the 2,500-foot range,
That's not what I asked you, sir. I said, do you agree with me that it's not appropriate for a sex offender to move next door to someone after finishing their sentence, correct?
next to his victim.
Correct.
Yeah, personally, I do not feel that would be good.
Okay. So you believe that there should be some buffer, correct?
In that case with that family, yeah, that's a poor decision for that person to move back there.
Does it sounds to me like there's a loophole in state law with regard to someone getting out on parole versus someone serving their full sentence. You testified a few minutes ago that you felt like when someone's on parole, and which I think is correct, you're gonna have an investigation where there's a parole officer that's investigating where you're working, where you're living, and that sort of thing.
In my understanding, that's correct.
Well, I mean, in your experience, is that correct?
No.
Okay, so did you serve your full term?
I'd never served.
You never served. But it's your understanding that someone has to go through that process if they're released on parole prior to serving their entire sentence?
That is my understanding.
Okay. And do you have any understanding whether or not any type of investigation is done if someone fulfills their full sentence?
I do not.
Yeah. But does it make sense that once they've served their time, they're released without being on parole, correct? I mean, parole means early release, right?
That's my understanding, yes.
Okay. So if someone serves their entire time, which I think was the situation that we're discussing today, then there is no type of investigation or accountability with regard to job or residence. Is that your understanding?
Well, if they serve their full time, they would be on the registry. So there would be certain restrictions of, as it's stipulated in there, Chapter 62, of where they could and could not work, et cetera.
Okay. So what do you think a reasonable buffer is, in your opinion?
I can't personally give you one.
Why is that? Well, you gave me, okay, is it more than or less than from here to I-35? Was it less than that?
Okay, if you want to pin me in the corner, I would have to say more.
Okay. So you think it should be further than 2,500 feet?
Well, you mean the distance that they would be allowed or not allowed?
Earlier, you gave a reference between, you estimated that the proposed boundary or buffer is between here and I-35, correct?
Right, and then in that case, I would have to say a decrease. Again, because, I mean, if you're in a rural area, 2,500 feet may be the next house. If you're in an urban area, 2,500 feet may be 5,000 people.
This last question, do you have any recommendation as to what the buffer should be?
I do not. I'm sorry, I do not.
Okay, thank you.
Representative Shetson.
Thank you. Thank you, Mr. Chairman. I have to say, it is a bold move as a sex offender to come in and testify against this bill. Bold's the kindest words that I can come up with. So my biggest question is, so as a sex offender coming in here, just want to be clear, you're advocating on behalf of sex offenders to have the right to move in next door to the victims once they're free from prison.
I wouldn't say it like that.
How would you say it?
That sex offenders aren't only the individuals, it also encompasses their family. So that family, is their spouses, their children, et cetera. And so if that was the only house that was available for that person and their family, then to deny that right to that person and that family, you're saying that you can't live here, you are banned.
It's interesting. My wife's a realtor. There are tons of houses on the market right now. It's actually booming. Ultimately, this is a big state. You could live within anywhere in Texas. You can move out of Texas. But I just want to be clear. You are advocating that the conveniency of yourself or a sex offender is more important than the safety of a victim who was sexually assaulted.
Of course I can't say that.
What would you say?
As stated, that a person has a right to live in a house that they can afford, where they can afford it.
Are you advocating the fact that that is the only affordable house in the state of Texas?
I can't say, no, of course I can't say that. I can't advocate that because we know, as you said, your wife's a realtor, the housing market is a frenzy. So you may find one house, but that house to the offender is within 2,500 feet of a park.
Is it more important for the sex offender who's come out of prison to be able to live in that singular house or to protect the victim who has been a victim of a sex crime?
No.
That doesn't answer my question. Is it more important?
No, it's no.
My last question, is it more important to protect the ability for a sex offender to move into the house of their choice or to protect the victim that has been sexually assaulted?
By that individual. So that's what you're saying, yes. Yes. No, and I would side with the victim in that case.
I'm so glad that you're advocating for the bill.
I'm not advocating for the bill.
So let's do this. And I appreciate you answering questions. Mr. McCurry, and as someone who's been through a number of these conversations, There are a myriad of restrictions placed on those who are registered sex offenders. The debate that we get into and where this bill touches is, do we think those restrictions are sufficient or do we not? I think what you're coming here today to tell us is you think they are sufficient, we don't need to change them anymore. That's your opposition to the bill. I'm going to leave it at that. These are challenging conversations, and this won't be the last time that we talk about it, guaranteed. You're right to be here to testify. Appreciate you coming forward and giving your opinion. Doesn't matter whether I agree with it or not, but it is important to be able to open up in public debate to have these discussions, because that is the policy discussion we're getting into. So, Mr. McCurry, I don't think we have any other questions for you at this time, but certainly appreciate you coming forward and testifying.
Thank you for this opportunity.
Yes, Chair calls Wendy Boynton, and I have you registered as Wendy Boynton, representing yourself and testifying in opposition to House Bill 4061. Is that all correct?
That is correct.
Okay, go ahead and begin your testimony. Thank you.
My name is Wendy Boynton. I am testifying on behalf of myself, and I am opposed to House Bill 4061. Thank you, Chairman and committee, for hearing my testimony. My son is on the registry. He was convicted of sexual assault of a child for a relationship he had with a girl he met when he was a senior in high school and she was a freshman. After he graduated from high school, the relationship progressed and he was charged and convicted at the age of 19 and sentenced to 6 years in prison. When the girl turned 18, she contacted my son and began visiting him. My son has completed his sentence, and he and the supposed victim are living together. They are planning to get married soon and saving money to buy a home. Her mother and father are now my son's biggest fans. They did not realize at the time that turning him in would land him on the sex offense registry for life. My son went from losing an academic scholarship at the University of North Texas to now sandblasting sewage pipes for a living. He also missed 6 years of his siblings' lives because they were under the age of 18 when he was incarcerated and serving the remainder of his time on parole. House Bill 4061 does not take into consideration these types of situations. I'm sure there are many other situations like my son. He has suffered enough because of the laws that forever stigmatize and harm people on the registry and their loved ones. Therefore, I am opposed to House Bill 4061 because it would be impossible for him and many others to comply.
Thank you, Ms. Boynton. Members, do we have any questions? Yes, Representative Schatzline.
So we actually have a committee substitute.
Do we have that?
We have a committee substitute that was spoken about that would actually make it to where your son does not apply to this bill because his girlfriend moved in with him.
Okay, I wasn't aware of that.
Well, and come back, Ms. Boynton. So, and you wouldn't be. So the way the process works is substitute comes forward, and the first time it's talked about typically is in. It's a little bit difficult when we run session the way we do, but it's just the way that these things happen. Is it'll be submitted to the committee members first, and sometimes that's hours before a hearing. If not, I mean, sometimes I've seen it distributed right before the bill is laid out. So you wouldn't have had an opportunity to see that. But what I would like to do is if you have a copy of the sub, if you can provide it to Ms. Boynton so she can look at it, let's do that. But just wanted to let you know that's how the process works. So it's not that you didn't see something or whatever. It's just that you wouldn't have had access to that until right now. So thank you so much for offering your testimony.
Thank you.
Thank you. Is there anyone else wishing to testify on, for, or against House Bill 4061 at this time? Okay. Okay, hold on. You're wanting to testify, sir? Yes, sir. Okay, I'm going to need you to, is that a registration kiosk right there? Okay. We're just going to need to get you registered before we call you up, okay? That one doesn't work. What? That one won't work right there. Oh, okay. It's okay. There's kiosks behind here in the hallway, and you need to enter in on this bill, 4061. If you come back, we'll wait for you, and then we'll call you once we gets in the system. She'll show you. Do you know where they are? No. Okay. Been waiting all day. Sorry for the hold up. back to your regularly scheduled programming. Chair calls Ian McPherson. I have you registered as Ian McPherson, representing yourself and in support of House Bill 4061. Is that correct?
That is correct.
Okay, go ahead and provide your testimony to the committee, sir.
Thank you, Mr. Chairman, Vice Chairman, and members of the committee. First of all, my thanks to the parents and sympathy to the family. A couple of points. I believe I was shocked at 2,500 feet. Why that? I would advocate that it be outside of the county. Number two, how can the burden of the crime fall on the family to have to move from their residence? Thank you very much.
Appreciate it, Mr. McPherson. Thank you so much. Mr. Chairman Leach.
No, that was worth waiting for.
You're okay? All right. Did you?
Thank you.
All right. Thank you so much. Okay, and now I also have a Kevin Witt. And have you registered as Kevin Witt, representing yourself and testifying in support of House Bill 4061. Is that all correct?
Yes.
Okay, go ahead and begin your testimony.
Thank you, Chairman Moody and Vice Chair Cook and committee members. I would like to testify for myself and as a survivor of sexual abuse and rape. When I was 14 years old, I was raped. Not only was I raped, I was drugged, I was held down, I had an inhalant put over my face, and I was sodomized at 14 years old. This is called, and not only that, it was also, my father molested me. Later, I was raped again, and eventually, I was human trafficked. And to sit up here and to sit in this room and hear people that have also raped or molested or whatever you want to call it, other children is absolutely disturbing. I only heard about this bill today. This was not planned, but I just could not sit here and listen to that and not come forward because since then, I have been diagnosed with borderline personality disorder, PTSD, and a number of other mental illnesses that I have to take medicine for to this day. It's affected the rest of my life. I cannot go the city where this happened. I cannot not even go to the city without being triggered, let alone allowing a sex offender to live 2,500 feet from me. I think that distance should be increased because 2,500 feet is not enough. I think that they should not even be allowed to live in the same county as the victim because we have to take into consideration we are the innocent ones. The victims did not do anything. It was the offender. They committed the crime. They took an innocent life, an innocent child's life from them and destroyed it for the rest of their life. I am now 44 years old and I still live with these effects to this day. Thank you, and thank you guys for being here.
Kevin, thank you very much. I appreciate you weighing in on that. Representative Schatzline?
I just want to say thank you so much for your bravery and coming up here and sharing your heart. It takes so much courage for you to come up here and be that vulnerable. And I just want you to say you made a difference today. And everything that you just said was so meaningful. And it was meaningful to this family. It was meaningful for the victims that are crying out for justice. And so thank you.
Thank you. And I just want to say that many people don't think that boys are victims, and they are. And most men are afraid to come forward because they're men and they're not supposed to, and they're not supposed to show their emotions. But I've never done this publicly. I've never gone into the depths of my rape or abuse or any of that in public. So I only have said that I'm a survivor, never really what happened. So it was really hard for me, but thank you for having me.
Your vulnerability brought justice today, so thank you.
Thank you.
Is there anyone else wishing to testify on for or against House Bill 4061 at this time? Chair sees none. We'll recognize Representative Schatzline to close on the bill.
Thank you, members.
Thank you.
I think, I'm just completely shaken by, the testimony we just heard, and really the story that originally really just caught my heart for being able to bring justice to this family, but more importantly to victims across the state of Texas. I think one of the things that was said that I wanted to bring clarity to was one of those sharing testimony said, we hear from TDCJ, we can't move there because the victim lives there. Well, that's actually an inaccurate statement. TDCJ does not actually disclose why they can't move there. And I wanted to clarify that because it's important to note that we do guard the safety and privacy of the victims' homes and their addresses. And so I also just want to just encourage you and challenge you that this truly is the right side of history to stand and say, hey, we're going to protect victims, not worry about the inconvenience to offenders, but rather we're going to put Texas children first. Those who are the most vulnerable, those who have been harmed the most, are going to be our first priority. And I'm honored that this is one of my first bills that I get to lay out. I want to thank the committee and thank you, members, of your time. And I ask for your favorable consideration, and I close.
Thank you, Representative Schatzline. Chair withdraws the committee substitute to House Bill 4061. And if there is no objection, House Bill 4061 will be left pending. Is there objection? Chair is none, and House Bill 4061 is left pending at this time. All right. And you do have a sub? Okay. At this time, Chair lays out House Bill 17. Chair also offers up a committee substitute to House Bill 17 and recognizes Vice Chair Cook to explain the measure and the substitute and the differences between.
Thank you, Mr. Chair and members of the committee, for this opportunity to lay out House Bill 17. This is an issue that arose during the interim under the leadership of Chairman Leach and the Criminal Justice Reform Committee that he put forth and had testimony brought forward during our committee hearings. And so I want to thank Chairman Leach for his efforts and leadership with regard to this important issue. As many of you know, or each of you know, the governor, lieutenant governor, and Speaker of the House all made this issue a priority with regard to prosecutorial discretion and when it's being abused. So I want to just first start off with and remind each of us we take an oath when we won our elections, and pursuant to Article 16 of the Texas Constitution, elected and appointed officers, including prosecuting attorneys, take an oath of affirmation to preserve, protect, and defend the Constitution of the laws of the United States and of this state. The same oath that we've taken as legislators. Prosecuting attorneys do have discretion in determining on a case-by-case basis if probable cause exists, whether or not a suspect committed a particular criminal offense that can be proved beyond a reasonable doubt at trial. The Constitution requires that determinations be made for all state laws, not just laws that politically align with the prosecuting attorney. As many of you know and have heard during the last few years, some prosecutors are bringing politics into prosecution, and the purpose of House Bill 17 is to eliminate politics from this arena when their main job is prosecution. Unfortunately, certain Texas prosecutors have joined a growing trend of adopting policies and issuing public pronouncements that particular laws, which they do not agree with, will not be enforced under the guise of prosecutorial discretion. These actions set a dangerous precedent of signaling to criminals that the law will not be respected within their jurisdiction. This not only usurps the legislature's policy-making authority, but endangers the public safety of all Texans. To me, this is not a partisan issue. This is not a Republican issue. This is not a Democrat issue. This is a legislature issue. In my opinion, any law that is rightfully passed by both chambers and signed by our governor is a law on the books, and with regard to criminal laws, those laws should be enforced on a case-by-case basis and not thrown out by someone making political statements, grandstanding, holding press conferences, or sending out press releases as to what crimes they're not going to implement or enforce that the legislature has passed. And we've all seen different examples of those. There's been, those types of statements have been made with regard to abortion laws, election laws, theft under $750 was an issue that was exercised in Dallas County specifically. And what that does, it sends a message to criminals that it's okay to steal. Just make sure you don't, that you don't go beyond $750. So whatever you take, make sure it's less than $750. But again, the purpose of this bill is to simply have prosecutors just do their job, not bringing politics into this environment. And I also want to say that, almost all prosecutors in the state of Texas do a wonderful job. It's on very rare occasion that prosecutors are removed, but sometimes it is necessary. And did you point out that I did have a committee sub, Mr. Chairman?
It's before the committee.
Sorry?
It is before the committee.
Thank you, Mr. Chair. So I want to just go over just a few of the changes that are made in the committee substitute. I also want to thank just numerous prosecutors, district attorneys, both elected and deputies from their offices for sharing their input with this important topic, and would like that that their voices have been heard, and that's why I do apologize, but I did provide a copy of the committee sub and a summary of the changes to each member. It should be at your desk. It was passed out earlier today. It was passed out earlier today, Mr. Gardner.
It'll be the piece of paper at the bottom of your stack, sir.
But the committee sub, again, as I said, it was a result of many discussions with many different district attorneys, and I don't know that any of them are jumping up and down and saying, yes, let's go pass this law. But I do know that they all have pride in the job that they perform for the citizens of Texas, and they obviously realize the importance of what the district attorneys, county attorneys do for the citizens of Texas. But in the committee substitute, basically the approach that House Bill 17 takes is broadening the definition of official misconduct. Specifically, the adoption or enforcement of a policy by a prosecuting attorney refusing to prosecute certain conduct constituting a criminal offense under state law, including a policy that the prosecuting attorney will categorically exercise the prosecuting attorney's prosecutorial discretion to decline to prosecute one or more classes of criminal offenses unless the refusal is in compliance with an injunction, a judgment, or other court order, which obviously would be permission or authority to forego prosecution of a particular crime. Further, we've added the definitions of policy and prosecuting attorney to Chapter 87. Chapter 87 of the Local Government Code is in existence and is available currently for the removal of prosecutors or a long list of other county officials, county officers that are referred to in Chapter 87. The substitute also clarifies that prosecuting attorney, it does include the elected, criminal district attorney, county attorney, whoever's doing the prosecuting in each county throughout Texas. It also clarifies that for the petition to be brought to seek the removal of a district attorney or a county attorney, the presiding judge of the administrative judicial region shall assign a district judge from another county to hear the petition for removal proceedings. This practice is already set up with regard to many instances, such as a motion to recuse. When a motion to recuse is brought forward, it goes to the presiding judge of an administrative judicial region, and that judge assigns a judge from a different county within that administrative region. And so that's the process that we chose to follow here. Also clarifies for trials the removal of prosecuting attorney, the presiding judge of the administrative judicial region shall appoint a prosecuting attorney from another judicial district or county within, again, the administrative judicial region to represent the state. Lastly, it states that a public statement issued by a prosecuting attorney to refuse to prosecute certain conduct constituting a criminal offense may be used as prima facie evidence that the attorney has committed official misconduct. To be clear, I support prosecutorial discretion. Believe it's at the core of what district attorneys, county criminal attorneys do for us, is exercising their prosecutorial discretion. And I want to make it crystal clear that not only do I support it, but the intent of this legislation is not to take away from that prosecutorial discretion, just to remove any abuse that's being proffered as prosecutorial discretion. But in reality, it's a situation where someone is bringing politics into prosecution. So that, again, that's the purpose of this bill. I'd be glad to answer any questions from any member of the committee. Otherwise, I'd like an opportunity to close when appropriate, Mr. Chair.
Well, certainly going to give you an opportunity to wrap. So just to kind of sum kind of the sections, you've got you're looking at the removal statute, which touches more than just prosecutors, right? That process exists for multiple.
Under current law, that's correct.
Right. So you're going to specifically say that certain conduct for our prosecutors is misconduct. That we're adding to that category of ways to remove someone, right?
That's correct. So they would, prosecutors are in the laundry list, and if you want, just for purpose of the committee, under 87.012, the officers that are currently subject to removal under this section is a district attorney, a county judge, a county commissioner, a county clerk, district and county clerk, a county treasurer, a sheriff, a surveyor, a county tax assessor, collector, constable, a justice of the peace, a member of the board of a trustee of an independent school, and a county officer not otherwise named by this section whose office is created under the Constitution or other law of this state. So all of those officers are subject to removal currently, and as the chair said, the purpose and the intent and the language of this House Bill 17 has specific provisions that are being added with regard to prosecuting attorneys.
Because it obviously wouldn't impact the other officers you talked about.
Correct.
And so then that's kind of one section of the bill. And then you make it clear that the removal proceedings for the officials not a prosecutor remain the same as current law and only change in the circumstance of removal of a prosecuting attorney. Is that correct?
That is correct. So if you look at page 2, line 6 through 12, and that's the current. So there's just a couple words that are different, but there's no substantive change. The substantive change for prosecuting attorneys is found in paragraph B1 on page 2, beginning at line 13. There was a request from the Travis County's District Attorney's Office, which I did include in the committee substitute, that currently, with regard to any officer under current law, a citizen of the county in which the conduct occurred who has lived there for 6 months may file the petition. The request that I received to include with regard to the prosecuting attorneys is not only have they been a member of the county for 6 months, but they're also actively currently living in that county. Okay. And that is included in.
And the current removal provisions, I mean, the petition is coming from someone that resides in the jurisdiction, right? That's
correct.
Maintaining that.
Yes, sir.
That part of it. The appointment of the judge that presides over it, also that's now the third bucket of what you're changing. Does that pertain just to a removal of the prosecutor or also to the removal of those other officers that you have in the laundry list?
So beginning at line 20, a petition for removal of an officer other than a prosecuting attorney. Again, there's some minor tweaks there. Beginning at line 22, a petition for removal of a prosecuting attorney must be addressed to the presiding judge of the administrative judicial region. That's a slight change, but that's where the petition of a officer as defined in 87.012, save and except prosecuting attorneys, would be found in paragraph C.
Okay. All right. And then So I didn't want to cut you off. Is there more?
No, I think I've answered the question. I mean, like in line 22 is where it states a petition for removal of a prosecuting attorney must be addressed to the presiding judge of the administrative judicial region. And then the petition for removal of an officer other than a prosecuting attorney must be addressed to the district judge of the court within which it is filed.
Okay.
Which is, like I said, current law.
Okay.
The first portion with regard to other officers.
And then the kind of last, the fourth section also includes a provision G on page, I think I'm looking at the right thing, line 5, page 4. It talks about the public statement of a prosecutor saying they're going to refuse to do something that constitutes prima facie evidence of misconduct.
That's correct, Mr. Chair. And what I would offer is that I think paragraph G shows the intent of what House Bill 17 is attempting to capture, and not a prosecutor doing his or her job. You know, so if they're going out and making a public statement indicating the attorney's intent, that's probably not within the normal confines of what a district attorney does. Instead, they receive cases, they review cases on a case-by-case basis. They decide whether or not to prosecute, and if they decide to prosecute, then it moves forward. And we want to respect that process that they currently have. We want to make sure that goes forward. But I think paragraph G sets up, you know, and identifies, captures what the intent of House Bill 17 is intended to prevent.
Well, because when we distill it down, this is a lawsuit. This is a lawsuit, right? And so people can say a lot of things, right? And it's the policy and the conduct that you ultimately have to determine whether it fits under the first parts of your bill. But the back end says that statement, evidence-wise, right? That's going to essentially allow you to, I guess that kind of fast tracks the litigation.
I don't know that it fast tracks it, but I think I mean, at the time that the decision is being made by a jury, I think it makes it crystal clear what behavior is attempting to be removed from.
Chairman Leach.
Yeah, thank you, Chairman and Vice Chair. You know I'm in support of this effort. I think I'm a joint author of the bill, and proudly so. I look forward to voting for it. I'm just sitting here, thinking out loud a bit. Are we concerned at all that this is constitutionally protected speech? I'm first among the legislators that are concerned about public statements from prosecutors saying that they won't follow Texas law, that they won't do their job, that they refuse to prosecute an entire class of crime. I think that's a big problem we need to fix. But are we concerned if that's the prima facie evidence that's going to be used in what you're right is essentially a lawsuit? Can a prosecutor can the Travis County prosecutor who signed a letter saying that he will not comply with Texas law, proudly and publicly so, then not raise a constitutional defense under the First Amendment and stop the proceedings?
What?
If that's the first thing I do, if I'm a prosecutor and I make a public statement and you're using that public statement as basically the only evidence to, Chairman, I think you're right, get to the second phase of the trial or get to the actual removal procedure, the first thing I do is say, hold on, I have the right to say whatever I want.
So I think that's what I was trying to drive at, because I think this is one of the things that we talked about is to not get tripped up in that space, because people are going to avail themselves of whatever opportunity to, obviously if someone's being sought to be removed, they're going to fight. They're going to try to figure out how to fight back against it, including maybe claiming some of those, having some of those claims. If you create it as a rebuttable presumption, I think that may change the dynamic there as well. Ultimately, they're going to have to come back and show that the policy, right, that they've got a policy as you've defined it, that's essentially cutting a whole class of offenses out. That's what the jury's going to have to do. You're teeing up the statement as essentially a key piece of evidence, and you're giving it you're giving it for lack of a better term, you're giving it elevated status by having that provision in the bill, right? That piece of evidence is very important. It doesn't preclude, it doesn't determine whether they're removed.
Yeah, and I think that's why it's not in the definition.
I remember initially there was some thought of putting that at the front end.
Correct.
Now you're trying to essentially giving it weight on the evidentiary side, which I understand where you're going with that. I think there's a way to construct that to keep it there, to give it the weight that you want to give it, without tripping some of those other wires. But it's my guess.
But you can't. My concern, Chairman, is that you can't. And again, I'm support of the bill. Sign me up. Move passage right now.
Not yet, man.
But if official misconduct, constitutionally protected speech cannot by itself be classified as official misconduct. It cannot be the position of the legislature that the mere statement in and of itself is evidence of misconduct. And so my question is if the statement is all there is, if there's no adoption of a policy, but clearly there's a statement from the prosecutor, and then a court rules that no, that's constitutionally protected speech, then how does the removal petition proceed against the prosecutor? Maybe a court won't say that, but I know that's what I would argue if I'm the subject of a removal.
Yeah, I think Chairman Moody. Oh, I'm sorry. Go ahead.
No, go ahead.
So I think Chairman Moody answered the question correctly. I think if we were to place it into the definition of official misconduct, which currently exists in 87.011 of the local government code, if we were to place it there and say that is official misconduct, then I do believe it would be subject to attack from a constitutional perspective. Obviously, like any other lawsuit, I mean, people make all types of different defenses and argue different legal theories. And so can I sit here and say that someone's not going to do that? Absolutely not. But I do think that the intent of the legislature can be set forth as far as what a prima facie case looks like of official misconduct.
So my suggestion would be and I don't see it in here, but we need some sort of severance clause in here.
Oh, good.
Because
I hear what you're saying.
Yeah.
And I know that we have we have a witness that wants to talk about the free speech element of this.
Okay.
So I think some of those questions could be.
Okay. Thank you. I love the bill.
No, I think that is one of the things I know you're trying to balance, because that's kind of what started the fire of this conversation with these public statements. Well, we know you can't just, all right, what someone says, that's great, but we're trying to get at the actual conduct, right? What is official misconduct? And so I think that's why you've put them in different places. But yeah, I think those are all good points. I do want to ask you, and I appreciate you work on this. Do you think it's important for prosecutors to have discretion?
Absolutely.
Okay, and just in your opinion, why is it important for prosecutors to have discretion?
Well, for a number of reasons. I mean, obviously, I think if you were to poll district attorneys or county attorneys, I think one of the first things you would hear would be resources. I mean, just quite frankly, it's a fact that they can't prosecute every single case out there, but from my interpretation of prosecutorial discretion means that he or she or one of their deputies needs to review each case on its own merits. That's what prosecutorial discretion is, in my opinion. And so if someone's making a blanket statement that they're basically giving clemency, which is not authorized, only the governor can give clemency, but that's basically what they're saying. If they're telling criminals that you can go commit this offense that the legislature created and I'm not going to prosecute it, they're basically granting clemency in the beginning. So that is not using prosecutorial discretion.
Yeah, and I think that's where we've got to drill down to when they step into when they step into the role of governor. That's where we need to figure out how to make sure that is a clear, bright line. I do want to touch on, because I think it's something that we do need to figure out how to do it. Many jurisdictions have pretrial diversion programs. Those are typically first offender programs where, the goal is that if they successfully complete that program, that case is going to get dismissed. And I just want to be clear, that is not that is not your goal of this legislation, is to preempt pretrial diversion, or I mean, we have various types of, you know, veterans courts, drug courts. You know, those are ways that we're also, you know, I could see someone say, well, that's, you're not prosecuting to the fullest extent of the law, right? Your goal is not to go after those mechanisms under this bill. Is that correct?
That's absolutely correct.
Okay. Because I do think, and for efficiency's sake, there's a lot of these things that are done. There's a lot of these things that are done, you know, to be able to handle a class of offenders, right? And so we don't want to take those efficiency tools away. I think Republican, Democrat, that people are using those all over the place because it's a smart way to handle certain types of cases, certain types of offenders.
Sure.
So I just want to make sure that we're clear on that. And that's something that I think we can make a little bit more pronounced in the bill. We'll work on that.
Okay.
Members, do you have any other questions, or just Chairman Leach and I are going to weigh in on this one? All right. We do have a number of witnesses. You're going to have an opportunity to ask any of them as well. We're going to try to keep pretty tight on the time because there are a number of witnesses that registered here, but certainly want to give everybody the opportunity to speak, and knowing that they've been waiting here with us all day. So we'll go through the witnesses now. Thank you, Mr. Cooper.
Thank you, Mr. Chairman, for the opportunity to lay it out.
Yes, sir. Chair calls Tammy Brown Rodriguez. I have you registered as Tammy Brown Rodriguez, representing yourself, and pronounce it for me, Jacob.
Yes, and Yaku Boyens Ministries.
That one.
Yes.
In favor of House Bill 17, is that correct?
Absolutely.
Okay, go ahead and begin your testimony. Thank you.
I've been a resident of Texas for almost 30 years, and in Dallas in the last 5 years, the crime rate has been out of control. And so for us personally, my home, my family, our house has been broken into, our car has been stolen, our other house has been vandalized, and nothing was done. Because our DA in Dallas County is not doing anything. It is an absolute absurdity that as a business owner, our salon could have $750 of items stolen every single day, and there not be prosecution. And to the point where we see people all the time doing smash and grabs, because it's almost the rule of law has been completely ignored. And I know that you know this, but our DA did take an oath of office, which said that he would swear to defend the Constitution of the United States and Texas laws. And how can you not prosecute crime under $700 if it's less than $750? How am I supposed to teach my kids about the rule of law, what is right and what is wrong? How do we in the community really feel secure and protected? We don't. And then, of course, that trickles down to our police. And our police officers are demoralized and frustrated as well. I worked with the Community Police Oversight Board for 2.5 years, and I saw firsthand what happens. We have to support this bill. It has to go through. And from the Yaku Boyens perspective, I'm the new policy, I'm the new director of policy, and you know that sex crimes, only 1% of sex crimes are reported. And out of that 1% of sex crimes that are reported, a very small percent are prosecuted. That has to stop. You saw here today what happened. This is an absolute horrific situation in Dallas County, and we have got to uphold the rule of law, not only for our children, not only for our business, not only for the great state of Texas, but how do we delineate between the three branches of government if our DAs are taking a broad stroke and deciding for themselves specifically what class of laws they're going to abide by and they're going to prosecute? My father was a police officer. I cannot imagine him trying to tell me, well, it's okay if you could steal, just $740. This is just unimaginable. And for me to have to be here today as a concerned citizen, this bill, the time has come. We have absolutely have to get this passed. So I know the great work you've been doing, and I appreciate it. Continue the good job, and thank you so much for the consideration of moving this bill. Thank you.
Thank you. Members, do we have, hold on real quick. Come on back. Unfortunately, we get to ask you questions.
All right.
Representative Schatzline.
Thank you, Mr. Chairman. I know Yaco very well and what you guys have done. If you don't know, committee, they are massive advocates for anti-human trafficking efforts, and they've helped our organization in a big way. I just had a question to follow up on what has been the response when talking to law enforcement in Dallas County? Are they, when you say they're demoralized, what have been some of the conversations you've had?
Well, it's been 2 interesting seasons. One, it was under Chief Hall, and there was a lot of frustration. They didn't feel like they could speak freely to us about the situation. I was on ride-alongs. We watched call intakes through the dispatch where there simply weren't enough police. And the police were very specific on what they would respond to, because they knew if they took the time to go ahead and respond to that call and they would have to bring that person in, they're off their beat for 4 hours to 6 hours. And we don't have the manpower to sustain that. So they took specific discretion, and then that puts us at risk. So the police officers were very demoralized. We had an absolute flood of them leave Dallas County and go work for other areas, because other areas, they knew that their time was treasured, and the hard work that they put in and the fact that they're risking their life in order to keep us safe would be honored by other DAs.
Thank you.
Anything else?
Do you have any other questions? No. Thank you very much.
All right, thank you.
Appreciate you spending time with us. Thomas Villarreal. Have you registered as Thomas Villarreal, representing yourself and the Austin Police Association in support of House Bill 17. Is that all correct?
Yes, sir.
All right, go ahead and begin your testimony.
Yes, sir. Good evening. My name is Thomas Villarreal. I'm the president of the Austin Police Association, and I'm here speaking on behalf of the 1,500 working cops who are left at our agency. I'm here speaking in favor of HB 17. Since winning election and taking office in January of 2021, the Travis County District Attorney has actively worked to interfere with Austin police officers' abilities to file probable cause affidavits. Soon after taking office, the DA's office began taking probable cause affidavits before they're presented to a judge and reviewing them to see if the DA's office was going to allow them to even be seen. On top of this being wholly improper, it also most likely runs afoul of the Texas Code of Criminal Procedure 15.17, duties of arresting officer and magistrate, which requires an arrested party to be taken before a magistrate to be informed of the accusation against him and any affidavit filed therewith. In essence, with this policy, the DA's office is wholesale rejecting probable cause affidavits that charge people with various crimes. A quick look into the list of crimes that have been intercepted and or dropped without any stated reason include felony assault, family violence, aggravated assault, family violence, terroristic threat, felony prostitution, possession of controlled substance, tampering with evidence, evading a vehicle, harassment of a peace officer, and auto theft. I'm sure there are more crimes the DA's office is categorically rejecting. These are just a few that seem to come up more than once on a list of rejected probable cause affidavits that I've been made aware of. It's also very interesting that a similar trend can be seen in the county attorney's office as well. In 2022, the county attorney's office of Travis County dismissed dozens of criminal trespass, failure to identify, and evading cases with no feedback as to why they were not prosecuting these cases. With this behavior, the county attorney's office has essentially taken upon itself to decriminalize these certain offenses in Travis County. Thank you very much. This problem needs to be addressed. Mr. Cook, I appreciate you working on this bill. I appreciate you taking time to meet with us the other day on it. And I thank each and every one of you for your service today in Texas. And I appreciate the opportunity to speak today.
And it's the first time you made reference to the cases being dismissed out of the county attorney's office. And when I worked as a prosecutor, I guess it was before technology, where we had there was 7 sheets that you'd sign the dismissal on, and you'd have to check a box, I'm dismissing for X, Y, or Z reason, anything like that. When they dismiss those cases like that, and they file their motion to dismiss, were they citing any reason in the motion to dismiss, or what did they state?
So I've been made aware of a list of affidavits that are rejected. If there's reasons for the rejection, there's a spot in this list for notes. And
you're talking about, like, these weren't, you had mentioned the pending cases. There were pending cases, like maybe when the new county attorney came in and they just like wholesale dismissed them.
No, sir, I didn't say anything about pending cases.
These are this is before they come forward. This is the probable cause affidavit that they're just.
These are probable cause affidavits.
I thought I heard something else. I want to make sure, because if they filed dismissal on pending cases, I'd like to get after what was the reasoning that they stated for that.
No, so
I misheard. I apologize.
Yeah, we've got just probable cause affidavits that are being rejected and we're not getting any feedback as to why.
No feedback to officers about reason for
absolutely
rejection of those. Aside from the other procedural issues, no communication. And you said that's happening both at the district level and at the county level?
Yes, sir, just different offenses.
Got it. Okay, thank you very much. I appreciate it. Sorry for the confusion. Members, do we have any other questions? Yes, yeah, sorry. Chairman
Yes,
Darby.
thank you for being here.
Yes, sir.
You just in your testimony, you talked about a myriad of different offenses.
Yes, sir.
And I guess I'm looking at the language of the bill, and the bill ties this effort to the prosecuting attorney's adoption or enforcement of a policy by refusing to prosecute certain conduct. I guess the question is, absent a proclamation or a written policy, a public statement, or a directive to subordinate attorneys, how do you just outline a myriad of offenses that they have chosen not to move forward with prosecution? And I guess I'm just I support the concept, but I'm having trouble trying to define it statutorily, that conduct, because, again, absent a proclamation or a written policy,
yes, sir,
or a direction to the police officers, don't go stop these people. You haven't told me about that or told us about that. So how would an action move forward against the prosecuting attorney absent all of those factors, because there's just no consistent policy? They just have chosen not to prosecute.
Yeah, I think and I'm just a silly old street cop, but I think one thing that you could do is you could look at percentage of cases that are being pushed forward at all, right? If 0% of cases on criminal trespass in the county are moving forward because, for whatever reason, I think we could pretty much say, whether it's formal policy or informal policy, that we've decriminalized criminal trespass. I think if somebody's in a district attorney's office, if the only cases that are making it to jury trial are cases against police officers, I think we could surmise that, we're not pushing these other cases forward. I do think that you could look at, and here's the sad thing, like, I've got a copy of a memo from the judges that all Travis County judges signed, but like, it's been so silly in Travis County that some of these things are being put in orders to subordinates. They are being put on paper and dispersed out to employees, giving them direction on what to do and what not to do. But absent that, if that's not the case moving forward in the future, I think it would be completely reasonable to just look and see, like, if 0 criminal trespass cases are being prosecuted, if 0, as someone previously testified to, if 0 cases of theft under $750 are being prosecuted, I think it's a reasonable argument for somebody to make.
Yeah, but that's an argument for somebody to make, but we're trying to define it statutorily. But there's been no order to the 1,500 police officers to not stop people for criminal trespass.
That is correct, sir. Yeah, and that's actually been
no order to stop
point of contention here.
Stopping people for XYZ offense.
There's been no order. No, sir. The problem becomes if I'm going to be tied up for 2 to 4 hours arresting somebody for criminal trespass, because that's just the process in Travis County, at some point with reduced resources, your working class police officers are going to stop doing certain things because it's not a good use of their time and energy, understanding that that person is never going to be prosecuted. That probable cause.
I'm not suggesting that that action should not be prosecuted. What I am suggesting is is it a matter for this legislature to determine when a prosecutor should be removed for just failure to do his job, or is that a matter for the voters who elected the prosecuting attorney for failing to administer the laws of their city or their county or their state? I mean, I'm just absent of, if we have a proclamation or an order, that's one thing. But absent that, I see a very difficult road to go down in trying to give rise to a cause of action for removal. Again, considering the constitutional implications of free speech, absent an order or proclamation or directive. So that's just mine. And maybe other witnesses can illuminate me and others. So, thank you.
Chairman Leach.
So to follow up on Chairman Darby's comments, the way I look at it is there are actions of commission and there are actions of omission. There are certain acts that I can take. I can commit certain acts as a prosecutor that would be classified as official misconduct. So I'm doing something. I'm issuing a statement that is official misconduct. But in your case, you're talking about an act of omission, and so I'm neglecting my duty. I am refusing to do my job, and I think both should be treated as grounds for removal. But we've got to be very careful about how we craft it. I would actually argue that what the Travis County DA has done in your instance, which I completely disagree with, is already covered by the existing statute: an intentional or corrupt failure, refusal, or neglect of an officer to perform a duty. He's neglecting to do his duty to prosecute. What I want to make sure that this does is whether because he could just say, well, okay, we're going to keep the same policy and just not issue a statement, but he's still neglecting to do his duty. If a police officer, if law enforcement, if you neglect to do your job, and we've seen some horrific examples in recent memory in Texas where police officers have gotten to the scene of an awful crime and have refused to do their job. They have refused to do their job. They showed up, they didn't necessarily do anything, but their act of not doing anything was, and there are internal affairs divisions, as you well know. There's public oversight. There's the Texas Commission on Law Enforcement. There is public oversight that holds police officers responsible. Judges have public oversight. And what public oversight is there over prosecutors, not only for acts that they commit, but acts they omit, things that they don't do. And that's what I want to make sure that this covers. I'm not sure that the new language here changes anything for the Austin Police Department. Could be wrong, but I'll defer to the author of the bill on that.
Okay. Any questions? Other questions, members? No.
Thanks, sir.
I appreciate your time. Yes. Thank you. Chair calls Jennifer Szymanski. And I have you registered as Jennifer Szymanski, representing the Combined Law Enforcement Associations of Texas, also known as CLEAT, in favor of House Bill 17. Is that all correct?
That's correct.
All right.
Good evening, Chairman, Vice Chair Cook, and members of the committee. I'm Jennifer Szymanski, Director of Public Affairs for CLEAT, the Combined Law Enforcement Associations of Texas, testifying in support of House Bill 17. We're representing over 27,000 officers and deputies across the state. for large major cities, large urban counties, and other smaller associations as well. Several of our major cities across the state are facing a public safety crisis. Today, I'll focus my testimony on Austin and the district attorney, who's played a major role in the destruction of the Austin Police Department. A district attorney who ran a campaign on prosecuting cops and letting criminals roam free is our reality. And he's living up to this promise as he has indicted 19 Austin police officers on first-degree felony charges. Those officers are facing life in prison for defending police headquarters and Interstate I-35 during the 2020 riots. The spike in crime and mass officer resignations are a direct result of willful neglect to prosecute certain offenses, such as theft, narcotics, firearms violations, etc. Peace officers are sworn to uphold the law and place themselves in harm's way every day to do just that, only for the district attorney to follow behind them and release suspects, sometimes even before the officer can get back into sector, because they don't believe certain offenses should be illegal, or they'd rather focus their efforts on prosecuting police officers. In Travis County, we have a district attorney who entered into a standing order agreement with the district judges, filed in district court to release suspects prior to magistration on certain charges they have determined they will not prosecute across the board. Every morning, police executives across this county receive a list of suspects released under these conditions. Just to review, the list are charges dropped, and they have nothing to do with probable cause. They're dropped prior to magistration, a very short time after booking takes place. I'm not sure how an officer should be expected to operate under such conditions. The Travis County DA is not alone in his attempt to ignore the laws of the state. The open declaration of certain offenses not being prosecuted is occurring in multiple counties and has been for quite some time. We'll do everything in our power to support this bill, and we look forward to its passage. And we appreciate the vice chair and those who signed on to the bill as well. Hopefully I answered at least one question that came out, which was there is more than just, there is evidence of this. It's very clear. There are emails, plenty of them, between the district attorney in Travis County and police agencies across the county. And the list I just mentioned, it's emailed out every morning to all of the police agencies inside of Travis County who had an arrest the previous night or day that fall under this category, which is a preliminary review, if you will. And the reason we know, Representative Darby, that it's very specific is not only because they emailed out the executives what they were not going to prosecute when they were elected, but they also, when you look at the list, it's those offenses that they said they weren't going to prosecute. So it's very clear, and the evidence is there. There's multiple pieces of evidence to this. So hopefully that answered your question.
No, thank you very much.
That was all I have. Thank you.
Hold on. Do you have any other questions, members? No, thank you very much.
Thank you.
Appreciate your time. Chair calls John Wilkerson. I have you registered as John Wilkerson, representing the Texas Municipal Police Association, otherwise known as TMPA, for House Bill 17. Is that all correct?
That is correct, Mr. Chairman.
Go ahead and begin your testimony.
Chairman and committee members, I want to thank you for the opportunity to hear this bill. If you know anything about me, you know when I come up here and testify, I try to make it about the conversation piece that's going on. I like to listen to the questions that the committee members have to be a better resource on there. So we've been prioritizing this issue for quite some time now. We've seen it as an issue that's going on around the state. I know our Deputy Executive Director has talked to Chairman Leach about this. Then also with Vice Chair Cook. So this is a big issue for us. And what I want to talk about just for a quick second is the other side of this conversation. And the first witness that came up and testified, Representative Shetland, you asked her what it does to the officers. I would like you to think about this concept. Let's say that you're here 8, 10, 12 hours a day, sitting right here, and all you're doing is taking testimony, hearing the same thing, broken record, broken record, broken record, and you know you can't do anything about it because there's somebody that's calling the shots over your head, what would your morale be like at the end of the week? That's what we're facing out there in law enforcement. Aside from the increased crime rate that we've seen in other states, that is an aspect that we do have to be mindful of, and that's what we're getting from our members. We represent a little over 32,000 members across the state in all different departments, and those are things that we hear on a day-to-day basis. I also want to, Chairman Darby, you asked a great question, and I cannot express how much we value your feedback on this because we understand where you're coming from, and we agree with a lot of it. And just to be clear, we believe that prosecutors need to have their discretion. We respect that, and we know that most prosecutors out there are really good prosecutors that are operating within the confines of the oath that they took. But some of the testimony that you've already heard, it's very clear that they're violating that oath. It's very clear that they're going above and beyond that. And I understand, Chairman Darby, that one of your concerns is it up to the legislative body to decide this? I've actually seen one of these happen, not with a prosecutor, but with the JP. I'm still a deputy sheriff in Bell County, and I saw a removal of somebody. And what I would ask you to keep in mind is at the end of the day, it's the voters that decide. It's the jury that decides what happens. And as I wrap up, I'd like to remind the committee we're in full support of this bill. We would ask that 3 very important additions are considered with this, and I apologize to the vice chair. I was trying to get by there to talk about it. But one, if a prosecutor is removed from an office, we believe that there should be a prohibition on that prosecutor running for office for a period of time. They should not even be able to go on a ballot. They cannot run for it. They shouldn't be able to run for it, and they shouldn't be appointed. Also, the removal under this statute can take several years, so we would like to see an expedited process that says, okay, district court, this is a priority for you now. You need to get this sucker done and over with. In Bell County, when the JP was removed, from the time that it was filed, I think it was like 3 years before that JP was removed. So we would ask that. And then lastly, if you're keeping up with news, you'll notice that the Nueces County DA, this provision has been invoked on the Nueces County District Attorney. And the Nueces County District Attorney appeared in the Commissioner's Court asking the taxpayers to flip the bill for their legal fees. So we don't think that the taxpayers should be paying for the legal fees that are associated with the DA that's going for removal on this. So we would ask that that's taken into consideration as well. Thank you for your time, and I'm more than willing to answer any questions.
John, thank you. I appreciate that. Thank you for highlighting these 3 extra provisions as well. I guess every case is different in the way it moves, and we didn't, certainly in El Paso, didn't have any issue moving that it moved very rapidly, and that included recusals and giving the county attorney time to decide on whether she's going to move forward with the case or not. And so I think it was, maybe 6 months from petition to resignation. So again, everything's different, but that's so maybe that's something to look at, and I appreciate you raising it.
Yes, sir.
The other, the last one about, and we encountered this issue. The district attorney at the time in El Paso went to the Commissioner's Court, asked for the Commissioner's Court to foot the legal bills to defend the removal action. The Commissioner's Court actually penned it. I'm not trying to remember what they functionally did. They did not agree to do it. I think I kind of said penned it later. They didn't know if they legally were permitted to do it. Let's say she goes through the action. I think the question that started coming, I watched most of the Commissioner's Court meeting. That's what I do in my spare time. I think they were saying, well, let's say the removal action goes forward and she's not removed. She's vindicated. Jury finds that she didn't commit official misconduct. Well, then should her fees looking backward be covered if she wasn't found? Well, I mean, that's a different question. If she is, then, and so they essentially kind of said, I don't think this issue is right for us to discuss right now, but it is something that came up immediately in this matter. And like I said, I've said before, and it was very apparent in the litigation there in El Paso, was I think her inability to cover her own legal costs was a big reason for the resignation. And so, so I think you raise a very good point here. So I appreciate you touching on all three of those.
Mr. Chairman, can I respond to your,
Which part
the
of it?
last conversation we just had about the lawyer fees being involved?
Sure.
Keep in mind, under that statute, when that petition is turned in and it goes to the judge, that judge can require the person who filed that petition to issue a bond.
They can post
that's
bond on it.
sufficient to cover the legal fees of the person. So, just don't have any input on that. Just wanted to make sure everybody was aware of that. So.
Oh yeah.
Wait. Sorry.
Chairman Lee.
Sorry, Chairman. So I'm sorry, just so I can clarify, you're saying this, that the person who's bringing the complaint has to put up a bond to cover the attorney's fees of the person they're complaining about?
No, the
judge could order that.
The judge can order the.
And what if the person bringing the complaint is not able to put up a bond?
I don't know that I've seen that, and I don't know that I've read what the disposition is.
Yeah, and they didn't require it in ours, but yeah, it is one of the things they can ask them to post bond in the event that the suit is, I guess, I don't know maybe someone can comment on that later. I don't know the nuances of it, but it is one of the things the judge can do in that case. Members, any other questions? No? John, thank you very much.
Thank you, Chairman. Committee members.
Let's see. Chair calls Matt Makoviak. Have you registered as Matt Makoviak, testifying on behalf of yourself and in support of House Bill 17? Is that all correct?
Yes, Chair.
Okay, and proceed.
Thank you, Chairman. Thank you, Vice Chairman, and other members of the committee. Here today as an advocate for improving public safety, not just in Travis County where I reside, but also across the state of Texas. Had some good points brought up here so far. Appreciate the opportunity to talk about this bill and why it's so important. My guess is you have 240 or 240 district attorneys, and for that matter, county attorneys around the state that are going to have absolutely no problem with this if this is ultimately passed by the legislature and signed by the governor. You have in 5 or 10 counties individuals who are literally giving the middle finger to the legislature. They are telling the legislature, thank you for your suggestions of what things should be illegal in our state, but I have the right as the king of whatever county I reside in to decide what things I'm going to enforce and what things I am not going to enforce. Every single member of the Texas legislature should be irate at what is happening in Harris County and Dallas County and Bexar County and Travis County and a handful of others. So to answer Chairman Darby's question, this bill does not allow the legislature to remove someone. It creates a removal process for official misconduct as it is defined by the bill. There is a very real consequence when a prosecutor, either as a candidate or as a newly elected official, says they are not going to prosecute a specific type of crime. Not only is that a policy going forward, but it is also a signal to anyone in that county and really anyone that can enter that county that it is open season on whatever that class of crime is that is no longer going to be prosecuted. And as some of the witnesses have said, in Travis County, as an example, we have a district attorney and a county attorney who have basically run together on this agenda, who have decided not to prosecute petty theft of up to $750, sex work, criminal mischief, specific property crimes. And predictably, those crimes have now increased, and we're seeing them time and time again. It's great to hear from these two law enforcement officials about what this has done to police officers. There is absolutely no question that it has had a chilling effect on police officers as it relates to the class of crimes that these prosecuting attorneys are simply not prosecuting. Why would you go put yourself at risk in every way that you can be at risk to go arrest someone for a crime that will never lead to a conviction? That literally breaks the bond that has to exist between a prosecuting attorney and a police department. Without them working together in partnership, public safety is irreparably harmed. This is a bill that ought to pass on a unanimous basis. I'm not naive enough to think that'll happen, but I certainly hope and expect it can pass on a bipartisan basis. In fact, an overwhelming bipartisan basis in the House and the Senate. Thank you for the time.
Thank you, Matt. Members who have any questions? Thank you very much. Chair calls Amanda Rios. Amanda Rios. Okay, we'll change her to not testifying. Chair calls Cleo Patricic. Yes. Did I get that right? Yes, sir. That was blind luck. Okay, that's how you registered as testifying for yourself and in support of House Bill 17. Is that all correct? Okay, go ahead and begin your testimony.
Thank you, Chairman and respective members, for bringing this legislation forward. My name is Cleo Patricic, and I'm a resident here in Austin, and I'm in support of this bill. I grew up in South Dallas. My parents are Mexican immigrants. Crime was a constant in my life growing up. My best friend was shot in the back in front of me when I was in middle school. Now in Austin, I'm a part of Save Austin Now, which we advocate for victims of crime and just to restore safety back to Austin. I'm also a Democrat. Since taking office in 2021, Travis County DA Jose Garza office has been neglectful towards the numerous victims of crime in our community. I support accountability for all levels of government. Negligent prosecuting attorneys should be held accountable, especially when they make press statements that they will not prosecute certain crimes. I understand prosecuting attorneys can exercise discretion on a case-by-case basis, but stating publicly that they will not prosecute a mass amount of crimes is unacceptable. DA Garza appears to have great enthusiasm for chasing police officers, but little interest in chasing criminals terrorizing our city. He is seemingly ideologically unable to accept the notion that criminal behavior is a choice over which the individual has control. His clear preference is to utilize his power and discretion to excuse chaos and criminal behavior. This bill will provide a necessary check on any prosecuting attorney's ability to allow personal ideology to unduly influence the execution of their duty. There must be a checks and balance installed to ensure the effectiveness of a prosecuting attorney. The laws of Texas must be enforced, and the judicial system must protect victims of crime and hold those breaking the laws accountable for their actions. This is about serving justice, not political ideology or personal agendas. Thank you all.
Thank you very much. Members, do we have questions? No, thank you. Chair calls Dane Wilkins. I have you registered as Dane Wilkins, testifying on behalf of yourself in support of House Bill 17. Is that all correct?
That is all correct.
Okay, go ahead and begin your testimony.
Well, first I'd like to thank you for this opportunity. It's really been kind of a pleasure to be able to see how the inner workings of the state that you've been living in forever functions. So it's been a pleasure. I guess I'm just kind of here to give you guys a little window into what it's like to be a Travis County resident. A little bit about me, though. I'm a fifth-generation Texan. My family goes back pretty far back. I'm from Midland, and we're West Texas people, so we're just a little bit different, I'd say, than the East Texas folks or those here in the central part. But whenever I decided to make the move out here, folks told me not really to make that because it really wasn't too safe, and they were, I guess, kind of right at this point. You know, coming from the background that I have, me and my three brothers were all Eagle Scouts, and, you know, I actually teach the country dancing class at my church, and I like to keep myself upstanding, and I don't like to look down on other folks who are not necessarily well off in this town. And I mean really the homeless folks. So as this problem with our laws not being enforced has grown, I've been watching it for the last couple of years while living here. In 2020, Christmas Eve, I was going to go back to see the folks, and my vehicle got burglarized. 2021, I had a vehicle that I had that I'd driven since high school, was restoring it. My aunt had just deceased and left me some money, so I dumped that into it. That was stolen from me as well. I guess I probably wouldn't even be here if about 2 weeks ago during South by, I showed up to go to a networking event. I do real estate, and there's one that showed up, so I wanted to make sure I went to that. This is over on Rainy. It was noon, middle of the day. I park, the one thing that I basically used to get around town now because my vehicle was stolen, there's an electric bike outside of it. And I hear someone messing with it, so I go outside, and there's a homeless person who's looking to steal this thing. So I go and inform him that it's not his property and that he needs to leave it alone. At which point he looks at me and says, "This is my bike." We have a very serious issue at this point. I try to wheel it away from him to move it closer to the location I'm at. This is right over in front of 70 Raining, at which point he tries to grab the bike. We have an altercation, and he pulls out a very long piece of steel, informing me that it is his bike. Now, if I was armed, like I sometimes am as I walk these streets now, and am more often, I would assume that lethal force would have come into this situation. This is not a light situation. Coming from a small West Texas town, this is not what I expect my capital to be like. In reality, the cops were able to show up. People were able to see what was going on, but this was still noon. This man himself had several warrants out for his arrest. He should not have been out on the streets. We should not have had that altercation. This is just one sign, and I sit here all day because I want to be able to share that with the people who represent us, because I'm just one person, but I know that my story represents thousands of other people. And if I can spend what freedom I have to be able to come here and share that experience with you guys, then that's what I can do. I do real estate, so I have to learn city code, and normally this is not the council that I'm in front of, it's normally city councils. But it's still the same. We have representatives, and we would like to be able to be properly represented. And anything that we can do as a people to be able to come and help exercise our freedoms is, we're willing to do it. I know this is probably just the beginning, so thank you for your time. I appreciate you guys a lot.
Thank you, Mr. Wilkins. I appreciate you sharing your testimony with us and taking the time to be here all day. I know it's been a long day. Members, do you have any questions for Mr. Wilkins? Yes, Ms. Bowers.
Thank you, Mr. Chairman, and thank you, Mr. Wilkins. So you testified for the bill, right?
Correct. I am for the bill.
Okay, and so I guess my question just has to do with if you really believe that this is the answer to fighting crime and to keeping people from stealing your possessions.
Well, realistically, what will really stop that is to have a strong social network, which is deteriorating rapidly in this country. I think that the best avenue to be able to actually do that would be to enforce the laws. And if you disagree with the laws, you go through the due process to change those laws. That's why we have them. The police officer who was able to assist me, or at least one of the group, told me that with the current state of affairs, these are more of suggestion enforcers, not law enforcers.
Oh, excuse me, who are suggestion enforcers, not law enforcers?
The police department.
I have family in law enforcement in Harris County and in HPD, and they don't take their job as suggestion enforcers. They do believe that they're law enforcers. And I'm just wondering if you feel like this is the answer to stopping crime.
So I believe in a very powerfully the word subsidiarity. And so I believe that having a jury that does convict a DA for not doing, or a DA or the county judge, or the county attorney as well, for not doing their job, I think that is probably the best move forward. I don't think that it needs to be from a governor or someone higher up. I believe that it needs to be the local people who actually make that kind of a judgment call.
So the citizens, you believe the citizens should make the decision, correct?
Based upon the avenues that have already been laid out.
Which are voting.
Through recall.
So recall, not through voting them out, or you don't believe in the process of our democracy?
I believe that the process of democracy can elect individuals that are not fit for the job And whenever that happens,
Well, how does that happen, that they elect individuals that are not fit for the job?
people can have a silver tongue. And if that is the case, then they need to have avenues to be able to recall those individuals. And then the people who decide should be the people.
So the avenue would not be to, I didn't mean to cut you off, because you're certainly answering my questions, but would it not be waiting until the next election?
Not if things are as bad as they are. Things can escalate quickly, and they have. I've seen them.
I'm not denying that. We have to stay here too, so I get what you're saying.
Correct, right.
And I appreciate it. But do you not believe that DAs and CAs are voted in?
Well, I do believe that they are voted in, yes.
And you believe that there should be an entity, whether that's a governing body, that should just be able to remove them?
There needs to be a due process to be able to remove them. That's essentially what this is. This bill, in my understanding, is helping reinforce is that, and it also having oversight from other DAs and CAs, depending on that. But I would actually also add to that I believe that having a DA or a CA from not a neighboring county preside over that would be an amendment I would add to that, just because of the geographic relevance. I think could add some sort of controversy. This is a big state, so maybe Harris County doesn't need to have the county next to it talking about it. I think that would help add a little to the.
So even if the county is smaller than the county, the neighboring county?
The size is not necessarily relevant in the jurisdictional, in my opinion, of course. I believe it's just based upon their actual performance. Surely,
but if a county is like an urban area like Dallas or Houston, then you can't have, I think we had someone from Bell County. I lived in all three of those counties. You can't have someone from Bell County necessarily dictate what goes on in a larger county like Dallas or Houston.
Correct. So those checks and balances exist. Now, it would be based upon the DA's district, correct? So if that person from Bell County is within that district attorney's jurisdiction, then they should be within their rights to be able to form a recall if they need to, because they're affected by that DA.
Do you have examples to give for your process?
In this bill specifically?
No, your process, what you think.
Sure.
Because I certainly will have a conversation with Vice Chair Cook, because I respect him just as I respect you, but I'm asking you what your process is, since you're saying that you think this is the answer, right?
Correct.
Okay. Thank you very much.
Thank you, Representative Bowers. Okay. Chair calls is Rupal Chadari. Please correct me, or did I do okay?
Very good.
C minus. That's how I have you registered. I have you testifying on behalf of yourself in support of HB 17. Is that all correct?
That is correct.
Perfect. Go ahead and begin your testimony.
Good evening, Chairman, Vice Chairman, and all the committee members. I do want to thank Representative Cook for introducing this bill. But before I move forward, I do want to thank each one of you, how attentive you have been the whole day listening to each bill after bill and everybody who's testifying. I'm Rupal Chaudhary, and I'm a resident of Travis County, and I'm also a business operator, but in a different county, in Williamson County. I am for House Bill 17. Representative Cook touched upon it. There is a huge difference between prosecutors' discretion versus issuing a blanket statement, not to prosecute a crime. And I believe we got in a discussion of oath and First Amendment right. A prosecutor who takes an oath to office saying, I will uphold the law, how can he go ahead and hide? I mean, this is not the discussion out here for First Amendment, and I understand it is beyond it, but he's basically hiding, a prosecutor would be hiding behind First Amendment speech and issuing a blanket statement. But what it does, it sends a signal by issuing that blanket statement that we are open to certain crimes which completely defeats the concept of deterrence. When you add defund the police to this madness, it creates a perfect storm where the criminals are more emboldened each day and not afraid of consequences. Watching the decay of California into lawlessness should be a wake-up call to all of us. We should not import the worst policies of other cities to Texas. Thank you very much.
Thank you very much. Members, do we have any questions? No. Thank you for your time.
Thank you.
Chair calls Chantel, is it Pridgun? 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 Okay, we'll change her to not testifying. Chair calls Bethany Carson. Bethany Carson. We will change her to not testifying. Diego Ruiz. Diego Ruiz. Change him to not testifying. Ranisha Ship. Ranisha Ship. Okay, we'll change her to not testifying. Chair calls Rebecca Parma. I have you registered as Rebecca Parma, testifying on behalf of Texas Right to Life in favor of House Bill 17. Is that all correct?
That's correct.
Okay, go ahead and begin your testimony.
All right. Thank you, Chairman Moody and members, for allowing me to testify before you today. My name is Rebecca Parma, and I serve as the Legislative Director for Texas Right to Life. I am testifying today in support of House Bill 17. Leading up to the Dobbs decision, district attorneys and attorneys general across the country released a letter signaling their intent not to enforce pro-life laws, even if Roe v. Wade was overturned. Since that decision was overturned last summer, we have had 5 Texas district attorneys release public statements declaring that they will categorically refuse to enforce pro-life laws that this legislature duly enacted. District attorneys appropriately have discretion over whether to prosecute case by case. However, they do not have authority to adopt sweeping policies that have the effect of subverting the lawmaking authority of the legislature. By issuing such far-reaching statements, these individuals are refusing to do their jobs of enforcing laws passed by you, the legislature. They have proved themselves unreliable and are putting lives at risk. District attorneys need to be held accountable for and disincentivized from issuing such blanket statements. We support House Bill 17 as one method of holding such lawless district attorneys accountable. This bill adds to the definition of official misconduct the adoption or implementation of district attorneys' policies under which they prohibit or materially limit the enforcement of any criminal offense, including violations of pro-life laws. Such an action of official misconduct is subject to petition for removal. Texas Right to Life believes we must not only hold district attorneys accountable to doing their jobs, but also have tools to go around them to ensure our life-saving laws are fully enforced. This bill helps to further the first goal. The legislature is in a unique moment in this first session post-Roe. We must not let flagrant neglect of our laws become the status quo or undercut the gains that have been made. We thank Speaker Phelan for recognizing this as a priority and Vice Chair Cook for carrying this bill. We look forward to your favorable consideration of HB 17. Thank you for your time, and I'm happy to answer any questions.
Okay, thank you very much, Rebecca. Thank you for taking your time to be here. Members, do you have any questions for Rebecca? Thank you very much. Okay, stay on this theme. I just don't know how to pronounce the last name. Is Dr. Joe, is it Homan? Hoyman? Okay, got it. Dr. Joe Hoyman I have you registered as such, representing Texas Alliance for Life in favor of House Bill 17. Is that all correct?
That's correct. Thank you,
All right,
Mr.
Dr.
Chairman.
Poyman, go ahead and.
My name is Dr. Joe Poyman. I'm Executive Director of Texas Alliance for Life. We strongly support House Bill 17, and we thank Representative Cook for authoring it. This bill successfully addresses a problem created by a small number of district attorneys in our state that we believe should be called a dereliction of duty. We completely understand and appreciate the principle of prosecutorial discretion. Necessitated by limited resources or the goal of achieving justice in individual cases, prosecutors will naturally prioritize prosecuting offenses on a case-by-case basis. However, a prosecutor should never categorically limit or prohibit the enforcement of a particular criminal offense, unless ordered by a court. Offenses are created by the legislature with the understanding that criminal laws are to be enforced, not ignored by police and prosecutors. However, we're seeing a substantial problem from a small number of district attorneys who, by the way, happen to be from some of the largest counties in Texas. 5 district attorneys have published a very disturbing statement that they intend to completely and categorically ignore all felony laws passed by this legislature to protect unborn children and their mothers from abortion, even abortions on babies very late in pregnancy up to birth. This is very disturbing to us, and we think it should be disturbing to everyone, regardless of how he or she feels about those particular pro-life laws. The shoe can be easily on the other foot. We have heard and appreciate the argument that prosecutors are accountable to the voters in their districts and are up for re-election every 4 years. While this is certainly true, that statement gives us little comfort when the general statute of limitations for felony offenses is only 3 years. Thank you.
All right. Thank you, Dr. Poyman. Do we have any questions? No, thank you. Chair calls Kylene Wright. I have you registered as Kylene Wright, representing yourself and Texans for Life Committee for House Bill 17. Is that all correct?
That is all correct.
Perfect. All right, go ahead with your testimony.
Thank you. And following up on some of the testimony we've already heard about some of these blanket statements, on May 3rd of last year, the Bexar County District Attorney Joe Gonzalez was quoted by Texas Public Radio as saying he absolutely will not prosecute anyone involved with an abortion in Bexar County. When told this is in stark contrast to the positions of the Attorney General Ken Paxton and Governor Greg Abbott, he said he does not work for them. The only boss I have are the citizens of Bexar County. The only boss I have are the people standing here, the voters, he said. They make the decision about whether or not I'm doing the right job. I'm not worried about Ken Paxton. I'm not worried about Governor Abbott or anybody else in Austin. That's you. On June 24th, the day Dobbs was handed down, KSAT quoted him again as saying, while every prosecutor has a legal obligation to comply with the law, he doesn't plan to prosecute abortion cases, quote, barring extreme circumstances like someone being forced to have an abortion against their will. Travis County's District Attorney Joe Garza was quoted on April 24th of last year as saying, we are very focused on holding accountable people who commit acts of violence in our community. He said, pulling resources away from that to focus on this kind of case would be reckless and endanger the safety of our community. On June 24th of last year, the Caller Times reported on the Nueces County District Attorney. More than 2 months before the Dobbs decision was handed down, Mark Gonzalez, alongside 4 other big city Texas district attorneys, released a public statement condemning efforts to criminalize abortion and pledging not to prosecute personal health care decisions. And he later confirmed to the paper that he intends to stand by that pledge. As you heard, 5 district attorneys signed on to the joint statement from elected prosecutors, originally published in May after the Supreme Court draft leak, and then published again the day Dobbs was handed down in June and updated on July 25th. These 5 district attorneys hail from Dallas, Travis, Bexar, Nueces, and Fort Bend counties. and they have not retracted their pledges to not prosecute. This is a violation of each district attorney's oath of office, and furthermore, it discourages, as we've heard already, other officers of the court and law enforcement from keeping their oaths. Even Dallas Police Chief Eddie Garcia testified as much to the Dallas City Council when they were considering a resolution directing police and others to deprioritize abortion cases. Cities and counties and district attorneys are not islands unto themselves and should not be allowed to thumb their noses at the Texas legislature and the duly enacted laws of this state. If prosecutors thumb their noses at the law, how much more so will others follow their lead? I think you've heard a lot about how that is already going on with crime. It sets the tone from very high up, and I urge the committee to support this bill.
Kylene, thank you so much for your testimony. Make sure, any questions, members? No? Thank you. Joel McNew. Chair calls Joel McNew. I have you testifying on behalf of yourself and Safe Horns for House Bill 17. Is that correct?
Correct.
Okay, go ahead and begin your testimony.
Thank you, Chairman and respective members, for bringing this legislation, sorry, it's been a long day, forward.
You are correct.
I am Joelle McNew, president of Safe Horns, a nonprofit that advocates for safety on and around the University of Texas at Austin. We are for House Bill 17. We monitor crime committed on UT Austin campus and the surrounding campus community. Our research indicates that neither County Attorney Garza or District Attorney Garza pursue charges on crimes committed. Almost all misdemeanor charges are blanket dismissed or rejected within 24 hours of booking, and those criminals return to our area many times to re-victimize members of our campus community multiple times. One offender with more than 75 arrests and only one charge that was prosecuted. Public safety is nonpartisan. Crime negatively impacts the quality of life of every citizen, and we'd like to see accountability for criminal behavior. Thank you.
Thank you very much. Members, do we have questions? Thank you for your work. Appreciate your time. Okay, Chair calls Jennifer Lauren. Have you registered as Jennifer Lauren, testifying on behalf of yourself and neutral on House Bill 17? Is that correct?
That's right.
Okay, go ahead and begin your testimony.
Good evening, Chairman Moody and committee members, and thank you for letting me be with you this evening. I am the Wright C. Morrow Professor of Law at the University of Texas School of Law, where I teach and write on criminal law and criminal procedure. And so what I wanted to do was use my time to discuss with the committee how I see this bill in the context of sort of existing landscape of prosecutorial discretion and of prosecutorial accountability. And against that backdrop, I have some concerns that the language of the committee substitute, the most recent version of the bill, really risks some unintended consequences for district attorneys who use very traditional and I think quite uncontroversial, as some of the comments that have been made suggest, means of guiding the discretion of their line prosecutors. So it's language targeting, quote, policies of refusing to prosecute certain conduct, the particular definition of policy that exists in the bill, and also the prima facie evidence provision that, to my mind, raise some of these concerns. So I start with the reality that I think we're now well familiar with, that every day, many times a day, prosecutors all across Texas make decisions that could be described as refusing to prosecute conduct. So to take an example that Chair Moody pointed to earlier, prosecutors do routinely offer defendants the opportunity for pretrial diversion, say into first-time offenders courts or veterans courts, as a result of which the defendant's conduct will not be prosecuted. Prosecutors routinely plea bargain, offering to dismiss a charge they perhaps could have proved beyond a reasonable doubt in exchange for the certainty of conviction on another charge. But as a result of the bargain, conduct putatively committed by the defendant will not be prosecuted. But more importantly, these discretionary decisions by line prosecutors are quite properly and commonly governed by office policies that make certain offenses subject to this type of prosecution. So it's common, for example, for offices to guide a line prosecutor's discretion in entering into pretrial diversion agreements by enumerating offenses that are eligible for such treatment. The current language prohibiting a policy of refusal could be construed as barring this desirable means of guiding prosecutorial discretion. So too is it common and valuable for district attorneys and supervisors to provide guidance to line prosecutors in making plea offers more consistent across cases. Such guidance, I worry, could be construed as an instruction or directive to refuse to prosecute conduct under the new policy definition that appears in the bill. Finally, and briefly, the bill's prima facie evidence provision, I worry, could aggravate the potential of the bill to diminish rather than enhance prosecutorial accountability. So Representative Darby made reference before to the electoral process. Making prosecutorial elections a meaningful check on district attorneys requires ensuring that voters have information about the very low visibility details of how offices function. But the combination of potentially capacious language defining a policy of refusing to prosecute and this prima facie evidence provision could create an enormous disincentive for elected prosecutors to communicate anything about their office policies, including on matters as anodyne as diversion, for fear of inviting a removal petition. So in sum, the challenge, as I see it, is really to isolate conduct that the body wants to prohibit without unintentionally putting prosecutors at risk for exercising traditional discretion and creating very sensible existing accountability mechanisms for the work of their office. Thank you, and I'm happy to take questions.
Thank you, and I appreciate you kind of pinpointing that stuff for us. And we talked about the diversion, other conditional dismissal type programs, and I know that Vice Chair Cook said that's not what we're trying to get to. Your point is maybe need some clarification to kind of statutorily set those aside. And I guess that if that's something you want to send our direction, language that you think, and don't have to answer it now, language you think that would safely give those programs their space to operate, that they don't count when we're talking about this, because I do think there is, want to make sure that those things continue. I think nobody would think of those in the same category as what you just heard the last few witnesses testify about, right? Very different. So if you could, we're willing to look at, like I said, this is an exercise that we're all going through trying to figure out how to kind of wanting to respect discretion, but also wanting to make sure that there's a line, there's kind of a clear line that we're not crossing. So if you want to submit that over the next couple of days, happy to take a look at it. Chairman Leach.
Yeah, thank you for your testimony, Mr. Chairman. I couldn't agree more. You've identified some real some important things for us to think about. Do you have any suggestions? It sounds to me like you have your pulse on, a good pulse of what's going on nationwide. I know we're not the only state that is looking at this. And so do you have any suggestions as to how we can deal with this issue better?
Yeah, I very much appreciate the question, and I think it is important to be looking around and thinking whether there are models of approaches that we see working that we could borrow from. I guess in this space, I feel cautious about that for a couple reasons. First, there are only a couple examples of bills like this that have passed, as compared to many more that have been proposed. So to the extent that one thing I'm encouraging you all to be mindful of is what's the interaction between the language that's being described here and really how this is going to interact with prosecution on the ground. I think even in those states where bills have passed, we're still in uncharted territory. I would be uncomfortable saying, well, a bill passed in Iowa, you should definitely grab that language. I don't think we know, for example, right, really what to say about those. But I'm happy to think more about the question, and
That's not the official timer.
Okay.
Yeah, I would.
Timer.
I would encourage you and request on behalf of the committee that you do so. Vice Chair Cook, the author of the bill, is being extremely thoughtful and intentional about how he goes about this. And I would say that whatever bill he ends up passing, I believe your bill's going to pass. We're going to do something on this. I think we're going to see other states, as they so often do, duplicate what we do here in Texas, and which is the reason that we need to get this right. I don't want to ask you to agree publicly whether you agree with us that there's a problem, but I think we know, we have our pulse on the legislators and the people that we represent, that this is a big concern that needs to be addressed this session. So I would invite you and would implore you to help us get this right.
Yeah.
So I think this bill's going to pass, and the devil's in the details, as we all know, and other states are going to copy what we do here.
If I could, Representative,
Yes, absolutely.
just a couple points in response. First, I'd be very happy to think more about language, to submit language, to work with staff in any of your offices on thinking more about that. I'm very, very happy to be a resource as this moves through. The second thing I would say, though, right now, without having specific language at the ready that I'm prepared to offer right now, is that I just want to highlight that one of the sort of theme of what I'm offering is that there are these practices on the ground, right? And also that the practices in prosecutors' offices about guiding discretion in various ways are, to the public, quite opaque. They don't see those policies by and large, right? And so one thing I think to be cautious about is to the extent that the enforcement mechanism here, or that the person who's going to bring the lawsuit, right, as people have said, is just an ordinary person who's looking at their prosecutor's office and just sees some output or lack of output and is like trying to understand what's going on. There can potentially be a gap between the language that's being used to describe something quite broad and what potentially an individual looking out at the landscape of prosecution is going to figure is probably going on. And so that's an interaction that I think suggests narrower rather than broader language being better.
Right, that's a great point. And Mr. Chair, I do want to just clarify for the record, I don't know this bill's going to pass. I hope it does, but of course you're in charge of it and stewarding it right now. So I just want to make clear for the record that I'm not making an official pronouncement, but I hope it does.
Don't put out any press releases, man. Sorry. Thank you very much. I appreciate the commentary. Oh, I did mention earlier when we talked about that, the part about the public statement and prima facie evidence. I talked about, would there be any distinction between that and creating like a rebuttable presumption there rather than, I mean, it seems like to me then maybe you're going to litigate a little bit more on the front end if you create it gives the opportunity for the prosecutor to bring forward evidence of, I had individualized reviews of these cases, all that other kind of, even if they said something, they still have the opportunity to present evidence that, hey, that's what this, I may have said this and maybe that wasn't the most artful way to say that, but this is what we've been doing in practice, like kind of create some space for them there. Is that a real distinction? I'm not a civil litigator, so I don't know.
Great, and I apologize for stepping on you. I didn't mean to interrupt, Chairman Moody. I'll say, I think, three things in response. I hope I don't go more than three. So the first is, I try to stay in my lane of expertise, and I don't want to hold myself out as a deep First Amendment scholar. So I have to be completely open that I haven't thought about sort of the doctrinal nuances of of what distinction this might make. The second thing I would say is that the set of concerns that I'm really trying to highlight are concerns about what sorts of practices within an office might be deterred by the sort of reasonable apprehension of a threat of just having to deal with one of these petitions at all. And to that extent, the possibility that there may be a pretty good answer that the prosecutor would have once the litigation starts underway doesn't fully take the sting out of the sort of over-deterrence concern that I'm presenting that might occur.
That's fair.
Yeah.
All right, you had mentioned it, and so I just wanted to ask. Thank you so much. Members have any other questions? Yes, Vice Chair Cook.
How would you describe or define prosecutorial discretion?
Ooh, you're challenging me to define it without using the word. I would define prosecutorial discretion as the legal power of prosecutors to select among and decide whether or not to charge a crime, period.
So legal power of prosecuting attorneys to select whether or not a crime exists and whether or not they're going to pursue prosecution. Did I get that close?
It's close. I was trying to capture the idea when I said select among offenses. I was trying to capture the idea that I when I teach criminal procedure, right, and I teach what I call bail to jail or the adjudication side, I try to make sure my students understand that under sort of existing prevailing law in the United States, American prosecutors have the power to decide to charge and the power to decide not to charge and the power to select among offenses in the context of a criminal law that's developed within that discretionary system that provides a pretty vast and overlapping and duplicative sort of menu of options.
Okay. So if we were to make you the district attorney for the day, what would go into your decision making? Like what would be the first thing you'd want to know on deciding whether or not to take a case?
I'd like to try to do what would go into my decision making rather than the first thing, if you don't mind.
I want the first thing.
Oof.
You need to know the facts, right?
Well, I guess the first thing that would go into my decision making are what are the facts.
What are the facts? And so would you agree with me that if you're prejudging a case before the case exists, that you're not judging that case on a case-by-case basis? If you're saying I'm not going to prosecute any felony fentanyl case or whatever the case may be, you're not using prosecutorial discretion by doing that. Is that correct?
I would agree with you, Representative, that there is a difference between categorical exercises of discretion and case-by-case exercises of discretion. How we capture that without compromising what we want to keep as we throw out the bathwater becomes the difficult part.
Okay. And then I guess what I would ask you to, and this is kind of just for anyone that's listening as well, but it seems like maybe the word consideration, I don't know if you have a copy of the committee sub.
I don't. I have a photograph on my phone of the committee sub.
And I apologize getting it out late, and we may have other copies. If not, we'll get it to you. But yeah, just maybe, listening to the testimony, it seems like maybe adding the word consideration, like in paragraph B on page 1, it says, when you're defining official misconduct, it says a prosecuting attorney's adoption or enforcement of a policy of refusing to prosecute. And I'm wondering if it may read better if it says refusing consideration of prosecution, because that's really what I think the intended target is prejudging a case before you know anything about the facts. And I mean, I think you as an expert in the field agree that you can't skillfully make a determination whether or not a charge should be pursued until you know what the facts are. And so if you're making statements, you're making prejudicial statements before you know the case that's coming before you, then I guess that's the intended target that we're seeking in House Bill 17.
Yeah, great. So if I could just respond a little bit. First, I want to be clear about my testimony. I agree with the proposition that there are differences between case-by-case discretion and sort of categorical, discretion. And I'm not prepared to take a position here in my testimony about whether I conclude that sort of the law makes sort of prohibited before some legislation comes out here, right? categorical exercises of discretion. But I do see them as quite different. I just want to clarify that. And the second thing I would say is, I guess I want to agree with the idea that if language truly could describe one without potentially implicating the other, you would have something different than what I think you have here.
Well, we would definitely like to have your input when you're able to do so.
Appreciate it.
Thank you.
Thank you.
Thank you very much.
Thank you.
Excuse me, Mr. Chairman.
Oh, I'm sorry, did you have questions?
I just
I
wanted to
apologize,
ask-
I'm sorry.
Yes. I just wanted to
Representative
ask
Bauer.
if you would share the language with the rest of our officers, with all of us, please. Yes.
And any bright ideas I have, I'm happy to share with the entire committee.
Thank you.
Yes, thanks.
Chair calls Jack Rhodey. Mr. Rhodey, I have you here testifying on behalf of yourself and the Galveston County Criminal District Attorney's Office, of which you are the elected district attorney.
Yes, sir.
And neutral on House Bill 17, is that correct?
Yes, sir, that is correct.
Okay, and please begin your testimony.
Good evening, Mr. Chairman and members of the committee. The question that y'all are grappling with and the question that is driving, I think, everyone who's testified on this is a valid question. And that question is, what do you do with an elected prosecutor who categorically refuses to enforce a law? There have been a number of proposals this session on what do you do. I believe the intent behind this bill and its purpose is the right way to get the job done. And that means focusing on the removal statute that's in place and sharpening its edges so that it becomes a very effective tool to address exactly this situation. Vice Chair Cook, you have been very open to working with my colleagues in terms of drafting this bill, and we are very grateful for that. I've reviewed the committee substitute that came out today, and I know some of my colleagues have looked at it too. We'd still like to be able to work with you on some of that language. I think one of the issues that came up tonight was the prima facie language, and then the struggle that I think you all are grappling with is how do we separate conduct versus speech? Because as prosecutors, we don't give up our right to express opinions on things. And my thought would be to make sure that this statute doesn't run afoul of that is maybe better left to not try and attribute a certain amount of weight to speech in the statute, but instead know that when these suits are filed, certainly the conduct of the prosecutor is going to be at issue, and certainly any speech made by that prosecutor will be evidence then to help prove up that prosecutor's intent and conduct. So I know, though, that there's been a tremendous amount of work being done on that, and thank you. I hope we'll still be able to work with you on that language. I am confident, members of the committee, Vice Chair Cook's approach with us has been very reasonable. And I'm confident that we'll be able to continue to weigh in on that and reach a final form of this bill. Certainly not all of my colleagues, but that many of my colleagues would be able to support. So,
Mr. Rhodey, thank you very much. And I want to make sure members have any other questions for Mr. Rhodey. Thank you so much.
Thank you.
Appreciate you. Chair calls Nick Hudson. Have you registered as Nick Hudson, representing the American Civil Liberties Union of Texas, registered against House Bill 17? Is that correct?
That's right. Vice Chairman and members, my name is Nick Hudson. I'm with the ACLU of Texas. We're here in opposition to House Bill 17. I want to get the number right. We want to thank Vice Chair Cook for working on these successive drafts. We've seen them as they've come out, and we can tell that you're putting a lot of work and being really thoughtful about them. I wanted to just point to two provisions we have particular concerns with. The first, the committee has kind of gone over, so I'm not going to belabor it, but we are concerned about how this might impact pretrial diversion programs, specialty courts, and however we fix that, it would be really helpful to make sure that we are not implicating desirable pretrial diversion programs and other things like that in the bill. The other one is subsection G. I just got the draft from, it was also on my phone, from someone earlier today. I shared it with our attorneys, and they have, they think it clearly violates the First Amendment, and so we'd be happy to work with your office to try to come up with some alternative, but I wanted to make sure I raised that concern in committee since they were able to review it. I think ultimately we think that removal should happen through voters. So I think we have a principled opposition to this. We think that ultimately voters should have the final say, but we wanted to try to offer helpful comments as you're working to on a bill that seems likely to pass.
Well, and I appreciate, thank you for kind of pinpointing where you think there's space that needs work. Obviously, elections are one way to handle these situations. Removal proceedings exist now. I mean, that's the law now. So I mean, I guess the way I look at this is fine tuning that for this particular conduct. There's other ways you can go about it. I mean, this legislature can set articles of impeachment for all, and quite honestly, it's happened before, and go through that process, right? So that exists under the law too. So I get what you're saying about election. I think it's important. We want to make sure that the will of the voters is an important part of our democracy. I mean, incredibly important. But we have these procedures in place, multiple places where someone can be held to account for not handling, business according to the statute. So I get the sensitivity around it. I think it is very. I think we're threading the needle on this one is difficult, and that's why I think these conversations have been very robust, because long-standing respect for prosecutorial discretion and wanting to make sure that we're using surgical strikes as best we can to make sure that there's a very clear line that we're not going to cross. So, Nick, thank you for and that you always work very earnestly with everybody, no matter if you're going to land on the same page with them or not. We've had multiple of those conversations, and so I appreciate you being willing to have them, and I know that Vice Chair Cook will continue to take your concerns to heart. Members, do you have any other questions? Thank you.
Thanks.
Chair calls Andrew Hendrickson. Is he? Okay. I'm going to switch him to not testifying. Also, we all know Nick did a better job than he would have done anyway. So, all right. Then Chair calls Chris Gatewood. Mr. Gatewood, thank you.
Thank you.
Appreciate you being here. I have you representing yourself and representing the Smith County District Attorney's Office. Is that correct?
That's correct.
And have you neutral on House Bill 17, also correct?
That's correct.
Okay, go ahead and begin your testimony.
So as you said, my name is Chris Gatewood. I'm the first assistant district attorney at Smith County. I'm here on behalf of myself and behalf of the office. I'm neutral on the bill, and the reason we're neutral on the bill and in the office, the Smith County DA's office is neutral on the bill, is because we appreciate the work that Vice Chair Cook and then Representative Leach have put into this. And I've also watched other hearings where Chairman Moody has talked about this process and this problem. And so we appreciate the work very, very much. And we agree with the spirit of the bill. So as a prosecutor, I took a job, or when I took my job, I took an oath that I would uphold the law. My job and my boss's job is to enforce the law that you guys put into place, right? So if a prosecutor or an elected official says we're not going to follow the law, they're thumbing the nose at the legislature, they're going out of their lane, and there ought to be some sort of recourse for that. Now, the concerns, and the reason I'm neutral, the concerns that I have with this legislation or the bill is that it's a little broad, and I have concerns about its application. So, for example, the language in 3B under proposed 87.011 says, a policy of refusing to prosecute certain conduct constituting a criminal offense under state law. Prosecution is not defined, or prosecute is not defined That would be helpful, because are we lumping diversion programs in here? Are we not lumping in diversion programs in there? But really, the other issue is I think that this language sort of targets innocent conduct. And what I mean by that is there's a lot of DAs, let me give you an example. There's a lot of DAs offices out there that say, you know what, we are not going to move forward on a dope case, on a marijuana case or a heroin case until we have a lab report from the DPS lab, because we're not going to take that case to grand jury until we have a lab. So effectively, we're not prosecuting the case until we get a lab. So you could have Joe Citizen in Smith County or any other county say, well, you know what? They have a policy of refusing to prosecute a certain conduct constituting criminal offense. They're refusing to prosecute this POM case or this possession of a heroin case. Another example would be if you have a policy not to prosecute cases where the evidence establishes an affirmative defense or supports an affirmative defense. Classic example is if you have a murder case or ag assault case where you have self-defense as the fact supports self-defense, right? Self-defense under the penal code is an affirmative defense. It's not an elimination of the offense, right? So we go to trial, I prove up that the defendant committed X offense and he's guilty of X offense, but he can prove up the defense and say, well, yeah, I did it, but I'm not guilty. So if we had a policy saying, if the facts support the establishment of the affirmative defense, we're not going to prosecute it, then we're done, right? Because then we have had, I mean, none of you would want someone to break into your home and you defend your family with a gun and you kill them or you maim them or you hurt them. And then some DA said, well, wait a minute. This statute says that I have to prosecute. And if I don't prosecute, then I've just ran afoul and I could be removed. And I know that may sound like a slightly silly example, but I've had cases before where a deceased family member is very upset because you didn't move forward with the case. And so they could file the petition for removal. There's other issues that I have with the second part of paragraph B, the unless the refusal is in compliance with an injunction, judgment, or other court order. No, make it going.
No, go ahead.
It says other court order. There are instances under the law to where we cannot prosecute a case. So for example, if a person has been arrested for an offense, it could range from criminal trespass all the way up to capital murder, right? If they're incompetent to stand trial, you cannot move forward with that case until they regain competency, generally speaking. Now, if the person is confined and they're arrested for a lower level offense like a state jail felony, there is law out there that says you cannot confine them and keep them in treatment to regain competency longer than the maximum period of confinement, right? So there's law out there that says if they're incompetent, sometimes you have to dismiss the case. And it's nuanced. But if we have a policy that says, look, if the law tells me under the Code of Criminal Procedures 46B that I have to dismiss this case, that could be a policy refusing to prosecute certain conduct, and there's no exception under the unless language for an otherwise valid statute. The language in here, I think you're moving in the right direction. You have injunction, judgment, or other court order, but I think that needs to be a little...
Complying with...
Right, otherwise valid law or something. But we agree with the spirit of this law. Smith County, we are an aggressive prosecutorial office. When law enforcement brings us to a case, we look at every single case and we say, can we make this case? If we feel like we can prove that case beyond a reasonable doubt, we move forward. It doesn't matter if it's a Class C traffic offense or illegal dumping. That's our role and that's how we view it. So we agree with the spirit of this bill. We are happy to work with you, Vice Chair Cook. We're also happy to work with Representative Leach to talk about what type of language doesn't have these unintended consequences of adversely affecting prosecutors who are otherwise doing a great job. So.
No, and I appreciate. I think the competency issue is one we haven't kind of worked through yet, and that's a very good example. I appreciate you raising that. I mean that's why these hearings are, why we have them and why we go through the process. So. Thank you for hanging with us and lending your expertise, and certainly appreciate Smith County office has been heavily engaged this session, and really grateful to the time y'all are spending here, because I think it really helps us understand what that looks like in your corner of the world.
Right. Thank you. We care.
So, members, any questions? No. Okay. All right. Great. Thank you.
Y'all have a great night.
We will try. We moved past public education. I guess Brian's back, so did they adjourn? That's what, I wasn't looking to win that competition tonight. Jeff's gonna win the race tomorrow, I think. Anybody else wishing to testify on for or against House Bill 17 at this time? Chair seeing none will recognize Vice Chairman Cook to close on the measure.
Thank you, Mr. Chairman, members, for your time and attention. I know it's been a long afternoon, so I want to try to address some of the concerns, or I can just open myself up for questions, whichever chair, you have a preference there.
No, I mean, if there's things you want to pinpoint, yeah, let's do that.
Okay, so I would say, what I would get into first is, some of the general versus specific, or omissions versus commission, that discussion earlier, and then how it ties in with existing law. And so, as we've talked about, existing law is Chapter 87, removal of county officers from office. And so, there's been discussion about whether or not, the gatekeeper is the electorate, is our voters. And so, yes, of course, that would be, in my opinion, more of a general, taking a general approach. Well, under existing law, there can be an immediate removal under Chapter 87. So in that particular instance, that decision or that immediate removal is resulting from a criminal conviction of any felony or a misdemeanor involving official misconduct, including a misdemeanor under Section 39.07. So if a county officer, which includes a prosecuting attorney and the long list of other county officers, if they're convicted, they will be immediately removed, and the court rendering the judgment in the criminal case shall include an order removing that officer in the judgment. So that's an immediate. So what I would say this process sets up is, instead of it being an immediately done by a judge or at the next election, this process sets up, let's say in year one, prosecutor is making these types of statements, refusing to prosecute cases, and a citizen of that county comes forward and wants to file a petition. This gives the electorate, obviously a much smaller electorate, but it gives a jury, so it is the citizens. And I know there was some testimony earlier about whether or not it would be in a different county or not. So that was a little bit, I don't think it was intentionally misleading, but I think it was a little bit misleading in that, in this case, in this situation, the removal process would occur in the county where the conduct occurred. So notwithstanding the fact that the administrative judge would be appointing a judge from outside that county to come in and be the trier of fact.
And yeah, I know there's prior iterations that had other concepts in them, and so there may be some just confusion about where we're landed, but also I think it's important to note that having it in that county is important. You've made that is something that you've made a change to get that, kind of get that in line. And I mean, as we saw out in El Paso, I mean, you end up going to the presiding judge at some point. Anyway, functionally, everyone's going to recuse themselves locally. They're not going to preside over that case. I mean, it'd be very difficult to, I would think. So you just essentially say, look, we're going to get there anyway, so let's just start there.
Correct.
So I think that's.
That judge is running for DA.
All right, that's a very particular situation. That's a good point.
And those presiding judges, I think they like their positions as a regional presiding judge. I think is the case most often. But I think that should address the concern that you had earlier, Representative Bowers, that you would not have a situation like you were talking about earlier when you said it wouldn't make sense for a Dallas County district attorney being adjudged or determined by Bell County, I think was the example. So that is not the case in my bill or under existing law. I think the other question that you asked was, yes, one of the witnesses, was it in his opinion, would this bill help stop crime? And I would offer that it has already. What I mean by that is in your particular instance where the Dallas County DA instituted a policy of not prosecuting theft under $750, I think at some point he figured out that was not a good policy, and he decided to rescind that policy, and then he started pursuing prosecution on theft under 750. So that, to me, is a perfect example of where, yes, this bill, the intent of this bill would stop crime because of that situation. So I wanted to point that out as well. You know, and I think just want to make sure that, you know, we've heard a lot of important bills today, and it's been a long time ago, but we've heard, you know, bills like, you know, that you laid out, Representative Stutzline, with regard to, you know, the distances for, you know, for sex offenders, or, you know, the jailhouse informant, or we talked about, you know, protecting the medical professionals, you know, because of the tragic shooting that took place in Dallas. Well, as I started in my remarks at the beginning of consideration of HB 17, I said this should not be a Republican issue or a Democrat issue. It should be a legislature issue, because Representative Morales, if you pass a law, you expect it to be followed, correct? And that's what, you know, that's what this is really about. And so I hope that you will, as you go through your deliberations, and I know it can be difficult because, you know, you don't want to vote against your county attorney or district attorney, but I would offer that you're not voting. You're just like the Smith County district attorney that testified. I mean, they are for, I mean, they want to improve. We all, you know, whatever profession we're in, as legislators, we want to improve the body that we work with, and as attorneys, we want to make other attorneys better. And so there's no doubt in my mind that generally speaking, prosecutors have in my opinion, probably have the most integrity, you know, as far as officers of the court are considered. You know, they have a job to bring justice to us as citizens, and I respect the job that they have, and I think that they do a fine job of it. But this bill will, in the limited circumstances where we have a district attorney or county attorney that's refusing to enforce a law that you passed, or that Representative Anchia passes to protect medical professionals at a hospital. You know, those laws need to, if 150 members of this legislature, or a majority of the legislature in the House and the Senate and the governor all believe that those laws should be passed, and they should be enforced. If a prosecutor disagrees with them, they should not be sending out inflammatory political messages. They should be coming to be involved in the process, like a lot of them are being involved today, which I appreciate, and I appreciate a lot of them reaching out and having input into House Bill 17. But to send out political statements does not help the situations. So in my opinion, they should come down and be a part of the process, or run for a different office, which would be the legislature, as opposed to the district attorney or county attorney. So who knows, I may be inviting someone to come run against me, but that's how strongly I feel about it, is that if they want to change laws, this is the building to change laws, not the courtroom. So that's what I would offer to you. I hope that have your favorable consideration with regard to House Bill 17. As been stated throughout the testimony today, I've had an open door policy on this. I welcome any prosecutor, any district attorney, county attorney, anyone that has an opinion about this bill to please reach out. And obviously, any of my colleagues that are here tonight, I would love to have any of your input with regard to the language. I think that we can all agree that the intent of this bill is genuine and well-intended, and we just need to work together to make sure that the language is as tight and as best as we can possibly make. So thank you for the opportunity to lay out House Bill 17. And I'll make myself available for any questions.
Yeah, certainly. Vice Chairman Cook, let me see if we, Representative Bowers, then we'll go with Mr. Harrison. Anybody have questions over here? Okay. We'll start with Representative Bowers.
Yes, thank you, Mr. Chairman, and thank you, Vice Chair Cook. Really, I just wanted to say thank you for answering my questions.
Yes, ma'am.
And just further, that I appreciate you saying that it should be a nonpartisan take on it. Our take should be, and I really appreciate that. And just your thoughtful intent on making sure that we're all on the same page.
Thank you, Madam Vice Chair.
Thank you.
Representative Harrison.
Thank you, Chairman, and thank you, Representative. Not so much a question, more a comment. I wish I was able to be here for the full layout of the bill, but just wanted to express my appreciation for the sentiments that you communicated in your closing remarks, and how critical, I'll back up and just thank you for bringing such a well-thought-out bill before the legislature. And I appreciate your sentiments to make sure it's as good as it can possibly be before it gets out of here, because I think a bill like this is not only something the legislature would be good for us to do this session. I think it's absolutely critical that we do this because the problem that you are trying to correct for, I firmly believe, is the biggest threat, at least here at a state level, to our constitutional system of separation of powers. And so we've got to make sure that the people are empowered through their legislatures here to determine what is or is not law in the state of Texas. So I just want to say how much I appreciate what you're trying to do here with this bill, Representative. Thank you, Chairman.
Thank you, Representative Harrison.
Representative Bojani.
Thank you, Vice Chair Cook, for bringing this. And, I'm just learning, being a freshman, how you really diligently took notes and was able to answer everybody. So thank you so much for that. The only comment I had was that a statement, and I think it was brought up by Chairman Leach as well, Chairman Moody, that a statement itself cannot be classified as a misconduct. So how can we bridge that, and being a prima facie evidence to support, it has to be some conduct as well. So I don't know how we work around that, but I think that's something that I just would like to just voice that opinion on that.
Yeah, I guess I disagree that a statement can't be. I mean, so like, let's say if the judge come out and made a statement that said, there's no way I'm going to find anyone guilty, would you agree that would be he or she prejudging your case? And so if you're a criminal defendant, you expect a judge or a defendant, any party in a lawsuit, expects a judge to be, as far as, to be open-minded, unbiased, give you a fair trial and that sort of thing. And so this really, it falls into that same space. And so it's a situation where if you have a prosecuting attorney that's empowering criminals to go forward with behavior and forego the laws that you've worked on to pass, I mean, why would you even spend the time to be here this afternoon trying to pass criminal laws if they're not going to be enforced?
Right. I mean, if a DA is talking about a specific case and says, I'm not going to enforce that particular case, that I think makes sense. But if it's just broadly talking about with their constituents and just talking something vaguely about, whatever they feel that's right, I don't know if that in itself becomes evidence to prosecute them directly without any other conduct, right, supporting it.
I think the key thing that you said there is vague, and yes, I would agree with you if a prosecutor is making vague comments, but I'll be glad to share with you some of the statements that are being disseminated and the press conferences that are being held, which are not vague statements. They're very specific that they're refusing to prosecute. And that's what this bill intends to do, is to stop prosecutors from refusing to do their job and prejudging cases prior to even knowing what the facts of the case are.
And then the free speech argument also that's related to that, right? So we'll have to figure out how we go around that.
Yeah, no, I think it's obviously part of the equation, but again, just like a judge can't go out and make statements prior to a case. I mean, the actual prosecutors are part of the judicial branch, and so just like a judge has to be unbiased and not make prejudicial statements, I think a district attorney or county attorney has the same responsibility and has an obligation to judge cases on a case-by-case basis. I do agree with you. We need to make sure that we fine-tune the language as best we can. But, again, I do want to make sure that the intent and the spirit of this bill is to stop this type of behavior.
Well, thank you for doing that. It is important that when we make laws, it should be enforced. So thank you so much for doing that.
Thank you, Representative Bojani.
And actually, I don't mean to ask a different question, but it made me think about it. Because you've got, typically what we've got in these bills is, this applies to actions after the whatever is enacted. Does that, because it's not clear to me when you're talking about, and I don't want to get into the statement of whether you can or you can't, but the statement that's being made, is that, because applies only to an action, Section 6 is the changes in law made by this act apply only to an action taken by a prosecuting attorney on or after the effective date of this act. So I could see how that could say that our process and the removal action and the misconduct is defined a certain way, and that definition is here going forward. Is your intent to go back in with the statements made prior to the enactment of law, be able to be pulled forward into the process that is begun after the fact?
I don't think so.
Okay, I know that I didn't think that's what you're trying to do, but I was wondering if.
I think it's a great question, because it probably gets into the difference in the speech, versus the act, and so I think maybe that's what triggered that question. I think it's a good question, but no, I don't think that it's a situation where we'd go back And I would compare it to statements that are being made, by some, and actually what happened here, I believe in Travis County, that the statements that were being made during a campaign prior to being elected, those statements cannot be used. Even if this law goes forward, you still can't use it. And once you get reelected, then you get that clean slate. So, you can't go back, and, if the voters, this goes back to the electorate, if the voters reelect you, then you're basically getting a clean slate. And so this law, would still not permit you to go back and try to prosecute for something that was taking place in the prior election. And so, it is a good question, because I think it came up during the testimony a little bit. And, as legislators, when you ran the first time, you probably all remember that. And so for some of you, it's been longer than others, like some of us, some freshmen and sophomores. So, but when you ran, you had to fill out a campaign finance report, and you had to adhere to the same rules that the existing legislators, were following at the Texas Ethics Commission. So it's for another day, but I do think that that's something we need to take into consideration. I don't intend for it to be part of House Bill 17, but looking forward, it's probably something that we need to keep an eye on, because, in my opinion, whether you're running for district clerk or district attorney or county district attorney, whatever the case may be, you shouldn't be able to make statements that your opponent cannot make. Does that make sense? Because if you're not an elected official at the time you're making the statements, but you're being held to a different standard than your opponent, who would be subject to this particular law that's provided for in House Bill 17.
Chairman, what about a situation, and Vice Chair Cook, I actually don't even know if I expect an answer, but something for us to think about, because one of the things I've seen, and I don't have it on me, but I could show you proof of this, is certain political groups, and I imagine they exist on both sides, but certain political groups that are during the campaign asking for candidates for prosecutorial positions to sign pledges. I will not prosecute abortion-related offenses if elected. We all see, we all are asked to sign pledges, but not like that. So I wonder if you have like an open seat, or let's say an incumbent is being challenged. This has actually happened. I know it's happened in the case of the district attorney in Los Angeles, who was just defeated by the former district attorney from San Francisco. And they were in that race both asked to sign pledges of non-enforcement, of non-prosecution, and they both did. Because the funding from this one group was contingent upon them doing so.
Sure.
So we need to think through, and again, this should be bipartisan, it should be nonpartisan. We need to think through how we address that. And whether this, so anyways, just something for us to think about.
No, I agree. I think it gives an uneven playing field.
Yeah. You only get to ask one set of questions. I'm sorry. No, it's just kidding. Just kidding. Representative Bojani.
Thank you, Chairman Moody.
Yes, sir.
Hey, just thought about this while we were talking. The statute of limitation, what would that be for this particular matter? Do we know?
I would probably defer to, as far as...
Because you mentioned that anything prior to election would not be in the purview of the statute.
Correct. It would not be, it would be like a reset. So once the electorate reelects, the district attorney, then you cannot prosecute an act that took place prior to.
Is that something in the bill already, or that's just something that you think that?
I think it's under case law, interpreting Chapter 87 of local government code.
Sorry. Now my wheels are turning, which can be dangerous. Is thinking about this more. So you've got a sitting district attorney, a prosecuting attorney who's running for re-election, and a major funder or a major group comes in and says, you're being challenged in your primary, or in a general, you're being challenged. I'm trying to decide who I want to support. I'm asking both of you to sign a pledge, a non-prosecution pledge. The current sitting prosecuting attorney under this law, it will be legally barred from doing so, but the candidate will not.
I believe that's the area that we find ourselves in. That's why I raised the issue. I don't know that we're going to be able to fix it with.
So let's all think on both sides of this equation, the scenario under which that could play out, and I don't know if there's a way for us to to restrict that, because if I'm the prosecuting attorney, I actually appreciate this statute because it provides me sort of a safe harbor. I can say to all these political groups, I cannot legally do what you're asking me to do because I will be removed from office. But that doesn't apply to the candidates?
Yeah, I think that's, not intentional with House Bill 17, but I think that's where we're at. And so, and that's why I bring up the Texas Ethics Commission. I think that's the best comparison that I can make, is that we need to look at it from that perspective and see how, once somebody, files for office, they're having to be subjected to the same rules.
Yeah. Great job on the bill, though. Great job.
Third set of questions? No, you're good?
Down here.
Okay, just check. Oh, Representative Bowers.
Okay, thank you. Thank you, Mr. Chairman. And Vice Chair Cook, I appreciate your work again, but want to just say that, I love the idea of a clean slate. I love that. I love the, I just don't know, as human as we all are, if you can really have a clean slate, because I feel like people will be looking back. And it's unfortunate, because we want to be able to forgive, turn the other cheek, and let all things go, but that doesn't always happen. And someone may just get there and say, hey, well, remember 5 years ago, 6 years ago, whatever, they did this or this, and I just don't trust. So I love the clean slate. I really do, and I think that's the way it should be. I just don't know if we're capable.
Yes, I don't want to speak out of turn, but I'm 99% sure that I've read that within the last 2 weeks as I've been preparing for this. So I'll make sure I get it to everyone, but I'm 99% sure that the current law would be that you get a clean slate. Once your electorate has reelected you, then you have a clean slate. So you would have to make the statement again before you would be subjected to House Bill 17.
Okay. I just, again, want to say I don't know if it's possible. And I hate that I feel that way, but
I'll get it to you.
thank you.
Thank you for the question.
Mhm.
Do we have any other questions?
No.
No, I mean, look, this is certainly an important topic. I want to make sure everybody has the opportunity, but we can continue this conversation independently with Vice Chairman Cook as well. Any other comments before close?
I believe that concludes it. Mr. Chairman, I appreciate everyone's time and just want to say we appreciate your favorable consideration and your discussion with your colleagues. That, again, this is a legislature issue, not a Republican or Democrat issue.
Understood. Thank you. Was that your first bill layout?
No, sir.
We'll withdraw the committee substitute to House Bill 17. And if there's no objection, House Bill 17 will be left pending at this time. Is there any objection? Chair hears none. House Bill 17 is left pending.
Thank you, Mr. Chairman.
Yep. You have work to do. Let's see.
We just had one, last one. Ready, Mr. Moody? All right, Chairman Moody, lay out House Bill 4517 and recognize Chairman Moody to explain the bill.
Thank you, Mr. Chairman. Members, something we all know is that people in our system are innocent until proven guilty and entitled to due process. That's something we often lose sight of in practice, though. People are often treated as if they're guilty from the moment an accusation is made, despite the fact that many of those same people end up with dismissals or acquittals later. And even when offenders are found guilty, probation is more common than any sort of jail sentence. But with so many accusations, people end up stuck in jail because they can't bond out. They've effectively been sentenced without being convicted, and that can lead to people losing jobs, losing housing, even losing child custody, all without a finding of guilt. That being said, bond is supposed to be about public safety and ensuring appearance, and that's something we need to keep in mind. House Bill 4517 balances those concerns by making release on personal bond the default for eligible cases unless the judge finds that it's not appropriate. In other words, a judge can deny personal bond on any of these cases, and all the bill requires them to do is enter a finding on the record explaining why a personal bond with conditions of release isn't sufficient to ensure the accused shows up to court or to protect the community, law enforcement, or the alleged victim. Our law already precludes personal bond for most of our serious offenses, and the bill doesn't change that. In fact, it actually expands it by carving out offenses involving offensive or provocative sexual contact. The bill also makes sure that judges are considering the safety of law enforcement officers, which is not in current law. Again, members, this bill doesn't require anyone to be released on personal bond. It just changes the default setting to what's appropriate, which is liberty. When someone hasn't been convicted of anything, they shouldn't have their freedom taken from them unless there's a good reason. And the least we can do is put that reason on the record. I'm happy to answer any questions about this bill, and I would appreciate the opportunity to close at the end of testimony.
Of course. Members, any questions for Chairman Moody at this time? All right, we'll take testimony. Thank you, Mr. Moody. All right, first witness we have is Madeline Bailey. Is Ms. Bailey here? Madeline Bailey. All right, we'll show her not testifying. Next is Ken Good. Mr. Good, I show you that you're testifying on behalf of yourself and the Professional Bondsmen of Texas. Is that correct?
Yes, sir.
And you're testifying against the bill?
Yes, sir.
All right, you may proceed.
A personal bond is an important tool. What I want to talk about is making it a presumption. You know, during COVID, we had a lot of what I would call pretrial reform on steroids. So we now are starting to see reports and research that is showing us the results. So in California, Yolo County, the district attorney there, which is a progressive DA, in the last month has issued a report that said he did a comparison of release of people on personal bonds, which is free bonds, California's equivalent, and people released on surety bonds. And what he found was that people released on their equivalent of a personal bond were rearrested 163% more for their crimes than people who released on a surety bond. The average recidivism, or the reoffend rate for people released on their equivalent of a PR bond, was 70% higher than people released on a surety bond. Individuals released on their equivalent of a personal bond who were rearrested within 18 months was 148% higher than people released on a surety bond. Non-surety bail releases that committed new offenses were 200 times higher than people who were released on a surety bond. And I would just point out, in the last 2 weeks, New York has also tried, for the last couple of years, has had a presumption of a personal bond, and the governor there has proposed in their budget that they change that and take away the presumption and give it back, the discretion back to the courts on any type of bond and not have a presumption. And I would just say that it's also supported by the statistics that even the Democrat DA in Harris County has pointed out, that in their view of the increased use of PR bonds in Harris County, there was at least a 50% failure to appear rate. And then the Sheriff's Association did a 1-week review of the dockets and found a 70% failure to appear rate. And then HarrisCountyCourtWatch.com found a 80% average failure to appear rate from over the last 2 years on personal bonds. And so I would just end by saying, what is the secret sauce? What makes the difference? Why is there this difference that we're seeing? It's because of the involvement in the sureties and reminding people to go to court. The supervision that they provide. You know, we've had that discussion about surrendering of bonds. What we didn't point out is how highly regulated the bonding community is. If a trial court finds that a surrender was done improperly, they can order them to return the premium that was paid to them. So it's a highly regulated industry. And then when there's a failure to appear, a lot of times we get people back by explaining to them on the process, okay, you messed up, we can get you back, we can get you back on track, or we can get them back with a warrant and get them rearrested. Otherwise, if there's a personal bond and they fail to appear, there's nobody out looking for them. They issue a warrant, and it goes down and joins all the other warrants in the warrant division waiting for them to commit another crime.
Thank you for your testimony, Mr.
Thank
Good. Any questions for Mr. Good, members? All right, thank you.
Good night.
Next, we'll call Judge Nicholas Chu. Is Judge Chu here? All right. Show him not testifying. Next, we have Nikki Presley. There she is, still here. Ms. Presley, I show you testifying on behalf of the Texas Public Policy Foundation, and you're testifying for the bill. Is that correct?
Yes, sir.
All right, may proceed.
My name is Nikki Presley. I'm the Texas State Director for Right on Crime at the Texas Public Policy Foundation. Representative Leach already told me to shh, so I'm going to keep this real quick.
It's like this.
Yeah. We are in support of this bill. We are in support of any movement towards a risk-based bail system. This would address some of those lower level risk offenders who are, while we're also trying to address some of those high-risk offenders in some other legislation. And our only recommendation would be to limit this to first-time offenders and then keep the rest of it up to judicial discretion. That's all.
Any questions for Ms. Presley? All right, thank you for your testimony. Next, Chair calls Nick Hudson. Mr. Hudson, we show that you're testifying on behalf of the American Civil Liberties Union of Texas, and that you're testifying for the bill. Is that correct?
That's correct.
Right, you may proceed.
Thank you. I know you've had a long day, so I'll try to be fast. So this bill strikes a really good balance between liberty and safety. Judges retain discretion. You heard some stats, but keep in mind that judges under this bill, if they have any reason to hold somebody, they can still, or assign a monetary bond that could potentially hold somebody, they could under this bill. Originally, money bail was just supposed to make sure that people came back to court. And our system in Texas has really morphed into a widespread wealth-based detention system. And more than 80% of criminal cases, according to OCA, involve a money bond these days, including for minor offenses, including in some cases minor traffic violations. So it's leading to incarceration of people who pose no flight or safety risk. The Supreme Court Justice Nathan Hecht has recognized this in previous speeches before the legislature in 2019 in the State of the Judiciary speech. I'll just say, this will move us closer to a system where safety instead of wealth is the determining factor about whether somebody remains in jail. I'll just, one more thing, because I spoke to JP Chu. He has a couple concerns. One is about the finding on the record section. I think they're really easy fixes, and I'll make sure that they get to the chairman. So thank you.
Thank you. Any questions for Mr. Hudson? Any member?
Thanks.
All right. Thank you for your testimony. Is there anyone else who would like to testify on, for, or against House Bill 4517? Hearing none, Chair recognizes Chairman Moody to close on House Bill 4517.
Thank you all very much. I think Nick made the point I wanted to make, is at the end of the day, this doesn't remove discretion. Judges still have discretion. We're just saying, if they don't do personal bond, just tell us why. That's it. That's kind of simple. I appreciate Ms. Presley's commentary on maybe a tweak to it. There's a broader conversation around bail, and so I think that any of these pieces could be helpful to solving that broader issue as well. So
is that the first offense comment?
Yeah. I think I appreciate them bringing that forward, and we'll obviously take all that into account.
All right, members, any questions for Chairman Moody? Thank you for presenting House Bill 4517. If there's no objection, we'll leave House Bill 4517 pending. Is there any objection? Hearing none, Chair finds that House Bill 4517 will be left pending. And I'll turn it back over to Chairman Moody.
Okay. That's right. Try to do this as efficiently as possible. Thank you, members. Chair lays out as a matter of pending business. You ready? You tell me. Okay. Chair lays out as a matter of pending business House Bill 291 by Chairman Murr relating to occupational driver's licenses and to the renewal of driver's licenses. At this time, Chair offers up a committee substitute. To explain real quick, substitute. This removes the exception for the Omnibase system. That was the complaint I think that we had all heard and were raised. Chairman Murr has let me know that with this, so if this substitute is adopted, both Fair Defense Project and Texas Appleseed support the bill.
So is there any objection to the adoption of the committee substitute? The chair hears none. The substitute is adopted. The chair moves that House Bill 2, the chairman did also ask that we send this to the local and consent calendar now that it's been worked through. Okay, so chair moves that the House Bill 291 as substituted be reported favorably to the full House with the recommendation that it do pass and be printed and be sent to the Committee on Local and Consent Calendars. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani?
Aye.
Representative Bowers? Representative Darby? Representative Harrison? Representative Leach? Representative Christina Morales? Representative Schatzline?
There being 9 ayes and 0 nays, the motion prevails. Chair recalls House Bill 352 by Gonzalez of Dallas from the Subcommittee on Criminal Procedure. The chair lays out as a matter of pending business House Bill 352 by Gonzalez of Dallas. Members, this bill was heard in subcommittee. Chairman Bojani, do you have any comments on this particular bill that was heard in your subcommittee? No? Okay, all right. Then the chair moves that House Bill 352 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani?
Aye.
Representative Bowers? Representative Darby? Representative Harrison? Representative Leach? Representative Christina Morales? Representative Schatzline?
There being 9 ayes and 0 nays, the motion prevails. The chair recalls House Bill 399 from the Subcommittee on Criminal Procedure. The chair lays out as a matter of pending business House Bill 399 by Representative Collier relating to the automatic orders of non-disclosure of criminal history record information for certain misdemeanor defendants following successful completion of a period of deferred adjudication community supervision. This was a bill heard in Subcommittee on Criminal Procedure. Representative Bojani, did you have any comments further on this bill? No? Okay. Chair moves that House Bill 399 without amendment be reported favorably to the full House with the recommendation that do pass and be printed. Clerk, call the roll. Oh.
Representative.
Hold on. We don't have a sub?
And that's one where it was, yeah, she limited where this one had like multiple chances, like 5 or 6. Yeah, the substitute right here. So.
This is the non-violent, non-sexual misdemeanor offenses, and it's automatic order of non-disclosure.
Okay. And it limits. There was another bill that the subcommittee heard that was not part of our list today, and maybe that was one that has a sub coming. We do not have a substitute on this bill. You want me to? You prefer to vote no. Okay,
I'll vote no if we're hearing it.
Okay, let's do this. We'll encourage a conversation further on this bill. If there's no objection, House Bill 399 will be left pending. Chair hears no objection. House Bill 399 will be left pending at this time. Okay. This time, the chair recalls House Bill 412 from the Subcommittee on Criminal Procedure. The chair lays out as a matter of pending business House Bill 412 by Dean Thompson relating to requiring the corroboration of certain testimony in a criminal case involving a controlled substance. This is a bill that was heard in the subcommittee as well. Works for all these hours, and now it's not going to. Representative Bojani, do you have any further commentary? Okay. Chair moves that House Bill 412 without amendment, be reported favorably to the full House. The recommendation that do pass be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
No.
Representative Bojani? Representative Bowers? Representative Darby? Representative Harrison? Representative Leach? Representative Christina Morales? Representative Schatzline?
There being 8 ayes and 1 nay, the motion prevails. Chair lays out as a matter of pending business House Bill 905 relating to credit toward a defendant's sentence for time confined in jail or prison before sentencing. Chair moves that House Bill 905 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani? Representative Bowers? Representative Darby? Representative Harrison? Representative Leach? Representative Christina Morales? Representative Schatzline?
Being 9 ayes and 0 nays, the motion prevails. Chair lays out as a matter of pending business. I'm sorry. I apologize. I know, I got it, sorry. The chair recalls House Bill 964 from the Subcommittee on Criminal Procedure. Now the chair lays out as a matter of pending business House Bill 964 by Representative Jatan relating to the applicability of sex offender registration requirements to the offense of improper relationship between an educator and a student. Chairman Bojani, any commentary on this bill before we vote? No? Okay. Your glowing endorsement? The chair moves that House Bill 964 without amendment be reported favorably to the full House with the recommendation that do pass and be printed. Clerk, call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani? Representative Bowers? Representative Darby? Representative Harrison? Representative Leach? Representative Christina Morales? Representative Schatzline?
Being 9 ayes and 0 nays, the motion prevails. Chair lays out as a matter of pending business House Bill 1394 relating to the eligibility to participate in certain drug court programs. And I know there's some questions about it. This is 1394 by Chairman Moody relating to the eligibility to participate in certain drug court programs. And there's a question about qualification to participate in certain offenses. If you're not eligible for probation, you cannot participate. This is a probationary program with kind of intensive supports and services around it, and so you cannot get into it otherwise. There are probation eligible crimes of violence that would be if the prosecutor and the judge do permit it. So this is for clarification. The chair moves that House Bill 1394 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani? Representative Bowers? Is that Representative Darby? Representative Harrison? Representative Leach? Representative Christina Morales? Representative Schatzline?
Being 9 ayes and 0 nays, the motion prevails.
Yeah, I mean, without additional reforms, I'm comfortable adding items to this list, but I'm okay with the bill being voted.
Okay. Okay. Do you want to give commentary on it?
Just said I'm happy to.
Yeah, okay. No, I mean, I know the position. Chair recalls House Bill 1442 by Representative Ann Johnson from the Subcommittee on Asset Forfeiture. The chair lays out as a matter of pending business House Bill 1442 relating to the prosecution of certain criminal conduct involving a reckless driving exhibition and to the forfeiture of contraband as a result of reckless driving exhibition. Chairman Harrison, if you could give us a commentary on this matter.
Yeah, heard the bill in the forfeiture subcommittee without additional reforms to our civil asset forfeiture statutes. I am personally uncomfortable adding items to that list. That said, I'm very comfortable for the committee to vote on Representative Johnson's bill this evening.
Understood. And I think, without getting into, certainly have some efforts underway to get at that broader reform. So I appreciate your work on that topic. Chair moves that House Bill 1442 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody,
Aye.
Vice Chair Cook,
Aye.
Representative Bojani,
Aye.
Representative Bowers, Representative Darby, Representative Harrison, Representative Leach, Representative Christina Morales, Representative Schatzline.
Being 7 ayes and 2 nays. No, Harrison, Schatzline. Right. Okay, so 7 ayes, 2 nays, the motion prevails. This time, chair lays out as a matter of pending business House Bill 1762 by Gonzalez of El Paso relating to the prosecution of criminal offense of indecency with child. Chair moves that House Bill 1762 without amendment be reported favorably to the full House with the recommendation that do pass and be printed. The clerk will call the roll.
Chair Moody,
Aye.
Vice Chair Cook,
Aye.
Representative Bojani,
Aye.
Representative Bowers, Representative Darby, Representative Harrison, Representative Leach, Representative Christina Morales, Representative Schatzline.
Being 8 ayes and 1 nay, the motion prevails. Okay, members, we're going to move to some bills that it doesn't feel like we heard today, but we actually did. Chair lays out as a matter of pending business House Bill 1221 by Chairman Metcalf relating to authorizing the comptroller to release a reported owner's unclaimed property to the owner's crime victim in certain circumstances and payment by the Texas Department of Criminal Justice of certain amounts owed by an inmate. The chair moves that House Bill 1221 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. Clerk will call the roll.
Chair Moody,
Aye.
Vice Chair Cook,
Aye.
Representative Bojani, Representative Bowers, Representative Darby, Representative Harrison,
Forgive me, I missed the bill number. Which one?
1221.
Got a little distracted there for a second.
Representative Leach, Representative Christina Morales, Representative Schatzline.
There being 9 ayes and 0 nays, the motion prevails. The chair lays out as a matter of pending business House Bill 1603 by Chairman Guillen relating to the procedures of governing the prosecution of misdemeanor offenses in the jurisdiction of the justice and municipal courts. The chair moves that House Bill 1603 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody,
Aye.
Vice Chair Cook,
Aye.
Representative Bojani, Representative Bowers, Representative Darby, Representative Harrison, Representative Leach, Representative Christina Morales, Representative Schatzline.
Okay, being 9 ayes and 0 nays, the motion prevails. Chair lays out as a matter of pending business House Bill 1712 by Chairman Canales relating to the inclusion of a magistrate's name on certain signed orders. The chair moves that House Bill 1712 without amendment be reported favorably to the full House with the recommendation that do pass and be printed and sent to the Committee on Local and Consent Calendars. The clerk will call the roll.
Chair Moody,
Aye.
Vice Chair Cook,
Aye.
Representative Bojani, Representative Bowers, Representative Darby, Representative Harrison, Representative Leach, Representative Christina Morales, Representative Schatzline.
Being 9 ayes and 0 nays, the motion prevails. This time, chair lays out as a matter of pending business House Bill 1826 by Mr. Turner of Tarrant. This time, chair offers up a committee substitute to 1826. Substitute is now in front of us. Let me just remind everybody, just in case they forgot since this was laid out, the committee substitute for House Bill 1826 would add language specifically allowing virtual meetings and a digital report. It would also add permissive language for the task force to work together and share information on active cases if necessary. Additionally, the committee sub would add recommendations on better coordination of all stakeholders, how to educate law enforcement and prosecutors on the most effective way to prosecute organized retail crime. Any questions on the substitute? Okay. Is there any objection to the adoption of the committee substitute? The chair hears none. The substitute is adopted. The chair moves that House Bill 1826, as substituted, be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani?
Aye.
Representative Bowers? Representative Darby? Representative Harrison?
Aye.
Representative Leach? Representative Christina Morales? Representative Schatzline?
Being 9 ayes and 0 nays, the motion prevails. Chair lays out as a matter of pending business, House Bill 3260 by Chairman Herrero relating to the expunction of arrest records and files by a statutory county court. The chair moves that House Bill 3260 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani?
Aye.
Representative Bowers? Representative Darby?
Aye.
Representative Harrison?
Aye.
Representative Leach? Representative Christina Morales? Representative Schatzline?
There being 9 ayes and 0 nays, the motion prevails. There is one that we had already heard that wasn't from today that I'm going to lay out. This is, Chair lays out as a matter of pending business. This is the last bill we'll be voting tonight. Chair lays out as a matter of pending business, House Bill 1347 by Chairman Dutton, relating to the charging instrument in the prosecution of the offense of resisting arrest. The chair moves that House Bill 1347 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
No.
Representative Bojani? Representative Bowers? Representative Darby? Representative Harrison?
Aye.
Representative Leach? Representative Christina Morales? Representative Schatzline?
There being 7 ayes and 1 nay, the motion prevails. Okay, members, long day. We're going to be much shorter next week because we have budget next week. We want you to know that when Calendars Committee took up their first vote, 25% of the bills that they had in front of them were from this committee. So we'll continue sending them as many as they like. We'll probably have a formal meeting, just keep that in mind, later in the week. I'll advise everybody accordingly. Members, that concludes today's agenda. Is there any further business for the committee to address? Yes, ma'am. Oh, sure, of course, yeah, we can do that. Okay, chair moves to adjourn. Is there any objection? Hearing none, the committee stands adjourned at 9:17 p.m., subject to the call of the chair.